Good morning. I'm Senator Liz Krueger, Chair of the Senate Finance Committee, and I'm joined today by many people, but most importantly, my co-chair of today's budget hearing from Ways and Means, Assemblywoman Helene Weinstein. Today is the joint legislative hearing for fiscal year 21-22 on public protection issues within the executive budget. It's Wednesday, February 10th, around 9:40 in the morning. Check back 9:40 tonight. We'll still be here, I'm going to tell you, because today ends up being a very long hearing because there's so many different overlapping agencies within the rubric of public protection. These hearings are conducted pursuant to the New York State Constitution and legislative law. Today, the Senate Finance and Assembly Ways and Means Committee will hear testimony concerning the governor's proposed budget for the judiciary, the State Commission on Judicial Conduct, the Office of Indigent Legal Services, New York State Division of Homeland Security and Emergency Services, New York State's Office of Information Technology, New York State Division of Criminal Justice Services, the State Department of Correction and Community Supervision, and the State Division of State Police. Following each testimony, there will be time for questions from the chairs and rankers and other legislators. Following the 8 representatives from state government, we will move to testimony from the public who is asked to testify here today. All testimony is available online and can be read by each and every legislator and everyone in the public. If you asked to testify but you were turned down because it was too crowded, you are still welcome to submit testimony even past today's date. And if those of you who are just listening in and want to read along, you should have access to quite a bit of the testimony up online already. I'm now going to introduce members of the Senate, and Helene will introduce members of the Assembly. Following, we'll have introductions for the Senate Democrat. Oh, somebody, please mute yourself if you're not me talking at the moment.
Sorry.
That's okay. Thank you. That's another rule for these hearings. Remember to mute yourself if you're not the one who's supposed to be actually speaking. We have so many senators here today, but Jamal Bailey, John Brooks, Julia Salazar, Brad Hoylman, just going through the Gustavo Rivera, Pete Harcum, Diane Savino, Anna Kaplan, John Liu. Let's pass it to Tom O'Mara, the ranker, to name his members who are here today.
Good morning. Thank you, Senator Krueger. We are joined on the minority side by Senator Jim Tedisco. I'm sure others will be joining as we progress throughout the day.
Thank you. I now pass it over to Assemblywoman Helene Weinstein to introduce Assembly members.
Thank you. We are joined by Assemblyman Levine, Chair of our Judiciary Committee, Assemblyman Dinowitz, Chair of our Codes Committee, Assemblyman Zabrowski, Chair of our GovOps Committee, and members of those committees, members Bronstein, Bronson, Dillon, Epstein, Hindman, Joyner, Kellis, McMahon, Meeks, Rajkumar, Seawright, Steck, and we probably will have additional members joining us as the hearings continue. Let me turn it over. Let me just have Assemblyman Rod, the ranker of Ways and Means, introduce his colleagues.
Thank you, Chair. We are joined this morning by Assemblyman Mike Lawler, the ranker on our GovOps Committee. Assemblyman Morinello, who's the ranker on our Codes Committee, Assemblywoman Burns, Assemblyman Walczyk, Assemblyman Goodell, Riley, and Tanusis.
Great. Thank
If I may add,
Please.
Senator Krueger, I understand that we're also trying to be joined by Senator Palumbo. I think he's in the waiting room, waiting admission.
Okay, so one of the moderators, please let the senator in. They'll figure that out. Thank you, Tom. All right, continuing along, I'm just going to list out the testifiers. We're only gonna do this once today, and then we'll just call up each one. Just know when they start to testify, right before they start to testify, I will announce who the chairs of the relevant committees are for that specific testifier, because the rules of the road change slightly. Our guests have 10 minutes to do their presentations. Chairs have 10 minutes, if it's appropriate for the committee, to ask and get answered their questions. Rankers or chairs of other committees related to this hearing get 5 minutes to ask and get answered their questions. Other members get 3 minutes to ask and answer. Only the relevant chair for that committee gets a second round possibility if they need it at the end. I'll go over this a few times today. But so for example, our first testifier will be Lawrence Marks, Chief Administrative Judge of the Office for Court Administration. And the relevant committee is of Judiciary. So Chairs Hoylman and Levine will go first and have the first 10-minute opportunities. And then their rankers have 5 minutes. The flow, you'll figure out the flow as the day goes along, and I'll continue to explain. So again, we have Chief Administrative Judge, Lawrence Marks, and I'm going to introduce the others as we go along. Good morning, Judge.
Good morning, Senator Krueger, and good morning, everyone. It's good to see everyone, and thank you. I'm Lawrence Marks. I'm Chief Administrative Judge of the Unified Court System, and I'm pleased to appear this morning to discuss the judiciary's budget. So for the upcoming fiscal year, which as you know is fiscal year 2022, we are asking for the same level of appropriations we received for the current fiscal year. However, our spending plan has changed from the one presented to you a year ago. For fiscal year 2021, spending under the judiciary budget has been reduced by $291 million. That's a 10% reduction. In the fiscal year 2022 judiciary state operating spending plan assumes continuation of this reduced spending level of $2.25 billion. And I will address this shortly, but first I'd like to put our budget submission in its proper context by briefly summarizing for you the judiciary's experience over the past year. And this experience, of course, could not have been anticipated in February 2020 when I last appeared before you to report on our budget. Since that time, New York's judiciary, along with the rest of the state, has faced multiple challenges as a result of the COVID-19 pandemic. These challenges include the unprecedented task of keeping the courts operating consistent with a rapidly evolving understanding of public health needs. Back in March, as the extent of the pandemic first became apparent, and as the state began instituting aggressive measures to protect the community, the judiciary took the first of several critical steps affecting court operations. While determined to keep the courts open for business, we initially limited our operations to essential and emergency applications only. Over the next few weeks, however, we put into effect a program of virtual court operations to permit the widest possible delivery of justice services to litigants and lawyers. This made it possible and continues to make it possible for judges and staff to safely conference cases in all of our courts across the state, to the point where more than 20,000 cases a week are now conferenced to produce settlements, referrals to virtual alternative dispute resolution, and decisions on motions. Virtual court operations now also make it possible to conduct hundreds of evidentiary hearings and bench trials each week. As we took these steps to institute and expand a virtual court system, we were also planning for the resumption of in-person proceedings. Closely adhering to applicable public health protocols, we instituted a range of safety measures to protect the health of all who enter and work in the courthouses. This permitted us to resume certain in-person proceedings during the summer and fall months, including, among other things, impanelment of grand juries in all of the state's counties and some civil and criminal jury trials. With the resurgence of the virus since the holiday season, we have had to curtail many of these in-person proceedings, but we are ready to resume them in the days ahead once public health authorities make clear that it is safe to do so. So now just going back to the budget, the projected multi-year, multi-billion-dollar deficit the state faces as a result of the pandemic has had a major impact on the judiciary. Last spring, the governor in his revised financial plan urged the judiciary to reduce its current fiscal year spending by 10%. Notably, that amount was then deducted from the financial plan. As a result, and as a responsible partner in state government, we went ahead and reduced our spending by that amount. A spending reduction of this magnitude, a reduction significantly larger than the reduction we absorbed in 2011 when the state faced its last budget crisis, is an enormously challenging task for the court system. Our annual budget is overwhelmingly made up of personnel costs, with roughly 90% of the budget going to salaries of judges and non-judicial staff, along with health, pension, and other fringe benefit costs. So it follows that any effort to substantially reduce our spending must entail reductions in personnel costs. In making these reductions, there were no easy choices. Like much of state government, the judiciary has been living for years with very limited growth budgets, although in many respects, we are faced with a need to provide more services than a decade ago. Our annual budgetary allocation has only marginally increased since then. This has left us with little budgetary flexibility when there is a need, as now, to economize. Also complicating our effort has been the fact that coping with the pandemic and keeping the courts open as much as possible for virtual and in-person proceedings has necessitated substantial expenditures for technology, enhanced court cleaning, PPE, and courthouse retrofits. In addition, overtime costs have increased for our technology and public safety staff. Early on, we took a necessary first step. We instituted a strict hiring freeze, and so far this fiscal year, more than 730 positions that were lost to attrition remain vacant. While this has cost no one their job, its impact on court operations cannot be overstated. Our non-judicial workforce is the lifeblood of the court system. With no end in sight for the hiring freeze, the judiciary staffing level now stands below 15,000 employees across the state. This is 2,200 fewer employees than we had 12 years ago, a 13% reduction in our workforce. If the hiring freeze must remain in effect much longer, we can expect a diminished staffing level not seen by the courts in several decades. While the Chief Judge's Excellence Initiative in recent years has helped the courts become more efficient than ever before, our short staffing will make it increasingly difficult to conduct the judiciary's work in an effective and timely manner, particularly post-pandemic, when things return to a more normal course of business. This can have particular consequences for operations in courts that primarily serve economically disadvantaged litigants, including family court and housing court. Among the other hard choices we made this year was the decision not to certificate most of the Supreme Court justices who, having reached 70 and older, were seeking to remain in judicial service. Obviously, this was a very difficult decision, and toward the end of 2020, some of you asked that we reconsider it. In fact, some of the justices impacted by this decision have sued to have the decision overturned in the courts. As difficult as this decision may have been, we had no choice. By not certificating these justices, the judiciary will save $55 million over 2 calendar years. The grim alternative for us, in order to find comparable savings elsewhere in the budget, would be to lay off 325 or more non-judicial employees. And again, that's in addition to the 730 plus positions left open so far through the hiring freeze. This was simply unacceptable, both operationally and morally. First, as we learned from our experience in 2011, when the need for fiscal austerity required layoffs of several hundred employees, such a reduction can have a crippling effect on court operations. And as I have noted, this effect will be felt most in courts that primarily serve economically disadvantaged litigants who rely heavily on advice and direction from court staff to be able to navigate the court process. Second, because of the way civil service rules apply to layoffs, requiring layoffs now would fall most heavily on younger court employees not eligible to collect their pensions and strand them without income in what is a very difficult job market. The remaining austerity steps we've taken include limitations on non-personal service spending, and I won't go through that. They're listed in my written testimony that you have. So as we approach the start of the 2022 fiscal year, some have suggested that we should make more optimistic assumptions that before long, the federal government will provide financial assistance to New York and other states, and that assistance will cut New York's large deficit and enable agencies of government, including the judiciary, to ease up on their austerity measures. We certainly hope they are right, but we cannot base our plan on their hopes. For this reason, we've submitted a flat spending plan that maintains the reductions implemented this fiscal year. However, our budget seeks the same level of appropriations that was approved for the current fiscal year. So if the state's fiscal situation does improve in the days ahead, and the judiciary is able to share in the benefits of that, we will have the spending authority to meet all or at least more of our needs. But if that situation does not improve, we are prepared to continue operating under the spending reductions we have imposed during the current year. Our overarching goals will be to keep all courts open and to avoid layoffs of non-judicial personnel. The present hiring freeze will remain in place, as will the reductions in various judiciary programs. But we will fulfill our constitutional mandate, notwithstanding these cutbacks. And so just if I could conclude, I want to emphasize that now more than ever, as the state works to manage an enormous fiscal deficit while fighting the worst public health threat in our lifetime, the courts remain dedicated to ensuring the fair and prompt administration of justice. The budget we have submitted will, if approved, enable us to continue our mission regardless of what's in store for us in the days ahead. If it turns out that the state's present fiscal crisis requires that we continue to operate within a reduced spending level, we can do so under this budget. If instead the state's fiscal condition improves, this budget will permit us to resume more normal operations. Thank you for your attention, and of course, I'm happy to answer any questions.
Thank you very much. The first two questions will be Chair of the Judiciary Committee in the Senate, Senator Brad Hoylman.
Thank you, Chair Krueger and Chair Weinstein. Thank you for all of your work on these hearings, and it's good to see you, Judge. I appreciate the difficult circumstances under which you and your colleagues are operating. Let me just say from the outset, I'm concerned about the fact that a separate co-equal branch of government is imposing austerity measures. I'm not talking about the legislature, I'm talking about the judiciary, because I don't think austerity and the meting out of justice go hand in hand. But that's my editorializing as I open this hearing, and wanted to ask you specifically about what public health guidance you're following in terms of opening in-person proceedings, as you mentioned in your testimony. Frankly, I'm concerned about the health and well-being of many of our judges. And correct me if I'm wrong. Most of those judges are not getting vaccinated unless they're eligible otherwise.
That's correct. Judges are not among the categories of groups eligible for testing under the phases that have been implemented so far. And we've strongly urged the executive branch to include judges and render them eligible for the vaccine, because that's critically important to eventually resuming to more normal operations.
Thank you. And as you mentioned, your budget request keeps the all funds appropriations flat at 2.5 billion. And as you note, last year you cut your budget by 300 million. If we approve your budget as requested this year, so you're going to cut your budget again? Is that what I'm hearing?
No, we will maintain the 10% reduction that we experienced this fiscal year. So it's what we're seeking. I mean, obviously, like everything, this is a little more complicated this year. We're seeking the same amount of cash as we have in the current fiscal year, factoring in the 10% reduction this fiscal year, but our appropriation level is significantly higher. It's what was approved by the legislature last year. It represents a 2% increase over the year before that. And the reason why we want to maintain that higher appropriation level is that if there is federal aid forthcoming in New York, receives federal aid, and the judiciary benefits from that, we will be able to receive and spend more money up to that higher appropriation level.
So what does that mean for civil legal services? You know, obviously a very important function to make certain that the most underserved have legal representation, particularly during these difficult times. Can you commit, Judge, to keeping that 100 million in funding for civil legal services intact and not cutting it moving forward?
Well, what we did as part of the 10% reduction, the 100 million is in two parts. 15 million of that is a pass-through in our budget that we suballocate to the IOLA fund, which uses that money in awarding grants to legal services organizations. That was untouched, and that 15 million has been passed through this fiscal year to IOLA, and that will, if our budget is approved, that will continue in the upcoming fiscal year. What we did reduce by 10% was the remaining $85 million, which is money that we award in grants to approximately 80 legal services organizations. We did, in this 10% cut, reduce that 85 million by 10%, by $8.5 million. And because we're seeking a flat budget, we've put in for a flat budget for the upcoming fiscal year. That lower level of money in grants for civil legal services organizations would continue. It would be $8.5 million left in the upcoming fiscal year, unless we get more money in our budget.
Well, Judge, I don't have to tell you, as a representative, and I bet everyone who's on the Zoom would agree, we want you to spend the 100 million. We want our constituents represented in court. I would urge you to spend that, Judge. It's just so crucial, particularly given the complicated legal factors now at play for so many folks who are seeking legal representation. How about the OCA's contract with Housing Court Answers? Are we looking at a 23% reduction there, as I understand it?
That's news to me. I can check that, but Housing Court Answers is one of the 80 or so organizations that receive grants out of the 85 million. They would have, I'll have to check this and I will get back to you on this, but they should not have been reduced more than the 10% reduction that was imposed across the board. But I will check that.
And thank you. We'll follow up with you on that. And obviously, an issue that rankles a lot of the members of the judiciary is one you touched on, the certification of judges. Because we believe, I think again, many of my colleagues agree that this is penny wise, pound foolish to decertify these 46 judges that had reached the constitutional retirement age of 70. I wanted to point out something, Judge. Article 6 of the Constitution and the statute governing the certification process requires that the services of judges be, quote, necessary to expedite the business of the court, and that, quote, he or she is mentally and physically able and competent to perform the duties of the office. Is it your contention that these 46 judges have failed to satisfy this two-pronged test?
That is our position, and that's based on the much broader interpretation of the language in the Constitution that courts have applied and how they've interpreted that language over the years, including Court of Appeals decisions, including a relatively recent Court of Appeals decision in 2017. That language has always been interpreted far more broadly than how it literally reads, and with very good reason. And I could go into that if we have the time. But as I mentioned in my opening remarks, this issue is now in litigation. In fact, the case was argued before the appellate division just yesterday morning. So I don't want to get into too much of a discussion about it because I'm a named defendant in that lawsuit. But we strongly believe that that this was entirely legal. It was appropriate as a matter of good public policy and good fiscal policy. It was an extremely difficult decision. Don't get me wrong about that, but that it was entirely legal, and we expect to prevail once the lawsuits are resolved in the courts.
If you get additional funding through federal aid, for example, will you bring those judges back?
Well, that's a good question because there's some dispute about whether that would be authorized under the provision in the Constitution, because those judges are retired now from the court system. But to answer your question, because of the litigation, I can't really, basically you're saying, can we settle the case if there was money forthcoming? That's something that could be discussed, but I'd rather not do that in this venue.
And may I ask, Judge, how is the refusal to certificate these judges going to impact the non-judicial employees that work with and for those judges?
You mean their personal staff?
Yes.
This is unfortunately not widely understood and known, but that was about 90 or so personal appointees of these judges who weren't certificated. For those who wanted to continue employment in the court system, we have placed all of them with other judges and a few in other positions in the court system. So they've been saved. Those who've asked to continue, some retired themselves voluntarily, but those who wanted to stay on, we've placed with other judges in other positions in the court system, fortunately.
Thank you. My time is up, Chair.
Thank you very much, Chair.
Thank you, Judge.
Thank you.
Assemblywoman.
Yes, so let me before we go to our Chair of Judiciary, we've been joined by Corrections Chair, Assemblyman Weprin, Assemblywoman De La Rosa, Assemblywoman Glick, Assemblywoman Cruz, Assemblywoman Fahey, and Assemblyman Burdock. So now we go to Charles Levine, the chair of our Judiciary Committee, for 10 minutes.
And just a reminder, as Chuck is starting to talk, sorry, if you want to be on the questioning list, you have to raise your hand, which is at the bottom of your screen in the center. Thank you. Sorry, Assemblymember Levine.
Accept your apology, and thank you, Chair Kruger, and thank you, Chair Weinstein. It certainly seems to me that that at a time of savage and unprecedented attacks on our institutions of government, today's hearing takes on unprecedented significance. In his classic book on tyranny, Professor Timothy Snyder teaches us that in times of great civil crisis, our institutions of government, such as our courts, cannot protect us, the citizens, unless we protect them as well. So with that in mind, good morning, Your Honor. It's always a pleasure to see you, and please convey my gratitude to our judges, our administrative staff, and everyone who works in our courthouses, including court officers, court reporters, and those who have the challenging task of cleansing and sanitizing our courthouses as well. So on this subject of the non-certificated judges, we anticipate, meaning the courts anticipate, that there will be approximately 55 million in savings over the course of this year and next year?
Well, it's over the course of this calendar year and the next calendar year, because the terms of certificated judges are not coterminous with our fiscal years. So the savings would be in the last 3 months of this fiscal year, the full 12 months of the upcoming fiscal year, and 9 months of the fiscal year after that.
So does that amount of money, that 55 million approximately, does that also include judges who this year will reach the age of 70 and may request to be certificated or certificated, whatever the word is? And does it also include the judges who had been given certificates to continue past 70, whose 2-year term will expire this year?
So no, the 55 million pertains only to the 46 judges who were not certificated to start the beginning of this calendar year, January 1st, 2021. The judges who are currently certificated and those whose certification, you're right, it's difficult to pronounce. Those who would be up for recertification, the end of this calendar year, are not impacted by the decision that was made this fall. And hopefully later this year, the administrative board of the courts will be able to certificate and recertificate all or most of those judges.
So there's a movement to make permanent virtual or remote arraignments in our criminal courts. Do you have any particular view on whether that would be beneficial or detrimental to the concerns of due process?
Well, we've been out of necessity forced to convert to virtual proceedings throughout the court system, including for criminal arraignments. It's been successful. It was obviously done for health and safety reasons. And a lot of this experiment, if you will, with virtual court proceedings, I believe will continue post-pandemic, post-vaccination. But whether that makes sense for arraignments is something we would have to look at. We'd be interested in the views of our judges, how they feel about that. We'd be interested in the views of the district attorneys. We would be interested in the views, of course, of the criminal defense bar. We'd be interested in the legislature's view on that. That's something we'd have to look at. It has been very successful. Tens of thousands of arraignments. Everyone who's been arrested in this state has been arraigned, the vast percentage of which have received arraignments within 24 hours. It's been all virtual since the last week in March, so it's been successful. Whether it makes sense to continue that is something we would have to look at the appropriate time.
So as an old public defender from many years ago, I might simply add that something is really missing in terms of due process and in terms of interaction, basic interaction with those who are charged with crimes, where there is this lack of personal immediacy between defense counsel, even prosecutors and those accused, and the judges and those accused as well. But that's my 2 cents as someone who's been a defense counsel in the past.
I think it's a very valid.
Thank you. So we're going to end up with substantial case backlogs in our courts as we come to terms with how to best protect ourselves in the COVID crisis. Do you think that there are going to be changes in law that will be required in order to help address those backlogs?
Absolutely. One of the things we need to do to address backlogs, I mean, there's a series of things that we're going to need to do, and we are doing, which follows up on the Chief Judge's Excellence Initiative, which was 4 years in the making a year ago when we began to experience the pandemic, and was a very successful initiative. Dramatically successful in some courts in reducing delays and reducing backlogs and resolving older cases. So we know how to do this. And it's by looking at the data and sharing the data and focusing on older cases. And importantly, and this has happened to some extent during the pandemic, being able to move resources around, judges and staff, to address backlogs in the most efficient way. So to answer your question, yeah, I think that the most helpful and important thing that the legislature could do was to revisit the Chief Judge's proposal that was made last year to consolidate the trial courts. And I don't want to go into a long discussion about this today, but as you know, we have 11 separate and distinct trial courts in this state. It's far more than any other state in the country. It's a complicated, redundant Byzantine process. It makes it much more difficult to administer the courts. So if there was one thing in particular that the legislature should do, in our opinion, it would be to revisit that proposal and pass it, or at least since it's a constitutional amendment, see to first passage of our proposal this legislative year.
Thank you, Judge. Finally, the events of January 6th are fresh on our minds and will forever be seared on the mind and the heart of our nation. We've never seen anything like this before. Our courthouses represent our governments throughout the entire state of New York. I don't even know how many courthouses we have. I bet we have more than 100 courthouses.
Over 300.
Over 300. See, I wasn't even close. Close enough for government work, as they say, but not close enough. What steps are anticipated to be taken in order to provide protection to those representatives, those courthouses, which are so representative of our governmental authority?
It's an excellent question. And in fact, we did take steps last month, and we continue to be on alert for the problem that you raise. Our public safety command, the leadership of our court officer command, are in regular contact with law enforcement, FBI, and other law enforcement, the state police, with regard to credible threats to government buildings in the state, including courthouses. So and I don't want to get into too much detail about what we do if there is a credible threat, but we have measures in place and provide additional resources where that's necessary when we learn of a credible threat or a possible credible threat. So it's something we're very mindful of. It's a very real issue, as you point out, and we do have protocols in place to protect the courthouses, whenever, if and whenever that's necessary.
Thank you so very much, Your Honor.
Thank
I
you.
yield my 7 seconds.
Thank you. Assembly, I'm going to pass it back to the Senate if it's all right with you. And our next speaker is our Chair of Codes, Jamal Bailey, for 5 minutes.
Thank you. 5 minutes and 7 seconds as time was yielded by Chair Levine. Good morning, Madam Chair. Good morning, Madam Chair Weinstein. Liz, I'm very sad that we won't have budget pizza today. Judge Marks, good to see you. I'm going to jump right into it. This is my 5th budget hearing, and in each of the times we've had a conversation at the budget, we've spoken about diversity, not just within the ranks of OCA via the LEO program, which is great, but also diversifying the bench. And one of the things that Senator Hoyman wasn't able to touch on was the effect that it had on diversity within the ranks of the bench in the borough of the Bronx and also Queens. Many of the judges that we are losing as a result of OCA's plan, the decertification plan, are people of color. And as individuals of color are disproportionately affected by the justice system, we are disproportionately not represented within the ranks of the judiciary. I'm asking, were bar associations such as the MBBA, Dominican Bar Association, PRBA, and community organizations, did you have conversations with them when this was taking place?
No, frankly, we didn't. It was a strict budgetary decision. We felt it was a necessary and unavoidable, and difficult budgetary decision. And it was not discussed with bar associations or other groups. I could say, fortunately, look, you're absolutely right. And we've talked about this in the past. The judiciary should be more diverse, has to be more diverse. It has become more diverse over time, but a lot of work left to do on that. But I would say, fortunately, of the 46 judges who were not certificated, there were only 6 judges of color. So, and again, I'm not minimizing that. That's 6 judges of color, fewer than we have now than we did in December. But fortunately, it was not a larger number than that, or a larger percentage. And I think if, and these judges by definition are all 70 or older, but if for some reason a younger group of a block of judges left the court system, it would be far more likely that proportionally that younger block of judges would be more diverse and would include more judges of color than this group of 46 judges. But again, I don't want to disagree with you or argue with you on that point, because losing 6 judges of color is losing 6 judges of color. It's not a good situation.
And I would say those 6 of 46, yes, in the aggregate, that may not be as much of a percentage. But again, if you hyper local focus on the Bronx, we have a much larger percentage of judges of color that we've lost within the borough that has a majority minority population. So I would ask that we keep these things in mind, always based upon context. The next question I have is related to pretrial, some of the pretrial reforms that we were able to pass, some of the great pretrial reforms that we were able to pass. There are some reports that are due in November of 21 and January of 22. Are you having data collection issues with those, or do you anticipate that they would be completed on time?
Yeah, I believe the first one is due early July of this year. And we're hard at work on that. We're working hand in hand with the Division of Criminal Justice Services. And I know you have the DCJS Commissioner Mike Green testifying a little later this morning. So we are hard at work on that, have been for months, and expect to meet the statutory deadlines.
Okay. So again, the funding, right? Funding issues as related to the discovery reform that the governor's put in the budget. Has OCA taken a position on the amount of on the amount of money? Is it sufficient? Should there be less? Should there be more?
I think you're talking about funding for prosecutor offices.
The discovery form, yes.
Yeah. We haven't taken a formal position on that, but I can tell you from my own understanding of this and a background and experience that the new legislation does impose substantial additional burdens on district attorneys. So if they're asking for additional funding, I would offer that that's something that the legislature should look at seriously.
Okay, I would add my voice to the choruses of Chairman Levine about the in-person appearances being critical to, I think, the integrity of our justice system, and as related to the Article 7 proposal. And if there's time for a second round, I will come back, but I yield my 7 seconds, Madam Chair. Thank you, Judge.
Thank you.
So we now go to Assemblyman Dinowitz for 5 minutes.
Good morning, 5 minutes and 7 seconds. Good morning, Judge Marks. It's good to see you. I'm glad you're here today. I think it's regrettable that it's under these circumstances with the horrible budget that you have to deal with. I wish OCA had participated in the hearing that the Assembly had a few months ago on the budget, because one of the things I think is important is that when a decision is made, it should at least bring in some of the stakeholders, the legislature, because after all, the legislature has the authority to review, modify, and approve budgets. But not only the legislature, but other stakeholders, bar associations, the New York State trial lawyers, defenders associations, civil legal services, all the stakeholders that are really impacted by these very crucial decisions. So I would hope that on important decisions like that in the future, that those things will be taken into account. And I just wanted to say that the 46 judges, 8 of them are from the Bronx. We comprise in the Bronx 7% of the state's population, yet 17% of the judges that are being eliminated were working in the Bronx, the borough, the county that is probably in the greatest need of every county in the state. And of the minority judges that you've referred to, people of color, of the 6 judges, 3 of them are from the Bronx, 50%. That's also a big problem, I think. And the borough of Queens, I think they lost 6 judges. So that's a very high number. And the impact of this decision is not evenly distributed throughout the state, but in fact, certain areas, and I will say again, particularly the Bronx, is most heavily impacted. Elevate civil court judges, criminal court judges to become acting supremes, but that means that you're emptying out the civil court and the criminal court, which I think is another problem that you're going to face. But let me ask you this question: the cost of that you're going to save by eliminating a judge. The judge makes a salary, but that judge will then start collecting pensions at a much earlier stage. And the cost of the pension is very significant. Now, I realize the pensions don't come out of OCA's money, but it comes out of the taxpayers' money one way or the other at some point or another. So given the fact that you're not really saving money by, or at least not a significant amount of money by firing these judges, how do you really justify that?
Well, it's true that if you look at it from an overall state perspective, I believe there's still a savings for the state as a whole, but not the full 55 million. But the fact of the matter is, I mean, our responsibility is to balance our budget and operate within the money that's allocated to us. And there's no question that there's a $55 million savings to the judiciary, which of course is our primary concern. Assemblyman Dinowitz, could I just respond very quickly to what you said about the Bronx and losing the judges? It's 7 judges, 2 were in the criminal term, 5 were in the civil term of Supreme Court. Through reassignments, we haven't waited, and we haven't even done this by taking judges out of, as you said, robbing the lower court, the lower criminal and lower civil courts. We've taken judges, Supreme Court justices, and 2 Court of Claims judges who were appointed by the governor last summer. And the 5 judges that the civil term lost in Bronx Supreme Court, because we are very concerned about that, as you are. And please believe me when I say that, because Bronx is a court that struggled with backlogs historically over the years. But we have held the civil term of Bronx Supreme Court harmless with respect to the five judges in the civil term who were not certificated by moving 5 other judges into Supreme Court. And the administrative judge of that court is very pleased that we were able to do that, and is not complaining about judicial resources, at least for now.
Oh, I'm sure the complaints will be coming in the near future. But you know, I understand what you said about you're worried about the judiciary budget, and rightly so. But we, as legislators, have to look at the whole picture, and the whole picture is that ultimately the taxpayers really are not saving much money at all. But yet we're concerned about how that's going to affect how justice is dispensed in every county in the state. And my time is up.
So
Thank
we
you.
go to the Senate now.
Thank you very much. We're next going to Senator Tom O'Mara.
Thank you, Chairwoman Kruger. Good morning, Chief Judge. Thank you for being with us today. I want to first thank Assemblyman Levine for his opening quote regarding tyranny and the protection of our government organizations. And that's certainly never been made clearer than the 61-day siege of our federal courthouse in Portland and the several-week siege of a police precinct in Seattle. What is the court system doing, Your Honor, to prevent something like that happening here in New York State?
That's an interesting question. It's not one that's occurred to me, whether the judiciary has a role in protecting attacks and assaults on other governmental buildings. I mean, other than if that occurs and people are arrested and they're charged with crimes, the judiciary will adjudicate those cases. But other than that,
well, I guess I'm talking in particular that what efforts are being made to protect courthouses in particular, since it was a federal courthouse in Portland that was under siege for 61 days.
Yeah, as I noted before, we have protocols in place to deal with credible threats to our more than 300 courthouses over the buildings, courthouses throughout the state. And we've instituted those protocols at different times when there has been a credible threat. And we are confident that we would be able to protect our courthouses if they were under assault, and anything remotely like what happened in Washington, we would be able to protect. We would be ready for that in the courthouses.
Thank you. I hope we are, because we certainly do not want to see that here anywhere, especially here in New York State. Moving on to virtual appearances. I'm drawing a blank on the section of law right now, but we've been working on it in our judicial district on virtual criminal court appearances. Some counties in the state have the ability to do virtual appearances even before this pandemic, I believe. Now others are allowed to do them while this pandemic is continuing. What are your thoughts on expanding that type of virtual appearance activity to these other counties that hadn't been able to do it before? Because I think from what I've been seeing, it has been very successful, and certainly in criminal cases with the transporting of inmates back and forth. And these appearances aren't for the purposes of sentencing or live testimony of witnesses at hearings and things, but for the more run-of-the-mill control dates and things. What's your thoughts on expanding that to these other counties that won't be able to continue that when the pandemic ends?
Yeah, I think under one of the governor's executive orders, it's permitted across the state video court appearances and routine proceedings in criminal cases. I agree, it has been very successful across the state. And we would be supportive. The provision of the criminal procedure law, I believe it's Article 182, allows for this in a limited number of counties. As I said, the governor's executive order allows it, for now at least, across the
Right.
state. So we would be fully supportive of legislation that would expand the current provision in the criminal procedure law to all 62 counties of the state.
Great. Thank you very much. Can you just briefly, in the minute that's left here, you've talked a little bit about backlog, and we certainly have had backlog in our court systems at both civil and criminal levels for some time. How has the pandemic to this point exacerbated that backlog? And when this pandemic ends and we get back to fully functioning courtrooms, how long is it going to take us to dig out?
Backlogs have grown, not necessarily across the board. In fact, Supreme Court, civil cases in Supreme Court, the backlog, interestingly, has not skyrocketed. It's been fairly modest, and I think that's because virtual proceedings have worked so well in Supreme Court, where in the overwhelming number of cases, the litigants are represented by counsel. So when that's the case, as compared to courts that handle a large proportion of their cases involve self-represented litigants who are not always as able to navigate the technology to participate virtually. But we do have backlogs that have grown. Look, the court system has always had backlogs. That's been the chief focus of Judge DiFiore in her tenure as chief judge, is to attack backlogs and make the courts more efficient and eliminate delays. So we had made tremendous success in that, as I noted before, but we're really going to have to redouble our efforts post-pandemic and focus intensively on the older cases, collect a lot of data, because a lot of this is data-driven, and share that data with our administrative judges and our rank and file judges in high-volume counties. Assign dedicated judges just to focus on trying to resolve the older cases, make greater use of alternative dispute resolution, and be more creative and flexible in how we move and assign our judicial and non-judicial resources, among other measures and steps we're going to have to take to address what are going to be very substantial backlogs.
Thank
Thank
you.
you.
I hate to
Thank you,
cut
Your
off
Honor.
the judge. Thank you, Tom. Passing it back to the assembly.
We go now for 3 minutes to Assemblywoman Rajkumar.
Thank you, Chairman Weinstein. Thank you to our Assembly's Judiciary Chair, Chuck Levine. And thank you, Chief Judge Marks, for your time and your testimony today, and for your efforts to maintain the integrity of our justice system during the very many challenges presented by this pandemic. I have 3 quick questions for you this morning. And my first question is about the discovery reform. How is the discovery reform that we enacted last year working out now in the New York State courts? And now that prosecutors must disclose their evidence earlier and that discovery is more enhanced, how are the district attorneys adjusting?
Well, I'm sorry.
Yeah, I thought, let me just get my 3 questions out, and then I look forward to your answers. So I just wanted to know how it's playing out in our courts. And my second question will be no surprise. I want to ask how the Office of Court Administration is managing layoffs generally during the pandemic. And I know, as was mentioned here several times, OCA was forced to lay off at least 324 court employees, 92 non-judicial chamber staff, and then, of course, compelled those 49 judges to retire. So can you just speak more in detail about how you are managing the layoffs generally, giving us insight into your strategy and thinking as a manager as you run OCA? And then relatedly, given that we do not have enough court personnel, can you talk about the steps that OCA is taking to deal with the backlogs in the courts and the overworked staff? Thank you.
Okay. Just quickly on Discovery, the governor's executive order stayed or suspended the swifter timetables that were part of the discovery reform that was passed by the legislature. So it's premature. I think most DA's offices are trying to comply because they, at some point the executive order will be lifted and the full extent of the legislation will take effect again. So I think a lot of the DA's offices, it'd be a good question for them, better for them than to me, but that they're complying nonetheless, or gathering the information that they're going to need, because the day of reckoning will come, and when the executive order is lifted and the reform takes full effect again. As for layoffs, we have not had to institute layoffs, and that was the our primary goal, and what led to the decision not to recertificate the 46 Supreme Court justices, because it was an either-or proposition. Either we saved the money from not certificating the Supreme Court justices, or we laid off over 300 employees. And we made the difficult decision that it made more sense, as difficult as it was to not certificate the judges, than to lay off the employees. And that was motivated by operational reasons, where we felt we could not afford to lose more employees on top of the attrition that's resulted from our strict hiring freeze. And it was also, we felt, the humane decision, given that if there were layoffs, it would be disproportionately younger employees with lesser seniority who would not be eligible for pensions, and would have great difficulty finding other employment, in this economic situation. So I hope that answers your questions.
So when you say, I know my time is up, but when you say there's no layoffs, I mean, it was reported in the Daily News that there was 300 layoffs. Can you clarify for me what you mean?
Time has expired.
Yeah, well, it's important. There were no layoffs. We avoided, if the 46 judges had been certificated, that would have translated into and compelled us to lay off
Judge,
325 employees.
Judge, we're going to go back to the Senate now. Thank you.
Sure.
Thank you very much. We next go to Senator Gounardes from Brooklyn.
I do not see him in here, Senator Krueger.
Oh, he's stuck off. All right, we'll circle back to him. Senator Kevin Thomas. Kevin, are you there? There you are.
Can you hear me?
Yes.
All right, excellent. Thank you, Chairwoman Krueger, and thank you, Judge Marks. I just want to take this opportunity to say how disappointed I am with the New York City courts and their handling of COVID. There are several issues which I would like to address, but I will focus my time on two things. First, the need for cleaning at the courthouses. I remember talking to you about this earlier on, but I specifically mentioned the Bronx Supreme Court. Every other day, a court employee tests positive with COVID, but proper cleaning is not done in the areas where the employee worked. And there are set guidelines for worker safety, and I don't think the courts are following that. Second, it's nearly impossible for litigants to get their court file. This kind of delay is resulting in litigants not being able to fight their cases. This is a violation of due process. I'm sure, again, this is not the first time you're hearing about these issues, and I cannot believe this is not rectified. Are you putting pressure on supervising judges at these courts to fix these problems?
Okay, just going to the first issue with court cleaning, and you and I have talked about this, and I've looked into it every time we've talked about it, and there's no question in my mind that there is extensive cleaning going on, particularly when a court employee has reported that they've tested positive for the virus. There's extensive cleaning going on. It's done by In New York City, the DCAS agency, as you know, maybe not everyone knows our courthouses are not owned by the state court system or maintained by the state court system. They're owned and maintained by local government, New York City, and outside the city, the county governments. And there is no question in my mind, and we really have to get to the bottom of this. It might be helpful if we knew if we had specific information where people believe that cleaning is not being done, because I've talked to many people about this, and within the Office of Court Administration, and we've talked to people within DCAS, the responsible agency in New York City government, and there is extensive cleaning going on, not just regular cleaning, which is elevated over the regular cleaning that's done in normal times than that was done pre-pandemic, but particularly when we learn that an employee or someone else has been in the building or has been in a courtroom who subsequently tests positive, there's very extensive state-of-the-art cleaning going on in those situations. So I'm not disputing what you're hearing, but you and I have to talk further and get specific information about where we think there have been problems. And I can promise you, we will look into them, and if there are problems, we will address them. But what I'm being told by everyone involved in this is that what I already knew is that we have very extensive cleaning protocols in place in all of our courthouses throughout the state. As for your second question, if I could quickly, about getting files, we spoke about this as well, Senator Thomas. I looked into it. It is in fact a problem. It's a function mainly of limited and reduced staffing in the courthouses, but you've identified a legitimate problem. It's a problem we need to address. The ultimate answer is to do more scanning so that we have fewer or no paper records, and everything is digital and online and accessible to lawyers and the public for that matter. And that's something we will work on. That's not a simple thing to do across the board. But the New York City Civil Court, where you've identified the problem, does not have e-filing.
I do. Hold on 1 second. I have to.
Can you mute, please? Judge, I know we are running out of time, but in the meantime, what are litigants supposed to do when they've filed their
Sorry,
clauses?
you've already run out of time. So you can follow up with him in writing or afterwards. Or
all right. Thank you, Judge.
Thank you.
We go to Assemblyman Epstein, 3 minutes.
Thank you, Chair Weinstein, and good to see you, Judge. I wanted to second the point about the money for legal services. I think the cuts are going to be catastrophic for millions of New Yorkers. I hope you reconsider the 10% cut, because Judge Lippman worked very hard to get that to $100 million, and it hasn't budged since then. We want the number to go up, not down during a pandemic, and I hope you figure out a way to support additional funding. On diversity of the bench, I know there's a huge issue with the lack of diversity of the bench, and I'm wondering, a report came out last year saying there's more diversity in judges that are elected than appointed, and I'm wondering how you feel about moving towards more an elected bench where that will allow more diversity in our judicial system.
Institutionally, we don't have a position on that. We have great elected judges. We have great appointed judges. We really can't take a position and get that. That's a politically charged issue, an issue for the legislature, not for the court system. I will tell you though that the one
judge, but just it isn't really, because the court makes appointments. You make housing court appointments. You make a lot of appointments that has made the bench less diverse, according to reports that we've gotten. So we really want the court to be a partner in this, and we make sure that the bench reflects the New York population. And right now, it's not doing that.
We appoint housing court judges. It's actually my appointment based on a qualification process by a statutory advisory council. And half of our housing court judges are people of color. So I don't know that there's any category of judgeships that's as diverse as our housing court judges, whom we appoint ourselves. Acting Supreme Court justices, which you might be thinking of, I agree we can do a better job of diversifying the ranks of our acting Supreme Court justices. And we will make every effort to do that.
Thank you. I appreciate that. I just wanted to see how, we passed making sure that ICE was no longer in the court system. I wanted to make sure there were any implications for that. I know I have less than a minute left. So just before you answer that, I want to just echo my colleagues around arraignments, how important it is for in-person conversations between a lawyer and their client. I've been a lawyer for over 25 years in New York, and I can tell you that, you can't really get the same thing on Zoom as you can in person. And I think especially people in criminal proceedings really need to have that face-to-face time. And if you could also answer about the declaration form for commercial and residential tenants, what are you hearing in the court system, about that? And I'll give you the time if you have to answer those two quick questions.
Okay, with the declarations, about 500,000 were sent out by our office. We have not gotten a lot of feedback yet on how that's working. There have been, and I can get you, I don't have it at my fingertips, but I can get you the number, and it's a fast moving target because it increases every day. But the return of signed declarations, but I can get you numbers on that. But the important news is we did get out all of them several weeks ago. The form the manual form that's sent out is in English and Spanish, but I think it's 6 or 7 most commonly spoken languages other than English. The form is accessible on our website, and that's noted in different languages on the hard copy form that we sent out. So we're optimistic that this will work out very well, and but more information to come.
Thank you.
Thank you. We go to the Senate. Before, I just want to introduce some members who have joined us since we began. Assemblyman O'Donnell, Assemblyman Kim, Assemblyman Byrne, Assemblyman Ashby, and Assemblyman Palmisano. Now to the Senate.
Thank you. I was going to call on Senator John Brooks. And here he is in his chair. Perfect timing. Senator John Brooks, Chair of Homeland Security and Veterans, 5 minutes. You need to unmute yourself, John.
Yeah, it wasn't cooperating. Thank you, Madam Chair. I appreciate it. Judge, we appreciate you being with us today. I want to just move maybe to a brighter note for just a moment and ask if you would comment on the Veterans Treatment Courts, the expansion of the program, the success we're seeing, where you think that can go, and how you see or don't see the acceptance of other neighboring counties accepting to participate in the program.
The Veterans Courts are terrific. We've expanded them. We have 37 Veterans Treatment Courts throughout the state, and that's not enough. We need more. There are remaining counties. We have an office that's dedicated within the Office of Court Administration to assisting localities with problem-solving courts, including the Veterans Courts. And I mean, I've never heard a word of criticism, or at least as to the concept of a Veterans Court on either side of the aisle, or in any stakeholder in the justice system in the state. I've never heard anything other than positive comments and response about Veterans Courts, and we're fully committed to them. And as I said, we're not stopping at 37. Maybe when I come back next year to testify, it'll be 62 or much closer to 62.
Yeah, that sounds good, and I agree. I think it's a great tool and great success, and I thank you, and I yield back my time.
Thank you very much. Assembly.
Yes, we go to Assemblyman Goodell, 3 minutes.
Thank you very much, Chairman. Chairman, can you hear me?
Yes.
Thank you very much, Chairman, and thank you very much to Judge Marks. As you noted earlier in your testimony, the judiciary curtailed many in-person proceedings earlier this year. And of course, that's creating even more backlogs. And as you acknowledged in an earlier testimony, the backlog is substantial and growing. Of course, one of the largest and most significant backlogs is in the housing court because we haven't had any evictions now. Looks like it'll be over a year. My question though is, at the same time that the court system is closing down in-person proceedings and creating more backlog, virtually every private sector business has been reopening. And the court system itself has been giving several decisions, striking down regulations that keep private sector closed. So my question is, why are the courts closing to in-person proceedings while the private sector is doing everything it can to open? And isn't the closing of the courts to in-person proceedings merely exacerbating the already horrific backlog that exists in housing court and some of our other courts?
Well, I with all due respect, I think the analogy to business organizations, may not be a sound one. Courts are different in many respects from most private organizations in that we have tens of thousands, in normal times, we have tens of thousands of people coming into our buildings every day. And, to suggest that we should go back to now, coming out of a second resurgence, that we should go back to normal in-person operations is just contrary to the advice of every public health expert we've talked to, including our own public health expert. And, we haven't, we did very early on in the pandemic, in late March, in April, and part of May, shut down all in-person operations, and we were conducting business entirely virtually. And then we, in the spring, the later spring, we started to expand in-person operations. We brought back, among other in-person operations, grand juries and criminal and civil jury trials, along with other in-person operations. But we, with the onset of the second resurgence, we did cut that back again. We have not suspended grand juries. Every county in the state continues to have at least one functioning grand jury. And when we're advised by the experts that it's safe to resume jury trials, we will do that. In fact, we've been talking about that recently. And if things go well, and we can't predict the future with this pandemic, but if things continue to improve, we will resume jury trials, which are clearly a critical part of the justice system, both on the criminal and the criminal and civil side. We can't have a fully functioning court system without jury trials. To some extent, it's what drives the court system, because although, as you all know, a very small percentage of cases actually go to trial, the opportunity to try a case is what drives settlements and pleas and other dispositions. So we're entirely guided by public health experts and what they're saying, what they're advising us. And hopefully we will be able to resume more in-person proceedings. We haven't suspended all of them, but hopefully we'll be able to resume more and continue that and return things as close to normal before everyone is vaccinated as best we can.
Thank you, Judge. I do note that I sent you some questions back in November of last year relating to the budget. I hope and trust you'll be providing me with a response to those.
Sure, I can call you or respond in writing or both.
Thank you very much, Judge.
Thank you.
Thank you. We go to Assemblywoman Joyner, 3 minutes.
Okay, thank you. Good morning, everyone. I want to just say fantastic job by our chairs who are running all of these hearings. Thank you so much. Good seeing you again, Judge Marks. I have a couple of questions. As you know, this pandemic has placed a strain and an unprecedented backlog on the New York State court system. And, I want to echo the concerns that my Bronx colleagues have brought up of, it's concerning that OCA didn't consult with the legislature, with the governor's office, with key stakeholders, trial lawyers, bar associations. It's very concerning because we're all partners in this whole thing, and it would be helpful that we can all be included in the discussions to help make sure that the court system is running smoothly for all litigants. So my first question is, did OCA conduct any study on the impact of eliminating these 46 judges from the court system and its impact on the backlog of the court system?
No, we conducted no formal study, but the decision was based on our long and in-depth experience in administering and managing the courts. The judges, by definition, the judges who were not certificated are judges who sit in the Supreme Court. And we felt that the alternative, if the judges were certificated, we would have had to lay off employees. That would have impacted disproportionately on courts that have large numbers of self-represented litigants who of necessity have to rely on court staff, court officers, court clerks, help desk employees for advice and direction on how to navigate the court system. And we felt that, not that this was a simple decision or an easy decision. It wasn't. Don't misunderstand me, but that given the two bad choices, the worst choice would have been to certificate the judges and have to lay off hundreds of employees.
Well, I hope that there will be a follow-up and a review of the impact of this. And I have 30 seconds left, but you and I worked very closely on making sure we had a legal hand site in the Bronx. It has closed, unfortunately. It would be great to figure out how we can revamp that and revive that. And then we've also worked on the language access problem in the housing court. Are there any plans from OCA to expand this in other courts?
The simple answer is yes. We need to do more with language access. It's a very challenging area. It can involve more resources. We don't have a lot more resources, but the simple answer to your question is yes. Language access initiatives can be expanded to other courts, and that's something we will look at.
Thank you.
Thank you. We're going to go, I believe the Senate does not have any other.
Correct.
Okay, so we're going to go now to Assemblywoman Seawright, 3 minutes.
Thank you, Chair Weinstein and Judge Marks, for your testimony today. I just have a couple of questions. Under Judge DeFiore's proposed simplification plan, certain courts like Family Court and Surrogates Court would join the Supreme Court. Family court facilities have designated areas that Supreme Courts lack, like child care and help desk for litigants who are unrepresented. How will OCA take this into account?
We would take it fully into account. Under the proposal, Family Court, we would have a consolidated Supreme Court, which would include Family Court, but we would have divisions within the Supreme Court, including a family law division. So the sort of the unique layout and resources that family courts have now would continue. I mean, those facilities obviously would continue to be used, and the design of those facilities would continue to support the way that the cases would be handled, although they would be Supreme Court cases, not family court cases under our proposal.
Okay, thank you. The pandemic has reduced the ability of OCA to host events, trainings, in-person conferences, saving money in your budget. Have you put a dollar amount on how much has been saved from all of these in-person trainings and hotel stays for your senior OCA officials now that don't travel?
We can calculate that number. I don't have it with me at the moment, but we will get you that number. So there's been, we've done a lot of training though. I just want to emphasize that. It's been online primarily for health reasons, but it's also had the benefit of saving us some money, and I will get you that number.
Okay, thank you.
So now we go to Assemblywoman Fahey.
Thank you, Judge. I know a couple of questions have been asked already, but I just want to go back to a couple of them. One, I just want to reiterate my sharing of the concerns with the courts being closed for and the access, and certainly I've seen a lot of concerns raised about that we're not processing those who are accused, and so very concerned about what is needed with technology and what have you. But I also, in order to keep them open and keep them full functioning, as well as to address the backlog. But my question though is also on the retirements. What is the plan to reduce the number of elected civil court judges by appointing them to the Supreme Court? And I'll get back to the retirements.
Just if I understand your question, you mean what is the plan for designating lower court judges as acting Supreme Court justices who can then sit in Supreme Court and handle Supreme Court cases? Is that your question?
Yes, to reduce the number of elected civil court judges by appointing them to the Supreme Court. How do you plan to reduce that? As well as, and I'll combine it with the next one, which is to increase the number of court of claim judges. The plan to increase the court of claim judges appointed to the Supreme Court. So however you want to broadly address that.
Well, court of claims is entirely the province of the governor. And there are court of claims vacancies, and those nominations and appointments are usually made at the end of the legislative session. So I'm not aware that there's been any discussion yet about that. But there will be, later in the spring, I would think. In terms of elevating lower court judges, civil court judges to Supreme Court, we have not done that yet this year. That's usually done at the beginning of every calendar year when we go through and rethink all judicial assignments throughout the state. We haven't done that this year at all. We haven't appointed new acting Supreme Court justices with judges from the lower courts. We will do that if we determine that that's needed. But I think, as someone suggested a while before, it's kind of a zero-sum game, because if you take judges out of the lower courts and you put them in Supreme Court, you've helped Supreme Court, but you've robbed the lower court. So it's kind of an art, not a science, I would say. But it's an option that we have, and it's a critical option that will help us attack backlogs as we go forward, particularly post-pandemic.
Okay, just overall, just want to share the concerns on the retirements, especially with the diversity among the retirements. Thank you so much, Judge, and I think I've used my time. Thank you, Chair.
Thank you.
We go now to Assemblyman Lawler.
Thank you, Chairwoman. Judge, thank you for joining us this morning. Appreciate your testimony. I want to focus in on the 9th Judicial District, which is where I live. Rockland County is part of that district. Currently, there are 40 judges within that judicial district. 29 of them come from Westchester, 11 of them come from the other 4 counties, Rockland, Orange, Putnam, and Dutchess. So roughly 72.5% of the judges that are elected come from Westchester County. Westchester makes up about 47% of the total population of the judicial district. The other 4 counties make up about 53%. I have put legislation in to create a new judicial district to ensure that there is adequate representation for the other 4 counties within this judicial district. Clearly, and obviously that is in part a political problem where these judges are being elected from. But clearly the other 4 counties are not getting equal representation. I'm just curious if you have any comment as to whether or not it might make sense to create a new judicial district to ensure equal representation within those other 4 counties.
Well, remember, we do have authority within a judicial district to move judges around. So there are judges who are either elected from Westchester or reside in Westchester who sit in other counties. And we sort of every year and throughout the year, for that matter, look at that to make sure that the assignments are consistent with the caseloads and the backlogs within all the counties of a judicial district. But in terms of creating another judicial district, that's something we could look at, and I'm happy to talk to you about that to see if that makes sense and meets the wisely meets the district, the needs and the circumstances of the district.
I appreciate that, and I very much would look forward to speaking with you about that. I think the caseload will show that the other 4 counties certainly are on par with Westchester, and certainly there is a need for more judges to be sitting in those other counties. In the time I have left, I would also just ask, currently, do you know how many judges from the 9th JD have been assigned to the Bronx or other judicial districts outside of the 9th JD?
I do not believe any have been assigned to other judicial districts, but there are some judges who are assigned to the Bronx. That's correct.
Okay, and the reason for that is based on caseload, or what's the reason why they are not serving the people they were elected to serve?
It's based entirely on caseload and the caseload needs and backlogs in the Bronx, and the judges who've been reassigned, and these are not permanent reassignments. They're usually temporary reassignments. It could be a year, could be less than a year, it could be longer than a year, but they're temporary assignments, and it's strictly based on need, and it's with the cooperation and participation of the individual judges who've agreed to a temporary reassignment.
Okay, I'd like to follow up with you on that. Thank you.
Sure.
Thank you. We go to Assemblywoman Kellis.
Good morning, Judge Marks. It's nice to meet you for starters, and thank you to both.
Morning.
Good morning. Thank you to both chairwomen for their endurance, if nothing else, for these meetings. I had one question related to a comment earlier about the impact of the discovery reform on district attorney offices. I just wanted to share a bit of information. I know in one of my counties, they've had to hire a 3rd investigator and an additional paralegal. They've had to add their own dedicated wireless network due to the bandwidth they're using. And they have also had to send a lot of the labs out to private labs because of a backlog at the state labs. And those are, multiple times more expensive. So I'm curious what data you're looking at that shows that there's no real impact on costs. I certainly think that discovery reform was, personally think it was a great idea, but the cost impact and the lack of funding is concerning. So I wanted to hear your response to that, and if there's any data or connection or communication with the district attorneys on that point.
Yeah, I think I said that I agreed that the new legislation imposes significant new burdens on district attorneys' offices, and it may well, they might well benefit and make a good case for additional resources. I haven't studied that particular issue myself, but I think there's no question the new law imposes significant new burdens on the DAs. And we certainly, it's not really our issue. We're more concerned and focused on additional burdens on the court system and whether we would require more resources as a result of this new legislation or any new legislation. But we certainly would be sympathetic to district attorneys' pleas for additional resources to help them better comply with the new discovery law.
And I'm curious, another comment. We had many questions before. Some of the points I'm very much in support of about funding concerns for the 46 judges, of course, as well. And I'm curious if there's any data on being collected on the time to arraignment that we're seeing. Is that being tracked? And can that be shared in response to the loss of the 46 judges?
Well, these 46 judges do not sit in the arraignment parts in the lower courts.
But it can create a backlog.
Well, I'm not so sure about that. I don't know if I agree with that in terms of we have enough judges to staff the arraignment parts. There really haven't been delays in arraignment. There's a mandate from an old Court of Appeals decision which says that people who are arrested for crimes and held in custody and brought to court for arraignment should presumptively be arraigned within 24 hours. And we do have data on that, and we do track that regularly. And we believe that the 24-hour rule is being complied with, particularly in New York City, where compliance with that rule has been a challenging issue for the courts and the whole criminal justice system for many, many years. Arrests are down now, and the compliance for a speedy arraignment, if you will, has been good from all the numbers that I've seen.
It would be wonderful.
Thank you, Judge. We're going to move on now to Assemblyman O'Donnell.
Thank you very much, Chair. I've not been here for all of it. I was conducting a committee meeting, but I want to make sure that you are hearing us. Many of us are disturbed. I'm outraged about your decision to not certify some of the judges who are available to be recertified. I'm disturbed because in my days when I was a mere legal aid lawyer, I would be accused of judge shopping if I handpicked who could and who could not get certified. Additionally, just before you decertified those people, you put 3 new Court of Claims judges in. Can you explain the rationale for creating 3 new judgeships when you're telling the most talented and experienced judges they can stay on the bench?
Well, we don't appoint Court of Claims judges. The governor does that. So that was not our decision and never would be our decision. In terms of
do you play any role in who gets those jobs, sir?
Occasionally, we're asked for information if there are judges who are under consideration, as opposed to lawyers off the street. Occasionally, we're asked for information, caseloads, and information on judges who were seeking nomination and appointment to the Court of Claims. But in the end, that's the governor's decision, not our decision.
So you're suggesting to me that you made a money decision about the careers of these extraordinary jurists, and then the governor in the next moment put 3 new people on the bench and you didn't know?
Well, I think the timing of it was the reverse. And I could be wrong about this, but I believe the governor made, and I think it was 4 Court of Claims appointments in June. When those appointments are normally made, and the decision about whether to certificate the retired Supreme Court justices was made in late September.
Okay, well, I can hardly believe that the financial problems that you bring up didn't exist in June, but did exist in September. Having said that, I'm concerned about the courts that are open, and I'm particularly concerned about the judges who are asked to staff them. Can you assure me that all judges who are staffing in-person courtrooms in the city of New York are getting access to the COVID vaccine?
I can assure you of that. We have urged the state health department to include judges among the groups of people that are eligible for the vaccine. We think it's incomprehensible that judges are not included on the eligibility list, and hopefully that happens soon. So I couldn't agree with you more on that one.
Well, I can assure you it is not happening currently. And I can assure you that the other employees of the court system who stand next to the judges are in fact getting the shot, but the judges are not.
You're absolutely correct about that.
Well, what can you do about that, Judge?
The executive branch determines who is eligible. We can't decide that on our own. We can interpret the guidelines, the language of the guidelines, and we have interpreted the language of the guidelines as applying to our staff. But the language of the guidelines does not apply to judges, and we've urged, believe me, we have urged the health department, the governor's office, to include judges among the categories of people and groups that are eligible, and we'll continue to urge them to do that.
Thank you.
I would certainly
Thank you.
hope that
The time is, we're a minute over. Thank you. Thank you, Assemblyman. Assemblyman Burdick.
Thank you, Madam Chair, and thank you, Your Honor, for your presentation. I have two questions. The first comes from one of the town judges in my district who asks about the sufficiency of funding for the local courts for dealing with COVID-19. If you could address that. And the second question stems from my experience in local government regarding specialized courts. And for example, in Westchester County, there are specialized parts in several areas, including foreclosure settlement and environmental claims. And my experience is they work well. And I'm wondering whether OCA is looking at establishing other specialized courts. And if so, what areas do you feel may be considered?
Just going to your first question, the town and village courts are part of the unified court system, but they're not funded by the state. They're funded by, unlike all the other courts in the state, the county courts, the family courts, the surrogates courts, the city courts, the Supreme Court, the town and village courts are locally funded. And although we do have a grant program that we've had in place for years, there's several $1 million in the grant program that would be continued in our proposed budget. But we don't have the money in our budget to fund the town and village courts in terms of PPE and retrofitting of courthouses. We do have this grant program that they could take advantage of, but ultimately that's something the legislature might want to look at, because the town and village courts are an important part of the court system. Well over 1 million people go through the town and village courts, and maybe 2 million people year in and year out. And we can't reopen the rest of the court system to full in-person proceedings and not do that for the town and village court. So it's something that the legislature should look at in terms of supporting those courts. As for problem-solving courts, we are fully committed to our problem-solving courts. There are hundreds of problem-solving courts throughout the state of New York. We're committed to creating more. I mean, they're all successful. They all address their own unique and specific problems. And to answer your question, we're fully committed to our existing problem-solving courts, and we're committed to expanding them to additional jurisdictions.
Thank you. I do know that the town and village courts are supported locally, having been a supervisor of a town. And I certainly will pursue that suggestion about the legislature looking at supplemental funding. Thank you very much.
Thank you.
We now go to Assemblyman Byrne, 3 minutes.
You're muted.
Assemblyman, yeah, please.
Thank you. Can you hear me now?
Will be good?
Yes.
Yes.
Okay, thank you, Chair. And thank you, Judge Marks. My question is relating to the Drug Treatment Courts General Fund. My understanding is it's from $15.8 million and it's being decreased by nearly $500,000. My question is, how does that affect the county drug treatment courts in the 9th Judicial District specifically? I represent Westchester and Putnam, but Putnam County's drug treatment court program has been lauded across the state and even somewhat nationally. And I know while we often in the legislature, we may act in silos and say, this is my county. It's important to note that many of the people that benefit from the Putnam County Drug Treatment Court program do not live in Putnam County. I would suggest potentially even the majority of them may be from all over the state. Putnam and Westchester are both part of the federally designated high-intensity drug trafficking area. And in Putnam, unlike many other counties, we actually take on felonies, misdemeanors, and alcohol-related offenses in their drug treatment program, including DWIs, which I think is unique, and it's been largely credited as a success to help give these people positive pathways to recovery, even making our roads safer. But I'm concerned about that decrease, and I'd like to just hear from you, sir, as to how those state dollars flow through the 9th Judicial Court into our local county court drug treatment courts.
Well, it's a very important court. We're fully committed to it. Its operations continuing. I wouldn't be overly concerned about that the budget shows a modest reduced funding. That may be a result of attrition, and maybe a single position will continue to be vacant under our hiring freeze. And if that turns out to be a problem, if that's a critical position in that court's operations, we will move staff around to address that. But I would not be overly concerned about that, the impact on that court. We will make every effort to ensure that it continues to be an effective and productive court. And if you're hearing anything to the contrary, please let me know and we'll address it.
Thank you, Judge. I just want to make sure they get the resources that they need, because the benefits go way beyond just the people in Putnam County, even residents from Connecticut that come by. So I think there definitely is a state obligation to support this type of program. And in Putnam County, we were blessed with a judge named James Reitz for many years, who sadly suffered from a heart attack while he was serving on the bench.
Yes.
The man actually got an Emmy for his promotion of the drug treatment court program, and it's now being managed by Judge Joe Spofford. They do a tremendous job, but I just want to make sure they get the resources and support they need. Thank you, Judge.
Thank you.
Thank you. We go to the Senate now.
Yes. Thank you. We've been joined by Senator Palumbo, Senator Todd Kaminsky, and Senator Palumbo has some questions.
Thank you, Madam Chairwoman. Judge Marks, good to see you again.
Good to see you.
How are you? And I know I had to run down to the floor for a little bit, so I'm sorry if I'm a bit repetitive, but I just have 2 quick questions regarding the certification. Of those 46 judges, I guess it was 39 Supreme and 7 Appellate Division. Were any of those judges removed due to either mental or physical incapacity?
No.
Okay. And is there any sort of a process regarding whether or not that would have been evaluated at all?
Oh, absolutely. That's required under the provision in the Constitution. And under our rules, for a judge to be certificated, they have to undergo an independent medical, physical, and mental examination. We contract with physician firms who conduct those examinations, and that's a critically important part of the process.
Sure. So none of those judges failed that aspect of their recertification?
That's correct. They might not all have completed the exam at the time that the decision was made, but I'm not aware that any judge had failed the independent medical examination.
Terrific. Thank you. And of course, in light of the backlog, they were not removed due to and a smaller caseload. Or I think we can all agree on that issue as well, correct?
No, it was entirely about the extremely difficult budget situation.
It was purely financial, I would say, I guess. Okay.
Correct.
Thank you. And now just to move on to the evictions. There were some administrative orders. Now we have legislatively allowed someone to file a document that says that they've been impacted by COVID or they're having a tough time obtaining additional or other means or other housing. My question, Your Honor, is in the event when this expires on May 1st, if there are additional administrative orders, I had some real concerns in my district where we had multimillionaires from Manhattan living out on the East End of Long Island and refused in residential situations to relinquish their tenancy, indicating just because they didn't feel like going back to New York City. So my question is, in the event that there are any further administrative orders, would you be willing to consider that it's only upon proof of COVID, of being impacted by COVID, that these folks would be able to stay and there would be a moratorium on those evictions?
Well, we did have there were executive orders issued by the governor. There were several administrative orders issued by the court system, signed by me. And then there's been at least 2 pieces of legislation that were enacted. The most recent one in late December, and then the Safe Harbor Act earlier in the year. So we, at this point, I don't anticipate there'll be any further administrative orders. I mean, we're always concerned about the health and risks of large numbers of litigants and members of the public coming into the courthouses during the pandemic. And that's been obviously an evolving background to all of this. But at the moment, there's very detailed legislation on the books. We're complying with it. And at the moment, we see no need for any further administrative orders.
Terrific. Thank you, Your Honor. I appreciate your time.
Thank you.
Thank you, Assembly.
We go to Assemblyman Riley, 3 minutes.
Thank you, Madam Chair. Thank you, Chief Judge Marks. I was actually wanted to ask a question about mental health court here in Staten Island. Currently, for misdemeanor cases, we can't have them referred to mental health treatment court. And I was wondering if you could touch on that, and if there's an ability for us to open up the opportunity. We can for felony cases, but at this time, I think it would be great if we could open that up for misdemeanor cases as well.
That's an interesting question. I'm not aware of that. That on its face doesn't seem to make sense. If felony cases are being referred to mental health court, why not misdemeanors? I will have to take a look at that, and I'll get back to you. But you certainly raise a very interesting question.
Okay, thank you. I really appreciate that, and I yield the rest of my time. Thank you.
Thank you.
Great, thank you. We now go to Assemblywoman McMahon.
Thank you, Madam Chair, and good morning, Judge Marks. How are you?
Good morning.
I just have a couple of questions regarding the certification of the judges over age 70. Did I understand your testimony correctly that the plan is to follow the normal certification process for judges who will be turning 70 this coming year?
And judges who will be up for further recertification. That is our hope. There are too many question marks about the economy, about our budget, about our operational needs, but certainly our hope is, later this year that the judges who are up for certification or recertification will be able to be approved. But I can't predict, and I certainly can't guarantee that. There are too many variables.
I understand. And just one other question. Do you know when the last time assigned counsel rates were adjusted in the state?
I believe it was, I don't know why I remember this, but I believe it was 2003. enacted by the legislature, taking effect in 2004. I could be off a year.
Has OCA had a recent examination of those fees to look at maybe the appropriateness of adjusting them again?
Yeah, they need to be adjusted. It's been many, many years. We have strongly advocated for raising the assigned counsel rates, the assigned counsel fees. The chief judge has been vocal on this. Obviously, at the moment, there are serious fiscal challenges, but there's no question after what I believe 16, 17 years without an increase, it's time for an increase. Very important.
Thank you very much. Appreciate it.
We now go to Assemblyman Walzak. 3 minutes. Thank you.
Your Honor, thanks so much for the time. Wonderful to see you. District attorneys have a staggering backlog of cases in some cases. What is the Office of Court Administration doing to ensure that speedy trial or speedy presentment aren't the reason that these cases are dismissed at the end of all of this?
Well, we've at the moment for pre-indictment felonies, the governor's executive order has suspended the speedy trial statute because that's in recognition of the difficulty of presenting a backlog of unindicted felonies to grand juries. But what we've done is we brought back grand juries over the summer, in July outside New York City, in August inside New York City. And since then, we've continued grand juries. Every county in the state has at least one. Some of the more populous counties have more than one, particularly in New York City. So we're trying to facilitate the easing of the backlogs by providing grant. And it's very impressive, but people are coming in to serve on grand juries. We weren't sure if we would get people to come in and serve, and it's been kind of remarkable that basically in the same very similar numbers to people in pre-pandemic times, people are coming in and serving on grand juries. So they're doing their public service, performing their civic duty. So we also have, particularly in New York City, we've made an effort to designate judges to conference unindicted felony cases to try to resolve them. And actually, we started doing that early in the new year, last month, and there have been thousands of cases that have been resolved without the need to present those cases to the grand jury. So this is going to take a lot of work, but it's a top priority for us, and we'll get through it.
Your Honor, one more. Your weekly address referred to electronic court systems as evolving into a quote unquote better normal. I was just wondering if you could explain to the members of the various committees that are represented what you meant by that, and what health metrics are you following to return to in-person? What can locals look to for those metrics and in anticipation that they will return to some of their normal
By the way,
operations?
the weekly remarks are from Chief Judge DiFiore, not from me. But in terms of virtual proceedings, our view on virtual proceedings, we've tracked this very carefully. We've examined how it's worked. In most instances, it's worked very well, but we're of the opinion that it's not the answer to all proceedings. We don't think that, for example, grand jury proceedings or civil or criminal jury trial proceedings are ideally suited for a virtual presentation. But there are many other, particularly routine proceedings in civil courts, where it's not necessary to drag people into court. That it's good for the lawyers, it's good for their clients, it's good for the court system. It can be more efficient, and it can promote public health and safety. So we're relying heavily on virtual proceedings now, and they will have an important role post-pandemic.
Thanks for the time, Your Honor and Chairwoman.
Thank you.
Thank you. We now go to Assemblyman Ra for 5 minutes, Ranker on Ways and Means.
Thank you, Chair. Thank you, Judge Marks. So I just wanted to go back to, obviously there's been plenty said by my colleagues regarding the recertification of the judges and backlogs and all of that stuff. But just with regard to those, individuals, one of the things that came up when we had a hearing back in the fall was about, the implication of not just not having, the judges to handle the caseload, but the judges' staff. And, having those folks that are there that help process cases, help write opinions, help do all that type of stuff. And I know that, basically by law, judges that are in office are, entitled to have their staff to help them with their caseload. So I'm just wondering what is the status with regard to that in terms of the employee headcount within the agency? Is there lacking of staff for judges, through retirements of that, or are they able to hire people so that they have adequate staffing in each courtroom?
The Supreme Court justices have it's in the judiciary law, they have a statutory entitlement to two personal appointments, a law clerk or a secretary. And in some instances, they don't hire a secretary, they'll hire a junior law clerk, if you will, someone recently out of law school. So the judges who were not certificated, the 46 had staff. We committed to finding positions for that staff. Some of those people decided to separate from service, retire, or find a job elsewhere. But those who wanted to remain in the court system, we have found jobs for, mostly with new judges coming in, particularly new Supreme Court justices coming in. Although they're entitled to hire the people they want, we've got a tremendous amount of cooperation from incoming Supreme Court justices to pick up the staff of the judges who were not certificated. So in terms of those employees, they have all been placed. But generally, our staffing levels elsewhere in the court system, not the personal staff of judges, but court officers, court clerks, court reporters, court interpreters, back office staff, we're down employees. I tried to address that in my opening remarks. And, we have a hard hiring freeze. We're forced to do that to meet the bottom line. We haven't gotten significant increases in our budget over the last decade. They've been, marginal increases. So staffing was down to begin with, and the last year has exacerbated that situation. So, I'm not going to suggest otherwise to you. It's a real challenge for us that we're going to have to figure out.
Okay, and thank you for that. And the other question, just more globally in terms of the budget of the department, there was a comment from the budget director, that they didn't direct the agency necessarily what to do with their budget, but obviously there's a $300 million figure out there of reducing costs. So is that, can you clarify that? Was that coming from the administration and the Department of Budget, or is that an internal measure to come up with that number to cut the budget by?
No, I'm glad you asked that. It's an important question. We in late April, when the governor issued and the budget director issued their revised financial plan for the state, how much revenue the state has, and so on and so forth. In the narrative of the revised budget plan, they urged and assumed that the court system would reduce its spending by 10%. And then they took a second step. They deducted that amount of money, the 10% from our budget. They deducted that from the revised financial plan. So, given that, and given that we always try to act as a responsible partner in state government, we went ahead and proceeded to develop a plan to reduce our spending by 10%. And so that's what we did.
Thank you, Judge Marks. Thank you, chairs.
Thank you.
Thank you. We go to Assemblywoman Burns.
Thank you. Thank you, Madam Chair, and thank you, Chief Administrative Judge Marks. My question is based off of what was just indicated, sir, when you spoke with Assemblymember Ra. You indicated that every judge has right to 2 personal appointees. And my question is, my understanding though, is that that there is also a hiring freeze on law clerks and secretaries to judges. So my understanding is that some judges are potentially going without secretaries and without law clerks because what would normally be their personal appointee positions are currently not fillable. So is it accurate to say that judges do have 2 appointees?
Let me be clear about this. The Supreme Court justices have a legal entitlement to 2 personal appointees. The other judges do not. The practice has been over the years that other judges are entitled to hire 1, and in some cases 2 staff people. And we've been able to support that in the budget for years. This year, Supreme Court justices, because there's a statutory entitlement, they have been able to fill vacancies and hire their 2 people and have 2 people work out of their chambers. With the other judges, we've said who do not have the statutory entitlement for personal appointment or personal appointments, we've said that every judge needs the assistance of an attorney, that a judge cannot do his or her job without the assistance of an attorney. But what we've tried to do is where judges have a vacancy, someone has left and they don't have the assistance of an attorney, not Supreme Court justices, but the other types of judges, we've tried to get them to hire someone from within the court system so that it's not someone off the street, increasing our employment level with the cost that entails. We've tried to work with them and it's been very successful, and the judges deserve credit for this. They understand the fiscal situation, and I would say overwhelmingly when a non-Supreme Court justice
Sir, I apologize. Oh my God, I've never interrupted a judge before, but I only have 30 seconds left. I was the court attorney to an acting Supreme Court judge. Are the acting Supreme Court judges who fulfill in multi-bench rural areas, they can't rely on somebody else to borrow a court attorney or a law clerk from, are they allowed to have the 2 personal appointees? Or even as acting Supreme Court judges, are they locked into whatever they're allowed to have in the hiring freeze? Thank you, sir.
They're not legally entitled to that, but we've said as a policy matter, every judge is entitled at least to the services of an attorney, and I believe we've done that, and there may be a rare exception to this, but we've been able to accommodate every judge in the state to ensure that they have the assistance of an attorney.
Thank you, sir, and my apologies for interrupting you.
No problem at all. Thank you.
Thank you, Judge Marks. So I just have a very brief, more comments, I think, than question. I was very concerned to hear your response to Senator Hoylman about the cuts to civil legal services, the 10% cut, as you know. I worked over the years with Judge Lippman to get us to that 100 million mark, which today, even if things were perfect, would not be enough funding. And with increased problems due to the pandemic, I would assume we've only seen an increase in need. So you had, at the time you did the 10% cut, the executive was withholding 20% from local assistance programs. Since the executive's budget's come out, that has been reduced to just 5% of the local assistance budgets and community budgets. So I was wondering if, in light of the change in the executive's position to just withhold 5%, if you would be rethink the 10% cut and see what can be done to restore those, make sure that those programs get fully funded.
I can commit to you that we will look carefully at that. It might require extending our hiring freeze longer. That's one of the options. We don't have a lot of options, but I promise you we will look at that very carefully.
And a question: have any of the stimulus pandemic fundings from Washington included any of the federal programs included any funds for legal services to assist people in terms of staving off eviction or mortgage foreclosure?
Not that I'm aware of. The funding I'm aware of is for. Are you talking about in the big, what's described as the $1.9 trillion package, or the
yes? Well, both the December, what passed in December, and the proposed. I mean, I should know the answers to the question. I don't, but why don't we both examine whether there's any potential for legal services funding to assist people who impacted by COVID-19?
No, we should do that. I agree.
Thank you, Judge. Back to the Senate.
Thank you. Judge, I also don't have any questions today. I want to thank you for your time with us and reemphasize, I think, my Senate colleagues' agreement with the Assembly. We can't afford to cut legal services at this time. I'm not saying we can afford to cut anything else in our court system, but I think you have explained fairly clearly that for the problems you're seeing, you feel like you have your arms around the criminal justice side of the court system. Arraignments have continued, courts have continued. There's been actually a decrease in the number of arrests coming into the courts. But we've also talked about, at some point, these moratoriums on evictions and foreclosures and debt and utilities are all going to come due. And I think it's going to be an explosion throughout the court system to try to figure out how you deal with a volume you've probably never seen before. So I don't want to ask you how you're going to deal with that volume. I'm going to say to you, you need every tool in your arsenal probably to be increased, certainly not decreased, to try to get through that tsunami when it happens. So again, I would urge you, explore how you have the resources, how you have your specialized courts, have your specialized courtrooms within your specialized courts, if it's New York City, so that you're up and ready for more foreclosures when those start to happen. You're up and ready for the residential evictions, which we hope won't happen, the commercial evictions, which we also hope won't happen, but we know it's all there, it's all building up. With that, we want to thank you very much for your time, and we want to excuse you. Not that anybody's done with the courts, but we're done with you here today with us, so thank you very much for your time. And I'm going to call up our next testifier, who is Robert Tembekjian of the New York State Commission on Judicial Conduct. And for people who track these things, this is also under the rubric of the Judiciary Committee, with Senator Hoylman and Senator Levine having 10 minutes, other relevant chairs and rankers having 5 minutes. So Robert, are you with us? I think you're there, but you're muted. Take your mute button. Ah, there we go.
Gotcha. Okay.
Great.
Thank
So good
you.
morning or afternoon. I'm not sure. Oh, it's still morning.
Still morning.
Still morning.
Which is a rarity, but thank you very much. I look forward to seeing many of you in person when we're allowed to do that again, and particularly the new Assembly Judiciary Chair, Mr. Levine. I look forward to working with you as I have in the past with Assemblywoman Weinstein and Dinowitz, your predecessors in that role. As you know, the Commission on Judicial Conduct is the state agency created in the Constitution, independent of the court system, to investigate and, where appropriate, to discipline judges throughout the New York State Unified Court System for misconduct, ethical misconduct as promulgated in the rules on judicial conduct. Like all of government and society, 2020 presented some very unique challenges for us. We are a small agency and we're able to adapt rather well to the challenges presented to us by the coronavirus pandemic. On a budget of $6 million a year, we are responsible for overseeing the ethics enforcement on nearly 3,500 judges throughout the unified court system. And somehow, under the unique circumstances presented to us this year, we managed to shift our operations in early March from in-person to remote and almost entirely virtual. We instituted video platforms so that we have been taking depositions and conducting hearings, as well as interviews remotely by video. We have been communicating through email and through electronic use of faxes and the postal system, and where necessary, private carriers. And our 11 commission members, who, as you know, are appointed by various appointing authorities, some by the governor, some by the chief judge, and some by the leaders of the state legislature, have been conducting all of our business remotely. And the result was that in 2020, we publicly disciplined 24 judges throughout New York State, which is a greater number than in any year over the past decade. And we were able to do it by essentially going into overdrive as we adapted to the challenges of switching from in-person to video. And although I vigorously agree with those who have presented the view that in-person proceedings, particularly our due process and depositional proceedings, are invaluable and really irreplaceable. Under the unique circumstances presented to us this year, we were able to manage. And I suspect that when we do return to whatever the new normal will be, that while we expect to return to in-office, in-person operations to a great extent, we will probably benefit from having pioneered this year the uses of technology for remote proceedings, so that where necessary, witnesses who are in remote parts of the state or even in other states who are physically challenged, who may be suffering from some infirmity that makes it difficult for them to reach one of our offices, will be able to communicate with them as you and I are communicating now by video. With all of that said, this year, rather uniquely, I am not asking for more money than the governor's executive budget is proposing, which is the same dollar amount that we had last year. As you know, we've been challenged for a number of years by the decision in the executive budget to keep the commission's appropriation flat. And 4 times in the last 10 years, the legislature has increased our appropriation, recognizing that the work we do is essential. It is a constitutional responsibility and obligation. And to make up for the fact that our staff has decreased over the last decade from 51 full-time employees to 39, while our caseload has increased, you have come through time and again to supplement what the executive has recommended. Because of the special challenges and strains and stresses on the state's finances this year because of the coronavirus pandemic, we submit a budget to you that asks for the same dollar amount as we had last year. And in discussing it with the governor's representatives, I'm happy to say that they agreed that that would be appropriate for us, with a commitment to the greatest extent possible for us not to spend all of the money that is appropriated to us. And as some of you know, because I've sought your help in between these annual events, we sometimes disagree with the Division of Budget on how our appropriations should be spent or allocated during the year. They have sometimes taken the position that they can implement a cash ceiling on our budget, as they do with executive agencies that report to the governor. But because we do not report to the governor, because we are constitutionally independent, our position has always been what the legislature appropriates is what we spend responsibly, keeping it under the full figure to do our part, particularly in stressful times such as these. And I'm pleased to be able to say this year, at least, that the executive and the commission are on the same page. And I certainly hope that the legislature would agree. Not that I would object if you somehow manage to find additional funding to provide for us this year so that we can continue the regeneration of our staff, which you supported and found the funding for in previous years. But given the state of affairs that we all find ourselves in, we are committed to making do with, again, a flat budget, and having demonstrated our adaptability in this electronic age to the benefits of IT, we think we can manage to do it. I certainly hope to stem the tide of departing staff who we cannot replace, which typically is the way we save money over the years. Our expenses go up, our responsibilities increase as our caseload increases, and the only real place that we can find any savings is in not replacing or in deferring the replacement of staff that depart. It slows us down, but we do the best we can. That said, I'm happy to respond to any questions that you might have, either on our performance this year, on the funding that we're requesting, or what we project for the coming year.
Thank you. Thank you very much. I don't see hands, but I'm just going to double check. Does our chair of Assembly Judiciary or Senate Judiciary have any questions?
Yes, I do.
Thank you.
Go forward, Chuck.
All right, thanks.
Ms.
Thanks,
Levine.
Mr. Tembeckjian, good to see you again, and I look forward to working with you. I want you to know that I spent 5 years as co-chair of the New York State Legislative Ethics Commission, and I also had so much fun in the 5 years that I served as chair of the Assembly Ethics Committee. So I have some special sense of understanding about what you do and how critically important it is. So let me ask you a couple of questions, not so much dealing with the budgetary issue itself, although I hear what you're saying about your budget. But a couple more granular questions. So there are 11 commission members.
Yes.
Correct?
Yes, correct.
Do you need a majority of those commission members to be able to institute an investigation?
No, there are certain quorum requirements to impose discipline. We need the participation of 8 and the concurrence of 6, no matter how many are in the room. To authorize an investigation, we need the concurrence of a majority of those who are present for the meeting and the vote. But I would say that unlike other entities where the staff has the opportunity to screen complaints, although we analyze and summarize all of the complaints that we receive, and last year that was 1,500, down a little bit from the previous years, but with the courts having been closed for much of the year, it's obvious why that number was down a little bit. But every commission member sees every complaint that we get, even if it's not against the judge, even if it's a non-jurisdictional complaint against a police officer, a lawyer. Every one of our commission members sees every one of the complaints that we get, and they all vote on them. They have the opportunity to hold for full discussion if they wish, but there is an opportunity for each of them to see every complaint, and they all vote on them. So it's fair to say that in my entire tenure, which is over 40 years at this, every investigation has had at least a majority of members voting, whether or not they were all in the room at the time. 6 out of the 11 have authorized everything we do.
Very good. And how are investigations initiated? Must they come through complaints, or do you have the inherent authority or innate authority to be able to investigate on your own, even absent a complaint?
The statute under which we operate, Article 2A of the Judiciary Law, provides for both. We can investigate complaints that we receive, written complaints from anyone, or the commission has the authority in statute to initiate an investigation on its own motion. And in fact, we do that on any number of occasions during the year based on information that comes to our attention, not through a complainant, but through a newspaper article, through interviews or information that we come across while we are conducting ongoing investigations, sometimes anonymous complaints, where the individual, for whatever reason, is concerned about revealing himself or herself. If there is sufficiently detailed information in an anonymous complaint, we will take that as an opportunity to initiate the investigation on our own motion. But then again, that must be by a majority of the 11 commission members. I don't have the authority to do that on my own.
And with respect to the non-jurisdictional complaints, that would be, for example, complaints against law enforcement officers or complaints against lawyers.
Yes.
What does the commission do with those complaints?
We have statutory authority to refer them to appropriate entities or authorities, but we don't refer them automatically. We will review each one of them to determine whether or not there appears to be some merit to the complaint, at which point we will give it the imprimatur of the commission and refer it. We do not refer frivolous complaints. As you might imagine, we do get some of those every year, and rather than burden some other entity and create a false hope to the complainant that someone else may be acting on their frivolous complaint, we will, by majority vote of the commission, decide not to do that. But we in writing explain to every complainant the reasons for our action, including to those complaints that we choose not to refer, by indicating that it didn't really involve misconduct against the judge and there didn't seem to be a legitimate basis for us to refer it elsewhere, but they certainly could if they wished.
And you mentioned you now have 39 employees. You're down from 51 not too terribly long ago. Is that 39 employees total? Does that include lawyers, investigators, plus clerical staff?
Yes, that's everything. That's our entire staff is 39 full-time employees, and we have 2 part-time staff who are retirees that we asked to, if they could manage to give us 2 days a week to help us through some of the difficulties created by our staff having been reduced essentially by 24% over a decade, which is a pretty big hit. And it's why in previous years, I've asked the legislature to supplement the budget request that the executive has put in for us. As you know, because we're not an executive agency, and because there would be a tremendous conflict for the court system to control our budget is submitted to the legislature in the executive budget. But unlike the typical agency head, if I disagree with the executive recommendation, I can come and tell you that and my reasons for it without fear of having no job when I get back to the office.
Mr. Tim Bekchen, it's been a pleasure speaking with you. I'm looking forward to working with you, and thank you. And please thank the members of the commission as well for working so hard to guarantee, well, I should say, work toward would be the better way to say it, the integrity of our judiciary system. Thanks so much.
Thank you.
I yield whatever time I have left.
Thank you.
Thank you. On behalf of myself, the Senate, I also want to thank you for the work of your commission. I'm not an attorney, but I've been here in the legislature now. This is my 19th year. And it's so obvious to me that democracies cannot stand if people lose faith in their judicial system. You have mistakes that happen up here with the legislatures and with local governments and with individual situations. And most of the time you figure it out without attempted coups on the US Capitol, most of the time. But if people don't believe that they're going to get, quote unquote, a fair shake from judges in our court system, then almost anything we try to do here or pass laws that make sense, cannot work. So you know that I have been a fan of your office and have tried to ensure that we do get you some more funding and get the money released to you. My question, because that's another issue that I don't think we ever get to in the state. I just said, I'm not a lawyer. I am astounded we have judges who are not lawyers. Is that a higher percentage of complaints that you see, a disproportionate number of complaints that come from courts where the actual judges have no law school training?
Certainly the percentage of public disciplines that we have imposed over the years has been higher for the town and village courts than the full-time courts. And within the town and village courts, which are the only ones that can be presided over by a non-lawyer, the vast majority of those disciplines have involved individuals who are not lawyers. They make up about 60% of the overall judiciary, but they constitute 70% of our disciplines overall. That's about 890 public disciplines over the last 40 years. It's not to say that there is misconduct that a non-lawyer judge can commit that a lawyer judge can't commit, but the numbers certainly do bear out your impression, Senator Krueger, that the majority of disciplines involves the part-time town and village courts, the large majority of those comprised of individuals who are not attorneys.
Well, thank you for confirming what I feared was the storyline. So to be more controversial, because a lot of people in the legislature don't or haven't been thrilled with the idea of a parallel type of commission for district attorneys, although we did pass one get it into law, then it flew up in our faces with a court case. Do you think that a commission like yours can work for overseeing and ensuring the legitimacy of the decisions made by DAs around the state? Is there a reason we should look at you as a model for them? Because if we're going to do something, apparently we have to go back to square one.
Well, I do think that the commission is a model for ethics reform at all levels of state government, and as you and I have discussed individually, the Judicial Conduct Commission is the model for a very interesting and I think meritorious constitutional amendment for redesigning JCOPE and applying our model to the executive and legislative branches. Whether or not individually identifying one category of public officials, such as district attorneys, makes sense is, I think it's a legislative issue, and it's as much a political question as it is an ethics question. If the legislature were to decide that such an entity would be appropriate, as you did previously by legislation, I would recommend that the approach be via constitutional amendment, as you've already considered for the executive and the legislative branches. There is mechanism within the existing grievance committees, which are supervised by the appellate divisions, to discipline attorneys, including district attorneys. But having decided as a public policy matter that it was a good thing, I would recommend us as the constitutional model as opposed to the legislative model.
Okay, that will take me another 18 years, but thank you for that. I have a series of constitutional amendments that unfortunately don't seem to be going any place too fast, but I appreciate that. Assembly, do you have any other questions? So we have one more senator who does.
We do not have anyone.
All right, then I'm going to call on our Judiciary Chair, Brad Foilman, who just rejoined us from another event.
Hi, nice to see you again. I'm glad we were able to successfully fight for your funding that you requested, and I appreciate how it's been utilized since then. Are there any trend lines that you see in the cases you've been handling that require any legislative action on our part?
I don't think so. I'm happy to say that the incidents of inappropriate demeanor appear to be diminishing, which suggests to me that judges over time have become more sensitive to even the appearance of probity while on the bench. I also think that after 40 years of vigorous enforcement by the commission, there has been a salutary effect on the judiciary overall. We are invited now annually to make presentations to newly appointed and newly elected judges. Various judicial associations invite us to give annual presentations to their events. And I think that overall, we're seeing that there is a greater appreciation and sensitivity by the judiciary to its ethical obligations. And I certainly wouldn't want to suggest that because we had 24 public disciplines this year, that we are overseeing a judiciary run amok. Quite the contrary. Our experience is that the vast majority of complaints that we receive are not substantiated, that the judiciary is comprised, generally speaking, of individuals who are highly capable, competent, dedicated, and increasingly sensitive to their ethical obligations. So I don't think So there is a bill that Assemblyman Steck has introduced, which he has periodically, about mandating punishment for those judges who are exceedingly tardy in deciding pending matters. But we have demonstrated there is a rule, existing rule, that requires judges to dispose of the business of the courts efficiently as well as fairly. And we have disciplined judges publicly for delays in failing to decide cases on a timely basis. And that's the only legislative issue that I'm aware of at the moment that would directly impact upon us.
Thank you. With the additional 300,000 that we were able to secure for the commission, how many additional cases have you been able to resolve due to that funding?
Well, our pending cases at year end actually declined by 23%. We went from 231 pending 2 years ago to 177 now. Part of that is because even with a diminishing staff, we had fewer incoming complaints this year, so that we were able to devote our existing resources a little more effectively toward pending matters. But there's no question that the 300,000 from 2 years ago really was a major boost to us, and it permitted, among other things, for us to be positioned to have the physical resources, the computers, the IT network, and so forth, that enabled us to adapt to an all remote and electronic model in March, once the coronavirus pandemic really
Has it resulted in additional staff? Would you say that it's improved the quality of investigations and hearings?
We certainly have been able to conduct more thorough investigations. The overall impact on staff, however, has not been realized. We're still at our lowest staffing point in 15 years. We dropped from 51 to 39 full-time employees, and as I mentioned to Chairman Levine, I was able, fortunately, to persuade two of our retirees to give us 2 days a week so that we can have the benefit of their experience and participation in our matters. But we are still terribly understaffed. Had our budget maintained the standard 2% annual growth over the last 10, 15 years, our budget today would be 6.7 million, but it's 6 million, almost even, 6,029,000.
So I just to be clear, the additional money that we secured has gone into equipment and other types of support, but not
yes, mandated financial obligations that increase every year. Raises for the existing staff that we still have, the increased cost of doing business, increased rent, and so forth. That 300,000, as you recall, was intended as the first of a 2-year bump to get us our staffing levels back up as well. But when the coronavirus hit last year, we were forced to live with the flat $6 million recommendation, which we're proposing to do again this year. But the consequences of living on the same dollar amount year after year is essentially regressive financing, because our costs go up, and in order to meet those rising costs with the same dollar amount, we have to cut something. And although we did have 41 staff, full-time staff, at the start of the last fiscal year, the two who departed for other jobs, we did not replace because we just were too tight financially. That would not have been the case if if the second year of your 2-year program had gone into effect. We'd have more staff now than we do.
And will you be able to hire more staff moving forward, or are you still in a triage mode?
No, not this year, not with another year of flat budgeting. It is my hope that if any one of our 39 existing full-time employees leaves, that we'll be able to replace them. But we won't really be able to tell until we see the overall effect of this flat budget for yet another year as we progress. I'm hoping that we stay at 39. We do not anticipate increasing unless you somehow miraculously find some extra money to give us. And as I said just before you rejoined, although we're asking out of a sense of civic responsibility and duty for the same dollar amount this year as last year, I certainly wouldn't object if you managed to find some more for us.
Thank you. Thank you, Madam Chair.
Thank you.
Thank you. Any other assembly members slide on, Helene?
No, we didn't have no members.
All right, then I want to thank you very much for being with us today.
Thank you, as always.
You to continue to work, and I want to call up William Leahy, New York State Office of Indigent Legal Services, and remind legislators that for this guest, Jamal Bailey and Jeff Dinowitz are the two chairs of committees for the first opportunities to question after testimony. Good afternoon.
Good afternoon, Chair. How are you?
I am fine. I am fine. How are you doing?
I'm doing well, and thank you for the invitation and the advantageous placement.
Well, we're just streaming through this hearing. Okay, that's a lie. It is 12:30, and you were number 3 of, I think, 31 today.
Well, I want to speak to you, if I may, and your co-chair and the chairs of the relevant committees, of course, and the other members. Essentially, it's a tale of two constitutional responsibilities, and there's one tremendous success story for which we thank everyone far and wide, and then there's one of seriously unconstitutional stature and crying out for attention. So, of course, I speak of the public criminal defense reforms that go back to the Kay Commission and the creation of my office in 2010 and the settlement of the Hurrell Herring lawsuit and then the enactment of Executive Law 832-4 in 2017 to extend the benefits of that settlement to the entire state. That is going very, very well. And it's going well because it is supported at all levels of government and throughout the legal community. The governor has lived up to his commitment, including in the executive budget that you're reviewing now. We support that request. That's the 4th year of the planned 5-year journey accounted for in the state's long-range fiscal plan. To put the state for the very first time in a state of constitutional compliance with respect to its Gideon obligation. And that, of course, that's shorthand for its 6th Amendment responsibility to provide the effective assistance of counsel. That's going well, I think, because our office is functioning well. We, even in a year in which we've had to shift from a lot of in-person meetings to a lot of remote meetings, we are continuing to work very effectively with each and every county in New York City. We have the support of a tremendous board, which supports us every step of the way. We've had support from the governor, the legislature, the 140 or 50 so providers of mandated representation all throughout the state. All the counties, the state bar, NYSAC, the Chief Defenders Association, the State Defenders Association. All of these entities are vital partners, and it's going very well. And I'll just cite you quickly to the bullets that we put in on page 3 of our written testimony. And we selected 4 of the many reports we have filed over the years in footnotes 2 and footnote 3 with respect to the 5 counties under the lawsuit settlement, which is still extant, And we still meet every other month with the parties, the Governor's Council and the Plaintiffs' Council in the Harrell Haring lawsuit, and in the statewide effort where we are, as I say, entering year 4 of the 5 years to get us to a state of constitutional compliance. There are a few things that we need in order to sustain that progress. We are, as everyone is under the state hiring freeze, we need specifically right now our 2 data officers that we've been waiting on since last March. We need NYSDA to be funded because NYSDA provides the training and the computer backup, the data backup, and the advice and support for lawyers. And I know that Susan Bryant will be speaking much later to you, and we support her testimony. And we also need, with respect to the Article 7 issue about the so-called virtual arraignment bill, we need no backing down from the requirement of in-person representation at arraignment, which is a core component of the Harrell Haring settlement and a core component of Executive Law 832-4. Now that's the good side of the ledger. I want to hold up for you, see if I can, I think it can be seen. The Chief Judge's Commission on Parental Legal Representation report in 2019 set out a blueprint for parental representation reform in New York. And parental representation is every bit as required under the state law and the state constitution as criminal defense representation is. It simply has not to date accumulated sufficient political and fiscal support. We are doing, and I cite you to Appendix B at the end of our written testimony, we're doing a lot. We have already acted on the Commission's recommendation to extend the eligibility for counsel standards to family court. That was approved by our board in December. We're finalizing the actual document. It'll probably be out within a week or so. We are taking to our board at the April meeting, in compliance with the Commission's recommendation, caseload standards. Now, those will have to be subject to state funding, of course, because when you reduce caseloads and you provide lawyers with appropriate caseloads, it's a significant fiscal lift. And so those caseload standards, we will ask them not to be self-executing, but to be contingent on available state funding. In terms of what you asked for at a time of crisis, I guess I want to say that you can't waste a crisis, and nor can the state wait any longer to fix the unconstitutional state of affairs with respect to parental representation. We have to get started, and we have to get started now. And of course, our request, our ask, if you will, is for the $5 million in aid to localities. We spoke with you all about it last year. And it's certainly a high agency priority. It is our fundamental priority this year. But we also asked you, outside the budget and as the legislative session goes along, to take a very serious look at the Parental Commission's recommendations. It's not rocket science. Control caseloads, provide appropriate state funding, provide appropriate state guidance and infrastructure. Do exactly what we are doing on the criminal defense side. We know how to do it. We have done it. We are doing it. And so let's get started. That's my plea on parental representation. And let's not wait any longer. So that's my opening statement, and I'm happy and eager, in fact, to have a conversation and answer questions.
Senator Brad Hoylman, chair of, oh, you know what? Wrong. Excuse me, Senator Hoylman. It's actually Senator Jamal Bailey as the chair of Codes.
Thank you, Madam Chair. And Director Leahy, Bill, good to see you today.
Good to see you.
As you often do with this testimony, and your testimony generally answers questions that I was going to ask, right? You always do a good job of that every year. But I guess I just wanted to double down and also share my agreement with you about the Article 7 as related to the arraignments and how it would negatively affect the work that you've been trying to do as related to the Harrell Herring settlement? And I just wanted to give you an opportunity to expound upon that if you wanted to.
Sure, you all could, you have my video, so you can see I'm a man of a certain age today. But way back in the day, you know, I was a public defender in the trenches in and around Boston. And I can tell you, there is no more meaningful stage of a criminal proceeding than the arraignment, when the public defender, who no client has ever chosen, goes into the dock, talks to a complete stranger, is a complete stranger, and goes out to appear before a judge to plead for that client's release. And so, you know, virtual appearances in the cause of court efficiency are a wonderful thing for unnecessary, unessential appearances. They should have no application to the arraignment. The work of a public defender, the work to build the trust of the client, the work to begin the process of having confidential communication really be meaningful communication, it starts there. It can't be done remotely. It has to be done in person to person. That's from personal experience. And I'm very gratified during Judge Mark's testimony, the number of members, you know, assembly people and senators who spoke to that. And it's embedded in the settlement and in the law. So we'd be rolling back at a time when we're talking about greater protection for minority defendants and people in minority communities and poor people, to tear away the ability to have a personal connection with your lawyer at arraignment. It's unthinkable. And there's nothing wrong, you know, with extending the 25 counties to the whole state. Just take arraignments out of it. Take arraignments out of it. And I commend to all of you the written testimony and the future oral testimony of Susan Bryant and Laurette Mulvey, representing NYSDA and the chief defenders. They'll be up much later and they'll be speaking to this. I've read their statements and they're excellent. Also, we have a statement. I think we've sent it to you already, Senator, but I'll share it with all of the members back on December 2nd, our notification about virtual arraignments, because we've been hearing the drumbeat for a while. Gee, it's so convenient. It's so easy. It works so well for everybody. It doesn't work for due process. It doesn't work for effectuating the right to counsel. It cannot happen with respect to arraignments.
And again, thank you for that. And again, I echo those same sentiments. You were speaking about, I guess, the rates for assigned counsel. And I know that we are in a fiscal crisis like we've never seen before as a result of this pandemic that we've never seen before. But I just wanted you to touch on the importance of the increase of the rates, despite us not having, you know, we may not have the fiscal wherewithal to do it right now.
Yeah, you know, it's interesting. Judge Marks mentioned 2003, 2004. The very same year, 2004, back in Massachusetts, my agency sued the state because counsel rates hadn't been raised in about 20 years. And we won a constitutional decision. I was lead counsel on the case. I've shared that with some of the people here. So last year, we worked with the association that was seeking the increased rates, and we were pairing it. It is one of the 6 recommendations of the Commission on Parental Legal Representation. And as Judge Mark said, the chief judge has been out front about this because sooner or later, lawyers just aren't going to be coming into court at these rates because they're not going to be able to make even a minimal living on it. So absolutely, there's a reason why it's in there as one of the 6 recommendations of the Commission on Parental Legal Representation, and it's something that is a component of a constitutional as opposed to an unconstitutional system of providing mandated representation.
Certainly, and I guess the final question or the statement I would have about parental representation, and we've spoken about this at length with you as well as my former dean Angela Burton. Now, I guess the question is like, yes, this is obviously, especially in times like these when people that can ill afford to not who cannot afford to have inadequate representation, however artful that sounded, as I stated, we need to make sure that there's some sort of oversight. And I look forward to working with you so that we can have these, so we can do something like along the lines of what you've said. If we have statewide representation, defense-wise, we should be having it on a parental level. And if you can, I guess, expound upon that as my final question statement.
Absolutely. And the issues, are exactly identical. I made reference earlier to how the criminal justice system has its largest impact on poor and minority communities. It is certainly exactly the same reality with respect to the child welfare system. And so it's really, not simply a matter of constitutional law or non-compliance with statutory law. It's just plain socially destructive not to have effective representation in that arena where families are torn apart and decisions are made about whether the parent and the child stay together. The thing it takes, and what we've learned from the criminal defense reforms, yes, it takes a lot of money, it's true, but it takes more. It takes two more things. It takes a expertise and guidance from a state entity so that you don't have, like, let's say a wealthy county which provides good representation and poorer counties that do not. And the second thing it needs is the spirit of collaboration and cooperation, which I like to think has been a hallmark of our agency, and certainly should be under, whether it would be ILS or whether it would be a new state agency. I know the commission presented both alternatives. That would be a legislative decision and a gubernatorial decision. But we certainly have a very strong interest in parental representation, as I think our actions have shown, and we'd love the opportunity to engage in discussions both pre-budget and post-budget with the legislature about how to get that fixed.
Yeah, I would certainly agree with you that we need.
And I'm not ignoring the executive here. I talk to the executive all the time, and they know, they know how we feel about that as well.
Sure, and I would certainly echo the sentiments that we need some sort of uniformity in ensuring that everyone from downstate to upstate and everywhere in between has adequate representation, especially at a critical age, especially when we are seeing on the news the younger people being criminalized, the younger people, and it's important to ensure that that there is representation, and not just representation. There are ways for diversion at that age. So I will yield the rest of my time, Director Leahy, and again, as always, I thank you for your work and for your testimony.
Thank you, Senator.
Thank you. Assembly.
We go to our codes chair, Assemblyman Diddle.
Good not morning. Good afternoon. How are you?
Good afternoon, Chair.
So I'm glad the issue of virtual arraignments was raised. I have concerns. A number of my colleagues have concerns as well. And I think it's good that we can do some things virtually, save time, save travel, save money, but we do have a tremendous concern on that issue. And I think as we get more and more used to doing things like we are today, it becomes easier to do other things the same way virtually. And I'm afraid ultimately that is going to infringe upon the rights of a lot of people. So it's really a big concern, and I think we have to address it. I think we have to look at that in terms of the proposal by the governor on virtual arraignments. But I wanted to ask you about immigration proceedings. There's a huge need for representation for immigration proceedings, especially when we're dealing with possible deportation. Can you describe how your office has been involved in establishing and improving representation in immigration-related proceedings for persons who are unable to afford counsel, which I imagine is a very significant percentage of the people involved in such proceedings?
Yes, of course. For starters, at the moment there is not a mandated statutory or constitutional right to representation in these hearings. I know New York has done a lot to provide representation through grants administered, I think, through the Department of State. But what our role in that is we are very proud that under our office and with the support of the legislature, we have got the first. New York is the first state, I believe, still the only state that has a statewide network of regional immigration assistance centers. And what those centers do under grants that we administer is they ensure that every lawyer representing every client in the state, publicly funded lawyer in the state of New York, is providing proper advice with respect to the immigration consequences of criminal and family court proceedings. We've just entered into our second 3-year set of contracts. We've got 6 offices all around the state. They have a network. They work with one another on listservs. And so while we don't provide or don't fund direct representation, we do fund support that makes sure that lawyers aren't inadvertently making mistakes that disserve their client's interest with respect to immigration consequences. If I could go back to your first reference to virtual arraignments also, Chair, there's, because it reminded me that there is a measure that really should be undertaken, and that is the existing statute that provides for centralized arraignments. One of the big problems in upstate New York, as we all know, is that the distance, the sheer number of courts and the distance, the physical distance between courts, and a number of counties under the legislation that was put into place about 4 or 5 years ago, that OCA, with the support of the counties, with the support of my office, have been creating these centralized arraignments. And you heard Judge Marks talk about, no one should wait more than 24 hours. Well, the way these courts are operating, no one waits more than 12 hours because they have a morning session and an evening session. I think there are about 15 to 20 counties now that are already have these courts up and running. There would have been more, but for the pandemic, a lot of plans got waylaid and delayed. So that's really the way to go in terms of the future of arraignments in the state of New York. They shouldn't be all over 12 or 1,300 village courts all over, in every highway and byway. They should be in these centralized arraignment settings, and they should be in person with in-person representation. That's the ultimate solution.
Okay. As a result of the pandemic, I believe there must be a huge backlog everywhere on everything. Could you just give your feeling on how we can sort of dig out from all of that and how long it might take?
Well, we stayed true and I have to repeat my credit to the executive and to the governor for staying true in this budget. We stayed true to the long-term goal, because should this funding continue to flow as it has continued to flow, we know that we will be able to assist the providers and the counties in weathering all the storms. And you're right, there is going to be a backflow of, particularly in the upstate, the town and village courts. A lot of them closed down for a very long time. Some of them still, some of them reopening and then reclosing again. And the discovery, not much attention has been paid today to the impact on the defense of the discovery. The district attorney has the responsibility to assemble the data. It's voluminous, videos, video cams and everything. But then the defense gets it and they have to analyze it all. So a tremendous additional burden, both in technology and in attorney and staff time. And as long as we stay true to the reforms that have been already put into statute and have already been funded consistently year to year, including during this pandemic, we will stay on course and we will be able to continue to make the public defense system in New York something to be proud of instead of something to be embarrassed about as it was for so long.
Okay, thank you very much. That's all I have.
Thank you.
Thank you. Any other members have
No assembly.
All right. Then we're going to thank Mr. Leahy for being here with us today. And we are going to move along to Patrick Murphy, New York State Division of Homeland Security and Emergency Services. And the two lead questioners will be Senator Brooks and Assemblymember Zabrowski. Good afternoon.
Good afternoon. So jump right in.
Please.
Everyone.
Yes, please.
All right. So a really brief opening comments here on the front side. But first of all, good afternoon to everyone. Thanks, Chairwoman Kruger, Chairwoman Weinstein, and to the distinguished members of the Joint Committee. I'm Pat Murphy, Commissioner of Homeland Security and Emergency Services. I'm proud to share what the agency has been working on and will provide an overview of the executive budget as it relates to this work that's been done. The staff at the Division of Homeland Security and Emergency Services have worked tirelessly over the past year to not only fulfill our day-to-day responsibilities, but also assist the state's COVID-19 response and recovery efforts. The executive budget provides the resources the division needs to accomplish our mission and enhance public safety, including the addition of COVID-related operations. The total agency appropriation in the executive budget is $4.97 billion, which includes a $3.4 billion increase from last year. This increase reflects additional appropriation authority to allow the division to administer federal aid to state agencies, local and county governments, and eligible nonprofit organizations. This federal aid is available as a result of the governor's March 2020 request for the first ever major disaster declaration for a public health emergency, which was promptly granted by the federal government. This declaration allows for the construction of alternate care facilities, including the Javits Medical Center, and provides reimbursement for many of the state's response operations, including COVID testing and vaccination sites. The division partnered closely with the Division of Budget and continues to work with the federal partners to ensure New York receives reimbursement for all the eligible activities. Throughout the governor's response to the pandemic, the division has helped coordinate efforts to address numerous challenges presented by the public health crisis. The State Emergency Operations Center has been activated since last February. This support to support the state's response and recovery efforts. The division staff supported the state's COVID testing and mass vaccination sites, serves in leadership, safety, and logistics roles. Additionally, division staff work with our partners in the National Guard and have undertaken the task of procuring, assembling test kits, which in turn have been distributed to state test sites, local governments, and school districts. The division also works with the National Guard to receive logistics oversee the logistics in receipt, storage, and distribution of personal protective equipment and other resources needed to combat the pandemic. Furthermore, the division staff assisted other agencies to perform critical response functions, including the New York State Department of Labor Unemployment Insurance Mission, the Department of Health's call center mission, and most recently, the vaccine hotline. I'm proud of the service and would like to note that over 90% of the division staff were directly engaged in COVID missions. The division's Office of Fire Prevention and Control were integral to the state's COVID response efforts. Office of Fire Prevention Control staff have served at field hospitals, state testing and vaccination sites, as well as the State Liquor Authority's safety mission and the Department of Health's pilot project for the Bills, opening the Bills game to spectators. Office of Fire Prevention and Control ensured the state's new efforts were not only efficient, but also safe for all involved. While COVID has been the main focus of the division over this past year, we continue to execute our core missions as discussed in our more thorough submitted testimony. It is not possible to cover all the great work the division has done during my testimony. But I appreciate the opportunity to appear before you today to further discuss the agency's efforts to maintain daily operations while serving the state's COVID-19 response. I look forward to the continued partnership with you and others, and hope to answer any of your questions you have. And I do appreciate being with you today.
Thank you very much. And you did it in 5 minutes, so you get extra points from us today also. Thank you very much, Commissioner.
All right, thank you.
The first questioner, I believe, will be Senator John Brooks. Are you here, John? So that will not be.
I'm asking him to
No, we
unmute.
were having some trouble getting the video's not on, but we're done.
Oh,
thank you, Chairman.
Very good.
And good afternoon, Commissioner. You've had a nice quiet. Not much to do. I tell you, I got a couple of questions. Some of the questions from a Homeland Security issue, I'm going to save for our briefing when we do that, so that we can get a little more deeper discussion. Obviously, this past year, I mean, every playing field you're on, something was happening. And I think you did a great job. But I'm curious to understand, how much assistance did you get, or how much interference did you get from the federal government as the pandemic was beginning to take shape? And to my understanding, in the past, the management of PPP and PPE rather, and other things had always been done more through the federal government. So the fact that suddenly you had to secure all of this equipment, how much assistance did you get from the federal government? How much direction did you get from the federal government?
All right, so I think to begin with, FEMA and the pieces of the federal government that we've worked with, Health and Human Services, along with the CDC, have been pretty good partners for us at our level in terms of providing additional guidance where needed, and then also some resourcing that was limited on the front side. I think because New York was kind of at the epicenter on the beginning of the pandemic, we received additional resources that other states may not have. We pressed hard to get resources that became very limited quickly, and then transitioned fairly fast over to procuring what we could because of the intensity of the infections and the rise in infections that we had over time. So we did not have all the resources that we really wanted in the early days of this, back in February and March, April of last year, but quickly found ways to start to increase those supplies. But by no means were we able to provide our partners at the county levels and municipality level the resources that they would have liked to had from the front. But now we're in much better shape today.
Okay, that is good to hear, and certainly as additional vaccines come into play, that's an assist too. But of course, we are seeing the virus move in a number of directions, so there's a lot there. You know, as in last year, we had a presidential campaign where there was a great deal of concern on what was happening in the internet and cyber-related issues. Can you give us your impression of where we are right now as a state? How secure are we? And did you see any activity on the internet that was directed towards our state?
So if you're asking specifically towards the election, sir, or ransomware that's being initiated across a larger audience, was it specifically to the election?
The election, and as we led up to the events in January that the Congress is meeting on now, how aware were you of activity that involved citizens of this state?
Okay, so to the extent of knowing individuals or others that would have caused harm or damage to our systems or to other infrastructure, not specific to the individuals. The more overall perspective on where we were with elections and election security, there was a full out state effort, multiple agencies aligned with the Board of Elections and ITS. Our team, our cyber team, involved in that as well, monitoring systems. And from our perspective, at no time was the state in jeopardy from having a fair and full election. The activities that followed that later, even in DC, the law enforcement agencies that we work with, that we collaborate with, were very swift in action where they had known targets and took action on those. And so I feel fairly comfortable at this point where we are with the knowledge of those who would cause us harm and the actions taken.
Okay, good. I think some of that stuff next month when we get together, maybe we want to talk a little bit more about what you think might need to be done yet, and where we stand in terms of what's coming from the homeland as opposed to overseas. With regards to the pandemic, from 3 rows back, would it be fair to say that the national leadership actually was coming from New York State when as this rolled out, and the direction of how this pandemic was being responded to and mitigated in terms of masks and social distancing? We were at the front end driving that bus as opposed to getting direction from Washington?
I would say yes to your question, sir. And really, in terms of, as I talk to my counterparts around the country, and having a position that's uniformly applied across areas where it's needed, was a benefit and an envied position by many of those that I work with in other states. Clear guidance. Decisions, timely decisions, are important in trying to manage the pandemic. And I think to your point, yes, I think the state showed very well as we look at in comparison to others.
Yeah. With the change of administration, is the communications you receive now and the direction better than it was before?
So I think, what I would say is that most of my communications are at the FEMA level, at FEMA administrator at the time, and the current acting administrator and Region 2. For in my lane, I would say that our communications were good across the board. The ability to respond to our requests, I think, maybe we're a little more restricted at one point, but the communications were open. The Administrator Pete Gaynor had no problem calling me, and I had no problem calling him in terms of resourcing or discussing the state's needs.
Okay, good. Just one last question. I know from my background, obviously, we develop a lot of plans for different events, from hurricanes to the rest. I'll assume that we had a pandemic plan in place. How dramatically did you have to change that?
So there was a plan in place, and much of that revolved around county activity and support from communities to be able to execute on the plan. The plan was not necessarily resourced at the local level to the degree that it could have been. We know that given the magnitude of the event that we went through, the federal government wasn't prepared to be able to support us as well to the degree that we needed that support. So did we have to deviate from the plan? Absolutely. Nobody envisioned when we wrote that plan that every corner of the state would be affected to the degree it is, and over a period of time as it's rolled out to literally a year ago when we stood up the operations center.
Okay, I thank you. I want to congratulate you for what you and your people did. It was almost an impossible situation, and as much as people could have envisioned what a pandemic was going to do, this one was way beyond anybody's practical thinking. So I think you've done a great job. I look forward to meeting with you next month on some of the other issues. But I just want to say thank you very much. And I got done early this time, so I'll yield my 7 seconds back. Thank you.
Thank you.
Thank you, Senator Brooks. Thanks for your partnership all the time.
Thank you. Assembly member?
Yes, Assemblyman Zabrowski is debating a bill, so we'll go to Assemblyman Byrne first. 3 minutes. Thank you.
Mr. Commissioner, I'm just trying to.
Hello, sir.
I am dealing with 2 different laptops for session and for this budget hearing. So thank you. Appreciate your time and your testimony. Really just one specific question. A couple of years ago, actually, my senator that represents portions of Putnam and Westchester and I wrote to the governor's office about the Securing Communities Against Hate Crimes grant program. We were advocating that it could be expanded, particularly for houses of worship in light of what we've seen across the country and the globe, but also right here in New York to some extent. And I was encouraged that I think it was last year or the year prior, there was an expansion not only with increased funding, but it was also added eligibility for nonprofit community centers. And I was just looking for some clarification as to would that include houses of worship? And is that something that the state and the agency are looking to make sure is a part of that program?
So the answer is, the easy answer to your question is, so that the aperture has opened up so that there are other applicants that can apply for those grants. With that open aperture, there were literally in the last round of applications over double the number that applied. We were over 350 applications that we continue to sort through and look at the needs. And so it's we adhere to whatever the legislation is that provides that funding, and we continue to move out on it. So I think your advocacy has expanded that eligible pool, and I think we're in a good place right now.
Thank you. I bring that up because I know there's been in the past, I've had many conversations with some of the local temples in my district, mainly in Putnam County, and Westchester and New York City are able to access some federal funds and support, but Putnam was ineligible because of the proximity to the urban community wasn't close enough. However, some of the information that was missed in the federal program was many of their members of their congregation were from Westchester. They just happened to be located in Putnam. So the state program offered them an alternative mechanism to try to get support and funding for things like cameras when there's been a rise of, anti-Semitic graffiti or just accusations. So I wanted to make sure that houses of worship were included and continue to be viewed. So thank you, Mr. Commissioner. I appreciate your time and your testimony this session.
Thank you, sir.
Thank you. Back to the Senate.
Thank you. Our next questioner will be Senator Todd Kaminsky.
Thank you so much. Good afternoon, Commissioner. Thank you, Senator
Hi,
Krueger. Commissioner, with respect to cybersecurity and preventing problems, so far in my district alone, I've had a Rockville Center School District being taken ransom, where payment had to be made for data recovery. And then the city of Long Beach just had a hacking incident where, thank God, there was no ransom, but their systems were taken down for over a week. You couldn't even call into City Hall. And my question is New York going to have some overarching vision as to how to deal with cybersecurity on a local level? Is there some audit being done of our local municipalities or villages or schools? Is there tools to give them resources to help them beef up? Normally when the state wants to undertake an initiative, let's say making its electric fleet, its buses become electric, it'll put money out for studies, it'll award you incentives if you do well. Is there an overarching program to help our local institutions, especially those that are in control of large amounts of money, protected from cyber hacking?
So currently, we have a number of things that we're doing with the area, whether it be in school districts or in communities, or even those that touch the state network, to be able to secure our own our infrastructure. With those things come a number of opportunities. We do assessments with the limited staff that we have. We're not able to get to 3,000 different districts, but we are able to work with those that have needs. We do education. In your district, I believe, and through some of your advocacy, we've reached out to a number of organizations and provided assistance in the way of best practices, how to go about securing the network, using other partners, that type of thing. So that assistance and advice have been the keys to the work that we've done. We have started to move towards and used some federal dollars as well to be able to do some cyber grants as we move forward. In the school districts, we still rely heavily on the state education to manage that piece of it. But when it comes to the local municipalities, even nonprofits that you would work with, that if requested, we would be able to reach out to them and support them as well.
All right, thanks, Commissioner. Let me just get one question before I go, and I'd love to continue to work with you to beef that up. But on the securing communities against hate, hoping you could expand it for cyber as well. We had a private religious institution hacked, awful anti-Semitic stuff on there. They would love to take some of that funding and instead of putting up physical gates or cameras in some cases, be able to put in some cyber solutions as well. But right now that's ineligible.
Yeah, and so just a quick answer to your question, sir, would be as whatever the legislation is that guides those hate crime grants, we will follow that. And if it designates monies for cyber, then we would be more than happy to work with those institutions to do that.
All right, I will get to work on that. Thank you, Senator Krueger.
Thank you. Assembly.
Yes, we go to Assemblyman Wolzak.
Commissioner, thanks so much for taking the time. Wonderful to see you once again. Obviously, and a lot of the questions in this hearing for you so far today have been fixed on the pandemic, and I feel like our executive branch's nose sometimes is just fixed solely on the COVID-19 pandemic. You said 90% of your staff has been fully dedicated to this. That's a little bit of a concern to me. I know that that's a huge focus right now and a public health concern moving forward. But there's other things going on as well. So I'm just gonna, this question is big, very important to me, should be important to everyone globally, and also especially to everyone in these two legislative bodies. Back in 2013, there was a train derailment in Quebec. That resulted in an executive order by this governor in 2014 that directed your department to prepare for train derailments, work with locals on emergency preparedness, and get ready for what we knew was going to be more oil carried by rail freight coming out of the upper United States and especially out of Canada. Now that we see the XL pipeline has been canceled by the federal government, we anticipate that more oil once again will be pushed onto freight rail, onto ships that go through the St. Lawrence Seaway and other areas. and possibly even hearing from some Canadians onto trucks. So I was just wondering does this budget provide for any additional funds for you to be able to deal with that possible future disaster? And can you talk a little bit about what your department is doing and will do to get prepared for that?
So I think the first thing is, in our responsibilities as it relates to hazardous material handling and response to, we continue to work with our partners with the Office of Fire Prevention and Control and the emergency management staff to best address the needs of the local governments, the counties where these trains and hazardous material would be shipped through. And so we've put in place things like firefighting equipment that would be used in a hazardous material handling situation. We've continued to do training, not as much in person right now because of the pandemic, but we'll get back to it to address that. But the specifics of our involvement beyond that, other than in consultation with the communities and those that are making decisions, is pretty much limited to that at this point.
Commissioner, are there adequate resources for your department in this budget to be able to handle an oil spill on the St. Lawrence River, for example?
Okay, so the oil spill itself, where we would respond, we are not responsible for the oil spill piece of that. That would be environmental conservation and the other partners that would actually respond to the spill itself. So we will organize agencies to be able to apply to it. That is our mission. But I would defer to those that actually have responsibility.
Thanks, Commissioner.
Thank you, sir.
To the Senate.
Thank you. Next, Senator Diane Savino.
Thank you, Senator Krueger. Commissioner, it's good to see you again. I want to go back to the thread that Senator Kaminsky started, but actually broaden it out a little. As you know, under your portfolio, in your portfolio, is the issue of cybersecurity. And quite honestly, I don't think that you have enough authority across the state. And we have seen, because so much of cybersecurity issues are dealt with at the local level by local governments, we're seeing breaches everywhere. Just last week, the Albany County District Attorney announced that many of the cases that are pending before him may have to be dismissed because of a hack in the Albany County DA's office that threatens criminal justice investigations. Yesterday, the New York Times reported an incredibly dangerous situation in Florida where hackers were able to access a water treatment plant and potentially poison the water down there. So we're seeing all of these things happening in other states, in our counties, in our school districts, in our healthcare centers. And one of the big threads along there is we allow localities, towns and villages to deal with the purchase of software and handle their own cybersecurity purchases on their own. I think, and you and I have had this conversation, this is the exact opposite way to go, particularly in this time. So I would say that we need to now open up this conversation about right-sizing the way this state addresses issues of cybersecurity and technology purchases, and not allow localities to handle this, but to allow it to be driven from the state down because the risks are far too high. Would you agree with that?
So one of the things that we've talked about, and thanks for continuing the conversation, and I know you're passionate about this, is that to be able to, in contracts, for example, to be able to dictate in a contract that would be worked either through Office of General Services or some other mechanism that required some level of cybersecurity or the awareness or implementation of those kinds of efforts would be something that we would advocate for, to be able to do it in a more a broad level. I think providing guidance, as we have for other things that is more directive in nature, is okay. But I will leave that up to the legislators and
guidance,
others.
not to interrupt you, but guidance doesn't seem to be working because I think the problem is the localities are forced to make decisions based upon financial reasons as opposed to the best practices. And I think it's time for the legislature to kind of get involved in this, and because the risks are far too high. whether it's ransomware attacks on school districts, whether it's, invading the district attorney's office and threatening the people's justice, or potentially poisoning our water supply, or our election systems. We can no longer stand by and allow towns and villages to purchase equipment at the lowest responsible bidder, because that's what the law requires them to do, potentially creating all sorts of risks to the population. So thank you for the work you're doing. I look forward to working with you in the future.
No, thanks for your partnership, Senator.
Thank you.
Thank you, Assembly.
We go to Assemblyman Riley.
Thank you, Madam Chair. Good afternoon, Commissioner. Thank
Hello,
you
sir.
for your testimony. Great to see you again. I have a couple of questions. Shouldn't be too time consuming for me. In the executive proposal, there's a decrease of $600,000 to the Red Cross for their preparedness for blood emergency response preparedness. Do you think that will have a negative impact on being able to get volunteers for our blood supply? Because just recently, I know that there was a push, especially in downstate. If you could touch on that.
Sure. And so, at our agency, we just had the Red Cross in drawing blood here about 2 weeks ago, and I was able to provide a donation myself. So, but to get to the point about the money to begin with, the executive budget this year is exactly the same as it was last year. And the add-on dollars that you see that look different were the add-on dollars from the legislature to increase that number. And so the budget itself in the going in position is exactly what it was a year ago. To your point about will it affect the Red Cross's ability to draw blood, get critical services? Red Cross does a great job, and they are our absolute partners. We keep a liaison in our operations center with us routinely because of their partnership. And I think it's the best thing for New York to have a strong Red Cross in our camp.
Okay. The second question I have is in relation to the interoperable communications program. Can you tell me what that money is going to fund? If you can just give us just a brief overview and maybe just one specific program that you might know of.
So it really works with a couple different areas. First of all, upgrades to radios and communication networks. Our goal is to more regionalize that effort so that we have interoperability across regions of the state. I think we've made great strides in the activity up to this point. But it could be radio upgrades. It could be system upgrades. It can be towers that are needed in certain areas, depending on how that county or region has applied for those grants. But those are the big things right now.
Commissioner, I only got 10 seconds left, but I just wanted to ask, is there any exclusions in regards to applying for the grant population that would prohibit maybe New York City from obtaining those grant funding?
So we focus on those that have the least amount of funding to begin with, or the more challenged funding areas, and that's why we see primarily those grant dollars going up in central New York or up in St. Lawrence County in those areas. But it's not specifically excluding anybody. It's really based on the resources available. Yes, sir.
Thank you, Madam Chair.
Thank you. Okay, I have a couple of brief questions for you, Commissioner.
Yes, ma'am.
Thank you. So it was asked before, but I'm a little confused. So the governor put another $4 billion of federal money into Homeland Security. That's from the December money from the federal government. Is that correct? Or is that from earlier money?
No. So what I was trying to represent, and maybe I just didn't state it very well, was that we now have the appropriations authority, so that as we receive the federal dollars for reimbursement or funding to the localities to be able to execute under this pandemic. So we have that expanded authority to receive and distribute those dollars is really where we're at with that.
So when the governor makes his speeches and talks about 6 billion from the feds would be the worst, 15 billion from the feds would be the best, he means then 4 billion of it will be sitting in your department if he gets it.
So I'm not familiar enough with the request from the governor. I know the numbers because I've heard them, but really what we're looking at are those projects that the municipalities or the jurisdictions will apply for those grant dollars that federal government would come in and reimburse for those activities. It could be, if it's vaccines, for example, and it's 100% reimbursable for those expenses associated with vaccines, that money would be pulled into that account and then redistributed. And that's what that authority is.
So you do have a master list of what kinds of things this money could be spent on?
So whatever the eligible criteria is for those is right. If I understand your question right, we think that number gives us the latitude to work within the disasters that we currently have for New York.
I think my confusion is we in the legislature tend to think of age localities as a category of budget spending that actually isn't related to emergencies. It's how we pay for all kinds of things in our counties and towns and cities. So it's a little confusing to see 4 billion of what we think of as, oh yeah, we do owe our age localities a lot of money, but that's not what this will be about. This is new categories that fit into approved federal activities.
Correct. So it's monies that would be associated with pandemic, or it could be associated with the Halloween flooding in the Herkimer County where we had that disaster that was declared, or Isaias where we had the strong winds and we had another federally declared disaster as part of that. That funding stream would come in so that it would be redistributed.
Okay. All right, I'm going to go further into it, but not with you today. Thank you very much. My second question, I believe the new head of the Defense Department at the Pentagon announced his concern that there were active duty military personnel and others in law enforcement who participated in the January 6th situation at the federal level. And I am wondering whether we in New York State are doing anything. He talked about a new system of training, educating, and sorting through whether we do have white supremacists or homegrown terrorists in our own systems of security. And I'm wondering whether you are looking at that and thinking through, do we need to do something parallel here in New York State?
So, we continue to look at whether they wear a uniform or not, working with our law enforcement partners and the counterterrorism zones, as well as the New York Intel Center, and identifying those that would surface as either a white supremacist or nefarious actors in some way, again, whether they wear a uniform or not. I'm not able to speak to the what General Shields would be working on with the National Guard at this point. I'm 2 years removed from that. If they've got a program that's coming through the Department of Defense to do screening or other assessments, just not able to speak to that at this point. But from our perspective, a Homeland Security's perspective, law enforcement partners continue to look at those that would cause us harm.
Thank you. Assembly.
We go to our chair of GovOps, Assemblyman Zabrowski.
Thanks, Chair Weinstein, and good afternoon, Commissioner. Great to see you. Thanks for being with us today. And like my colleagues, let me thank you and all the men and women who work under you for all their work and how, during this difficult time, you've found ways to help help out in a variety of ways, looking at and listening to your testimony today. I know Senator Brooks, I think, touched on it earlier, but I just sort of wanted to ask, piggyback on his comments and ask you a little bit directly too. So certainly, as I think he sort of mentioned, the past year, January 6th, it certainly seems to a lot of New Yorkers, extremism, domestic terrorism is on the rise. And I know that, and I'm not asking you to sort of comment publicly on things that are sensitive, but what can you say publicly to New Yorkers about these threats, about your analysis of these threats, about the rise of the threats and where we are now, about our ability to proactively prevent possible incidents of violence in the future? And then specifically, because this is a budget hearing, tie it towards our resources, both this year and in future years. Do we have enough resources for you to be proactively doing what needs to be done to protect all the various corners of New York State?
So what I would say is that those that have direct responsibility for gathering information, those that are authorized to gather information on citizens and continue to do analysis, we routinely partner with those folks. The New York State Police and the Intel Center have collaborated with the other agencies throughout the state to be able to track certain individuals that would otherwise want to cause us harm. And without going into specifics of how that's done or who it is, I think that the citizenry of New York should be fairly comfortable that we have a system in place to be able to take a look at this and to act on those people that would otherwise cause us harm again. So from that perspective, I think we're in a good place. Could we use more resources over time to better identify people and track them, or groups of people that would cause us harm or cause citizens harm? Absolutely. I mean, it goes anywhere from something as basic as license plate readers that have yielded some incredible intelligence for us that would help prevent something from happening, to something as simple as the Say Something, See Something program and the tip lines that we have that are relatively inexpensive. But if the population has confidence in us that we will act on those things, which we do, which our law enforcement partners do, again, I think those in New York should feel comfortable that there's a constant, unwavering eye looking for those that would harm us.
Thank you, Commissioner, and I know that to be true, and I appreciate over the years you and your team collaboration with the Assembly and with the Senate, and I would just end with saying that as we're certainly in troubling times, and I know we have a joint commitment to protect all the people of New York State, and I just want to express our commitment, for myself, but I think most, if not all, my colleagues that will work together and are willing to work together to sort of identify those resource needs over the course of the year, not just during these budget hearings like today, but so that we're looking outward several years and proactively to address all the safety concerns of New Yorkers. And really thank you for all that you've done and your team has done.
Thank you, sir.
Thank you. Senate, do you have anybody else? We still have.
No, I don't believe we do.
So we have next.
Senator Brooks has his hand up.
Oh, no, but he took it down for me, actually. He just didn't know he took it down.
Assemblyman Levine, then for 5 minutes.
Thank you so much, and thank you, Commissioner. Scott Beagle was a New Yorker, and he was a teacher at the Marjorie Stoneman Douglas High School in Parkland, Florida, when he was murdered almost 3 years ago, protecting his students, and he did protect his students. The Senate today is scheduled to vote on the Scott J. Beagle, excuse me, Unfinished Receiver Act, which would make it unlawful for anyone not a licensed gun dealer to possess the component parts to do-it-yourself homemade weapons, which are easily purchasable online. And the FBI has reported that between 2010 and 2020, there's been a proliferation of the home manufacture of these weapons. And as of 2020, there had been over 2,500 arrests, federal arrests for their possession. In the recent months, some of the militant rightist movements have had their members arrested for committing crimes and possession of these homemade weapons. They don't want the government knowing what kind of weapons they have got. After all, the government is the enemy, unfortunately. But this is the world that we live in. Can you tell me, has the Division of Homeland Security begun to yet focus on the threat posed by the homemade, do-it-yourself manufacture of these sophisticated tactical weapons?
So there's really two things that the division does that I think fall into the category of taking a look at this type of thing. There's really, the first one is probably the most direct, and that is with our red teaming, where we would go out to a business establishment that may have component parts, not only for building a weapon, but also for potentially bomb making material. And then we work with the See Something, Say Something program to get additional eyes or sensors, if you will, in the community to be able to do that. And so we go out and do a series of educational opportunities in a particular area in conjunction with the counterterrorism zone, local law enforcement. If that component parts and pieces would be part of a business there, we will go in then later and then sample that organization to see if they're tracking who sells it, if somebody buys those parts and pieces that there's an unknown reason why they would buy them and otherwise be used for something else. So through the red teaming, I think we touch it. What we also do is through our infrastructure vulnerability, we take a look at some of that infrastructure that potentially could be at risk. But I would tell you that in more specific terms, it would be our law enforcement partners, really state police in this case, or others that would be looking into something more in depth, like a mail order or somebody giving us an indication that they would be somebody that they know would be purchasing items that they would have something nefarious in mind with those. So I think not directly touching on what you're asking, sir, but that is our involvement in it.
Thank you, Commissioner. Thank you for all you and your division does. And thank you for addressing this burgeoning and imminent threat to the safety of our citizens. Take good care. Thank you.
Thank you, sir.
Thank you. So now we go our final assembly questioner, Assemblyman Lawler.
Thank you, Chairwoman. Commissioner, thanks for joining us this morning. I apologize for been going between screens for session and the budget hearing. So if I ask a question that you already answered, if you can indulge me, I appreciate it.
Sure.
The with respect to the FEMA reimbursements, what expenditures by local governments are considered eligible for this reimbursement? And does this include FEMA funding or CARES Act funding or both?
So I think the answer is both. And in terms of what is eligible for purchasing, our agency is not managing the CARES Act dollars. What we will do is work with the municipalities as to what those eligible costs are. Some of them are still being defined right now. In other words, cleaning, for example, as well as, or sanitizing, as well as some of the PPE that was purchased and over time, because we had a period of eligibility, then a period of ineligibility, and now we're back to something that looks more like 100% reimbursement. So we are currently working with FEMA to best identify what those eligible costs are. But in the end, sanitation as it relates to infection, personal protective equipment of a variety of types. Some of it may be durable medical supplies in the end that would be reimbursed. And then right now, as of, I think it's the 21st of January, 100% on vaccination costs. In other words, resources used by the county or the municipality to administer vaccines, pretty much all of those costs to be able to bring people into a particular site, to be able to provide them the vaccine, to provide them the medical supplies that support the administration of the vaccines, those types of things. Did I get to your question there, sir? It's fairly broad.
Yep, I appreciate it. The shifting gears completely away from that. My last question is about obviously some of the violence and extremism that we've witnessed in our country, both last summer with some of the riots, and certainly on January 6th down at the Capitol. When you're looking into some of this, are you looking to see if there are organizations or entities that are paying people to go protest, paying people to be part of this violence in any way, and helping kind of organize? Because in some of these cases, it certainly seems very organized. And I'm just curious if that's something you've looked into as part of ensuring the public safety here.
Okay, so our agency specifically does not look into that, but I can tell you from being part of the community of interest in this case, again, I would refer back to the state police, our federal partners that sit in the New York Intel Center. They do analysis on the flow of money that comes in support of a number of activities. So that is a component of the activity that goes on. And I can assure you that behind a closed door, we could probably talk a little bit more about those activities as they relate to that.
I appreciate that. And I know my time is up. I would just say I think that's something we need to look at and go after those that are paying people to actually go agitate and organize in that manner. So thank you.
Yes, thank you.
So Senator Krueger, we are finished on the Assembly side.
And we are finished on the Senate side. So Commissioner, I want to thank you very much for being here with us today, and continue with your good work on our behalf, even though we often don't know all the things you are doing with your division. Our next up, the New York State Office of Information Technology Services, Angelo or Tony Riddick, Interim CIO and Director. Are you with us? Hello. Does anyone on staff know whether?
I was pretty sure I saw them.
Here, yeah, he was just here. We will.
Okay. We've lost him. We will find him.
Yes.
And for those of you tracking the day, we've completed 4 of our 8 government representatives, to just give you a flavor for the length of this hearing. Let's see.
By the way, it's more than a little ironic that it is the chief information
I
officer that had technical issues. Just saying.
You know, that happens all of the time. Good afternoon. Can you hear me?
Yes, we can hear you. Hi,
I do
how are
apologize.
you?
I'm fine, thank you. I just looked at my team and says it had to happen right at the nick of time. So my apologies.
That's okay. Everybody has a little bit of technology problems. It's true. It's true.
Especially the Chief Information Officer. Thank you, Chairs Kruger and Weinstein.
Wait, wait, 1 second. Somebody's not on mute. Please put yourself on mute. We don't want to hear your phone conversations. Thank you. Okay, please keep going.
Thank you, Chairs Kruger and Weinstein, and distinguished members of the Senate and Assembly for your leadership, experience, and service to New York. My name is Angelo Riddick, and I'm grateful to be joining you to discuss the work and mission of the state's Office of Information Technology Services. Before starting as the state CIO in December, I was blessed to have a 30-year military career, much of it specializing in information technology. Most recently, I served as a CIO for the United States Virgin Islands. Let me start by first saying thank you to Governor Cuomo for the opportunity. Over much of the last year, the agency I now lead has been at the forefront of the state's COVID response. We helped tens of thousands of state employees in their transition from office to remote work with laptops, phones, video conferencing tools, and secure access to the state's network. This work allowed our client agencies to continue meeting the needs of New Yorkers during a global pandemic. We rapidly built and deployed new applications like the Facility Entry Screening app, which has allowed state employees to begin safely returning to their offices. 80 state entities now use this tool to protect their most precious resource, our people. We created the state's COVID-19 dashboard and Nourish New York app, expanded remote hearings and virtual waiting rooms, and improved the digital experience for millions of New Yorkers in search of state services. At the governor's direction, we managed the state's successful Tech SWAT program, a partnership with leading technology companies that allowed us to surge resources and meet unprecedented demand. Tech volunteers donated 25,000 pro bono hours and saved taxpayers $14 million. The work now being done by ITS is consistent with the governor's Build Back Better directive. When it comes to technology, our challenge is to always build back smarter, more agile, and more modern, and more secure for the future. Despite new and unexpected challenges caused by the COVID pandemic, our $861 million executive budget allocation is virtually unchanged from last year. However, like most agencies, we are doing more with less. ITS has accelerated modernization efforts, enhanced the digital offerings of many state agencies, and we continue to decommission legacy systems. We are now fully engaged with the vaccine distribution sites around the state, providing 24/7 technical support and assisting with other COVID-19 related IT challenges. Meanwhile, our security team is working around the clock to protect the state's infrastructure from a growing number of cyber threats. In cooperation with partner agencies like DISH's, our security experts are often engaged to support state and local government entities, hospitals, and schools as they work to navigate threats to their own environments. The most publicized SolarWinds hack has impacted many federal agencies, and while our forensic review has indicated no unusual activity within our systems to date, New York, as always, remains on high alert. Due to the challenges and complexities brought on by COVID, we live in a very different world than the one we resided in just a year ago. Under the governor's leadership, I'm proud to say that we have adapted to these challenges and continue to position New York as a leader and innovator. The executive budget will enable us to deliver timely and cost-effective solutions for more than 40 executive agencies and the New Yorkers they serve. Technology has always been an ally during the pandemic. It's allowed teachers to continue to educate our children, help many businesses evolve and remain open, allowed New Yorkers to seek real-time medical advice from highly skilled doctors and nurses, ensured the integrity of the state and federal elections, and kept us connected to our families when we needed them the most. Investing in our technology infrastructure is more important today than it's ever been. I am truly honored to serve the state of New York. As CIO, my goal is to seamlessly integrate the people, processes, products and policy to serve our citizens in a better, smarter, and more cost-effective way. I thank you for your time, and I'm happy to answer any questions you may have.
Thank you very much, Commissioner. I don't see the Senate Chair yet, so I'm going to move along to the Assembly Chair, Zabrowski, for first set of questions.
Thank you. Thanks for being with us here today. I got a couple questions, and I think the first one is definitely in your purview, and the second one may not. So perhaps you could point me in the right direction, because I don't know who else I would ask about it. First, so the budget once again includes a proposal to have almost like a design build system, right, for comprehensive technology service contracts. So maybe you could talk a little bit about, what problems are you trying to solve? What does this give you the ability to do? How do you currently sort of like internally produce, technology products, and how do you currently procure technology products, and how would this improve that process?
Of course, IT procurement is a touchy subject, and thanks for asking that question. I'm very familiar with the process. I've read in on the proposal, and what this proposal will allow us to do is possibly use one vendor from cradle to grave in terms of project management, architecting, and executing the project itself. Under the old infrastructure, and I've used it in many cases before, the procurement process forces an entity to look at several vendors throughout the life cycle of the project, meaning that you may have one architect, you may have one builder, and you may have one quality control executor. It's complicated when you add too many cooks in the kitchen. What this bill proposes to do is to allow us, of course, to use the standard procurement processes that we use in the state of New York, but in many cases, we can procure a vendor to do the job from its architectural phase and concept phase through the build phase and finally to the quality control phase before deployment.
Okay, so it's not necessarily like a cost saving measure as much as it's, given the nature of these contracts, this type of procurement process would make it more efficient and more searching for the right word. Maybe you could give it to me. Is that essentially what you're
I think
saying?
you used the perfect word, sir. Efficiencies are what we want to capitalize on. And this proposal will allow us to be more proficient, especially in big contract procurement programs.
Okay. All right. Thank you for that info. The second thing, so there's a part of the budget that would permit agencies to share voluntarily provided citizen data as long as the sharing is consistent with state and federal law and pre-existing privacy practices. So this is the part where I'm not 100% sure if this would be under your purview or not, but assuming it is, could you give me a sense of what is the state trying to do and how our current laws don't allow it? Because, in our sort of analysis, I'm not sure that we don't think that, you're able to do some sort of interagency sharing if you're looking to give people the ability to, sort of, I don't know, one-stop shop, if you will, but, sign into one state agency and have their information be shareable with other agencies. I could see how that, would be helpful to New Yorkers. Is that what you're trying to get at?
I see your perspective, and I absolutely agree that if we had one giant database and we could segment that database to allow information to be shared on a need to know and need to share basis, we'd be in an optimum environment. However, that's not always possible. Agencies develop requirements. We configure databases and data streaming based on those requirements using the policies and regulations that they are governed by. We don't set those policies. However, we do work with agencies to understand those requirements and secure that data as much as we can.
So maybe you could allay the fears of myself and some of my colleagues, okay? So what they would be afraid of if we adopt this in the budget, that, we are contributing to what is a proliferation of the selling of people's individual data, resulting in perhaps a host of harmful or otherwise invasive things happening in their lives. So will this provision, will you be selling data? Will this, when you say it'll be voluntarily provided, will it truly be voluntary? Will people know what they're doing, or when they're signing up for something on the DMV or on some other state agency, maybe they're getting a fishing license or something, will they just be checking a box that, they have to check anyway? And then therefore their information is going to be shared more now than it was in the past.
I can definitely respect your inquiry about the risk of sharing data. I can assure you that ITS will not be in the business of selling data, and data sharing will be based on requirements that are established by organizations that we support.
Okay. So you can definitively say it's not to sell the data.
Absolutely.
Okay. And, I know it says consistent with state and federal law. Well, it doesn't give me a whole lot of assurance because, a whole lot of data is being shared right now, and certainly it has to be consistent with state and federal law. So I can take from your comments today that it's not to sell, it's not to sort of like share with outside entities that are not related to state agency function, and that this is merely to allow the state agencies to exist and share data within each other for the benefit of New York citizens in terms of just utilizing state resources. I know I had a lot there, but can you say yes to that? Can you confirm?
I can say absolutely yes to that. And again, ITS is not in the business of selling data.
Okay. All right. Yeah, I appreciate your answers today. And, for both these items, I would just say, they definitely are complicated. We want to understand it. I want to understand it both as a chair and our staffs want to understand it. And we want to be able to, a lot of the members of the assembly, probably some senators too, I want to speak for the other house, but, have questions about this stuff. So as we go forward, perhaps we could set up a communication channel between now and when we adopt the budget, that if we have additional questions, we can ask you. We'd appreciate that.
Well, thank you for your questions. I look forward to working with you in the future.
Thank you.
Thank you.
Senate.
Oh, yes, go ahead. Senator Diane Savino.
Thank you. Thank you. Nice to meet you, Commissioner Riddick. And I saw in your testimony that you said that you were pleased to be able to join the team in December. At the end of this year, I'll ask you if you continue to feel that way after having been here for a year. As you know, New York State, like a lot of large states, is probably years behind where it should be with respect to its internet technology infrastructure. 10 years ago, as a member of the Senate, I wrote and passed a law that we adopted to allow for the insourcing of information technology and the development of an IT, what we like to call our own geek squad. 10 years later, the state has yet to fully implement that. We've not been able to accomplish that. How do we recruit and retain information technology experts who want to stay in the government workforce? And it probably couldn't have come at a worse time when the pandemic hit and we had to then send almost all of our workforce home to find ways to service the population, whether it was adapting our legacy systems, whether it was the unemployment system, our public assistance systems, and be able to have people work remotely, provide them the equipment, and all do that and then find ways to secure them. So you have your work cut out for you. I know in the governor's budget, he is proposing a couple of issues that I'm happy to hear you explained. The issue of the comprehensive technology contracts, or kind of the design build for technology. But I want to ask you a question that I asked your predecessor who testified previously from Homeland Security. One of the big challenges we're seeing across the state of ransomware attacks, whether it be in our district attorney's offices, our school districts, local governments, or even in our own offices. And some of it, I believe, is because we're allowing local governments right down to towns and villages to handle the issue of technology purchases and software purchases. Do you think, though, that this approach of this comprehensive technology contract is something that would help to prevent that type of cybersecurity risks?
I think it will definitely create efficiencies. And thank you so much for the question. But what you did is you tapped on my philosophy of using people, processes, and policy. As we work with local entities, as we work with organizations, it's important that we provide the guidance that they need. Now, one size fits all doesn't work for cybersecurity. I've always said since my days in academia teaching at the National Defense University that the best we can do in cyber is stay one town ahead of the posse. It's the people's job who work in ITS and all of the various agencies to lean forward and make sure that we're paying attention to what's happening out there in the wild. We have to improve our processes as well. We have to make sure that we identify efficiencies. And one of the processes that we have to implement and stay glued to is our ability to do the professional reading, to find out what's happening out there. And with regards to policy, I'm a policy man. I think that we should have inward-facing policies and outward-facing policies for the use of our technologies. These three things implemented in the right strategy will help us to secure our network and keep our data safe and our people secure. However, it takes an effort, it takes teamwork, and I'm going to be behind that 100%. Cybersecurity is something that I'm emphatic about. And again, I emphasize that we can only stay one town ahead of the posse. If we can get 2 or 3, that will be great, but they're always nipping at our heels.
Well, I certainly look forward to working with you. Have you had a chance to analyze some of these legacy systems that we've had in place, whether it's the old welfare management system or particularly with respect to our public assistance programs? They're horrible.
Oh, absolutely. I've definitely looked at WMS, Welfare Management System, and I've looked at its successor, the Integrated Eligibility System. Eventually in 2024, the goal is to deliver the Integrated Eligibility System, which should clean some of the problems that we've had with WMS. However, at the same time, it's like fixing the tire with the car rolling. We cannot discount that we still have to use WMS until its life cycle is over with. So we're paying attention to that. We're trying to fix the holes. We're trying to fix the gaps. We're trying to keep the clients and the customers satisfied there. And yes, I've looked at legacy systems as well. I appreciate that question. I met with the DMV. I know that they're working with an antiquated system, but they're leaning forward as well. And we're looking at solutions that they could move to make their technology up to date, more efficient and more effective. And eventually it'll save us money.
Thank you, Diane. Let's
look
go
forward to
over- No more, sorry.
It's okay.
Thank you.
So we go to Assemblyman Ra, 5 minutes.
Thank you, Chair. Good afternoon. Thank you for being here. My colleague got into a little bit of what I wanted to, but I just want to circle back to that, that Part FF in the budget bill that deals with this kind of design build type concept for awarding contracts. And you did give, an idea of what we're looking for. I don't know if you can maybe give like an example of a type of, situation that it would help the department with. I know that, in the past, there's been a major, bidding of IT contracts. And I know that the state, I guess, put off a contract that was due to be rebid and extended the existing one. So I'm just looking for, would this potentially be in place of that type of contract?
Well, I think I heard you say you wanted an example.
Yeah.
And I'm very willing to give you an example. And it's a great segue from what I just talked about in legacy systems. If we designed a project to upgrade all of the mainframe systems that we have in an area, let's just say an area like Empire Plaza, in the procurement process, we will look to a vendor that could come in and do an architectural design, provide the resources that we need to replace that system, say with the client-based, client server-based system, or a software solution that's in the cloud. And that person could work on the architectural design of the facility itself, rather than work on a contract that would hire 3 or 4 vendors to do multifaceted pieces of that work. This will allow us to do a procurement proposal that would allow a vendor to make a bid to do all of the work themselves. That creates efficiency, it reduces conflict, and it speeds up the project from cradle to grave.
Okay, and could you just, Obviously we've seen in so many ways in the last year that some of our IT infrastructure, needed to be upgraded to handle things. So certainly, I understand where you're coming from with regard to that, but I know this is a proposal that has come up in the past and I guess not made it past the finish line. So do you think that, the circumstances have changed in part because of some of the issues we've dealt with that makes this the right time to go with this type of approach?
I think with what we're going through with the surge in COVID and the resources that we have to use and to tackle, I think it's a great opportunity to identify those efficiencies and perhaps use the next project as an example of the clarity of the efficiency that proposal lends itself to.
Great. Well, thank you for that. It is it's an interesting budget from a technology standpoint. Certainly, there's these types of proposals. There's things that I know that aren't directly related to your department, but you have the broadband proposal. You have obviously the data accountability and transparency piece. And I just hope that when we get into some of these areas that are just so technical, that we can make sure we're getting the input from from our business community, from people in the state, and certainly from experts in these areas to make sure that we come up with the best systems we want. We always want the best. We always want to be the leader in the things we're doing. So I thank you for your answers.
Thank you so much.
Yeah, can we go back to the Senate now?
Thank you. Senator Kevin Thomas.
Hi, thank you, Chair, and thank you, Commissioner, for being here to testify. I'm sure you're aware that the governor introduced the Data Accountability and Protection Act. My colleague, the Assembly, just brought that up. How familiar is the Office of Information Technology Services with privacy and cybersecurity standards and best practices?
I have all the confidence, and thank you for asking that question, in my cyber team and the individuals that work at the executive level in ITS. They've done a heck of a job of bringing me up to speed with the questions that I should anticipate here. Not only that, in my orientation, they provided me with the information that I needed to talk about things like data privacy, data security, and all of those relative subjects. I got to tell you, it was a baptism by fire. I'm still working. I can't necessarily answer all of the questions, but feel free to ask me some specific and I'll give you the best shot that I can. I'll defer to my team at a later time and get back with you later if I can't satisfy your requirement here.
Sure. All right. I'll ask you one question because of my time. The governor's proposal gives primary enforcement to the Department of State. For context here, the Office of the Attorney General has actively prosecuted privacy violations for a decade. The Department of Financial Services, who was given a small enforcement role in the governor's proposal, has also actively regulated cybersecurity since 2017. What experience does the Department of State have in privacy and cybersecurity to justify their role as primary enforcer?
Respectfully, Senator, I think that's a great question, but I'm going to have to defer to my colleagues. If I get a satisfactory answer, I'll make sure to circle back with you.
All right. Chairwoman, I will yield my time. Thank you so much, Commissioner.
Thank you.
Thank you. Assembly.
Chair, you're muted.
We do not have any other Assembly members.
I didn't realize.
So back to the Senate.
Thank you. I didn't realize I was on mute. Okay, Senator Tom O'Mara.
Thank you, Chairwoman. And thank you for being with us today to testify. Appreciate your time and your commitment, which I'm sure has been a brutal year from your position in dealing with the crises that we've had, and particularly the difficulties in unemployment and how that was handled. Can you outline for us what's the status of the computer upgrade for the Department of Labor that we really got caught with our pants down this year with regards to handling unemployment claims? And my understanding is that was I don't know how old of a system, but I heard it was DOS-based. So where are we in regard to that agency in particular?
Thanks for that question, Senator O'Mara. I don't have a specific answer for that. I can tell you what I've done working with the department up to date, but in terms of a deployment for a new computer system or an upgrade, I don't have that specific answer. However, I will make sure that my team and I work on that, and we'll get back to you at a later date.
Okay, yeah, please do. And I mean, do you have a sense of the various agencies and departments across the state? I mean, where we could find ourselves very embarrassed and incapable because of our outdated systems, and just what kind of outlook you have for the state's overall upgrading of all its various systems?
Absolutely. As a part of my orientation, I think that's a great question. As a part of my orientation, I wanted my CTO, my Chief Technology Officer, and all around him to brief me on where we are with modernization. The modernization efforts that are in place, I'm very satisfied with. I want to improve on the process, however, of how we develop an RFP, how we look at bids, how we look at vendors who make bids for those RFPs, and make sure that we're using proper processes and project planning. Recently, I went over with my Chief Portfolio Officer the process that we use to take a project from cradle to grave. With regards to looking at those systems, what I want to do is implement a few processes like a control board to eliminate the dialogue that it takes to understand what requirements are as we move forward with satisfying an upgrade, and find efficiencies to move that process through to implementation. So yes, we've looked at the legacy systems. It's going to be a challenge, but it's not something we can't overcome with identifying efficiencies and looking at the latest, greatest leading edge technology.
Thank you for that answer. And I'm glad to hear that you're on top of this and reviewing these so we don't have these situations in the future. And I think we need to make a stronger commitment from the state budgetary process to make these upgrades. I think we go too long in between upgrades of various systems, and the technology has changed so fast. Can you generally outline for me what your or your office's the state's strategy is in regard to the cloud technology that's out there? Are we utilizing it fully? Are you comfortable with the safety and security of it?
And I think, again, that's a great question, because I've had those challenges before. Should we go to the cloud, or should we use a local-based system to store? Now, understand that the data centers that we have are really virtual clouds for the data that we store. When we need to resort to a vendor to use their cloud resources, say AWS, Amazon Web Services, or Google services, we'll definitely look for efficiencies, and we'll always factor in security as we make a prudent decision to move to those platforms.
Well, thank you very much. Appreciate your time and your answers, and good luck in making the changes that need to be made. Appreciate it.
Thank you very much.
Helene, do you have assembly, anyone?
We do not.
Okay, so we actually have one more senator, but before I go to him, that's Brad Hoylman, I do want to clarify for the record that Diane Savino is the chair of our new committee on information and technology, or some better name than that. And I think you heard from Kevin Thomas from Consumer Affairs. These are both crucially important committees for going down the road and looking at the endless questions that now confront us, because we live in a world where, that bad movie, the machines have taken over, but we're not exactly sure what they're doing. And we need to make sure they're doing what we need them to do and not doing all the other things they can do. So I encourage you to continue your work with both of those committee chairs and their equivalent assembly chairs. With that, Senator Brad Hoylman to close for the Senate.
Thank you. Nice to see you. Thank you for being here, Commissioner. Wanted to ask you a question. It's been brought to my attention from constituents that New York State agency websites do generally not offer users an easy way to translate the text of the websites into different languages. There's one notable exception, which is the state's COVID-19 vaccine eligibility website, which features a drop-down menu allowing users to translate into Spanish, Chinese, Russian, Haitian, Creole, Bengali, or Korean. It's a wonderful feature. I actually wish more websites incorporated it. In 2011, the governor issued an executive order to ensure that state agencies established language access plans. What role does the Office of Information Technology Services play in helping state agencies comply with this governor, with Governor Cuomo's executive order? It was EO 26.
Senator, great question. Our role with agencies is to make sure that we clarify requirements, that we work with those requirements, and we deploy the systems based on those requirements. I think it takes a double collaborative effort. When our team sits down with an agency, say to build a website or to deploy a new piece of equipment or upgrade, it's important that we understand what those requirements are. I am not necessarily familiar with the language challenge we have here, but I've made a note, and I'm going to have my web team take a look at these websites to make sure that we're working with these agencies to meet all of those requirements, be it language, be it Section 8, whatever we're required to do. It's my job to make sure we do it effectively and efficiently, but it's important that we collaborate. So collaboration is a part of that process that I want to improve as a team leader.
Well, I thank you. I appreciate that. I recently introduced legislation with Assemblymember Yuling New that would require New York State agency websites to incorporate language translation technology within 90 days. Do you think that's feasible?
I'll have to look at what that process involved. I think it's feasible. I know there's some tools out there that we can link to make that more realistic, where we don't have to do the heavy lifting and write all the codes. So I'll get with my staff to find out exactly how we define that requirement from the agencies, take a look at your proposal and do it efficiently and effectively and to standard.
Thank you very much. Much appreciated.
Thank you. And we have been joined by one additional senator desperate to ask you a question, Gustavo Rivera, Chair of the Health Committee.
Thank you. It'll be quick. Hello, sir. These are, and sorry that I'm a little dark, but the sun is right behind me right now. The questions all relate to our correction system. And they specifically, I wanted to see if you could give us any sense about whether it's medical records, updating medical records software, parole records. Obviously, you know, I don't have to tell you how much easier either of these things, whether it's providing medical care or securing medical care and the parole process, how easier it would be if there was a more modernized information system for both of these things. And also any updates that you can give us on potentially expanding broadband for prisons across the state. So anything you can tell us about how these things interact with corrections and information technology.
Senator, unfortunately, and thanks for the question, I don't have any ideas that I can express right now. I'll have to look into that challenge and get back with you if you'll allow me, because we're going to have to do an analysis. I'm not familiar with the situation. I'm familiar with all of the requirements, the HIPAA requirements, medical records, and all of those things. But as it relates to the correction system, I've not yet been read in. I will make that a priority.
And I would really appreciate it that you do. I mean, again, whether it's on I went to one parole board many years ago as an observer, and seeing a stack this, like literally this high off the desk of just paper for folks who were being seen that day. I mean, that obviously does not speak to, it was years ago, so I'm hoping, and apparently that is still the case. So whether it's related to parole, whether it's related to the medical systems, like, and whether it's related to broadband at prisons, and also looking more specifically into the tablets that are provided for incarcerated people, and considering that they're kind of like a money pit. Apparently, it's like a private company that just kind of abuses it, the service that they're providing. I would just appreciate that. I'm glad that you're on the record as being not being aware of stuff, but wanting to learn more about it. And I would really appreciate if you could get back to us on it.
Absolutely. Thank you very much.
Thank you, sir. Thank you, Madam Chairwoman.
All right, with that, I think we are going to say thank you very much. Welcome for joining us here in New York State in December. And plan on staying a while because apparently we have a long list of things for you to do.
Absolutely.
All right, thank you
so much.
Thank you.
Thank
Our
you.
next speaker is Michael Green, Executive Deputy Commissioner, New York State Division of Criminal Justice Services. And the chairs are Bailey and Dinowitz from Codes. Welcome.
Good afternoon. Thank you for having me. Good afternoon, Chairwoman Krueger, Chairwoman Weinstein, and distinguished members of the legislature. I am Mike Green, head of the Division of Criminal Justice Services. And again, thank you for inviting me to appear before you today. New York State is the second safest large state in the nation, ranking just behind Pennsylvania. While final crime numbers for 2020 are not yet complete, preliminary data shows that the total number of crimes reported will be similar to the historic low reported in 2019. The COVID-19 global pandemic has placed extraordinary pressure on all New Yorkers, but communities of color, already facing a disproportionate share of poverty and violence, have borne the brunt of the virus's devastating impact. Although total crime did not increase during this period, our state's largest cities experienced a sharp rise in shooting and gun deaths in 2020, a trend seen in large cities across the country. The 20 police departments participating in our GIVE, or Gun Involved Violence Elimination Initiative, reported a 75% increase in shootings and an 82% increase in gun homicides. Similar increases were also seen in New York City. Staff supported through GIVE, the Snug Street Outreach Program, and the Crime Analysis Center Network are working tirelessly to address these increases through effective evidence-based strategies and have adapted their approach in light of the pandemic. An innovative partnership with the State Office of Victim Services has allowed DCJS to establish a comprehensive social work program within our SNUG sites. Through this $2.3 million investment of federal funding, licensed social workers and case managers are helping individuals and families address long-term trauma resulting from ongoing exposure to community violence. Last year, the killing of George Floyd by a Minneapolis police officer ignited a renewed focus on social justice and racial inequality around the country. In response, Governor Cuomo issued Executive Order 203, which requires local police agencies to engage community stakeholders in a collaborative process to reform and reinvent how they protect and serve their communities. This process must be open and transparent, and local governments must ratify or adopt such plan by local law resolution by April 1st. Strengthening police community relationships and improving the fairness and effectiveness of the criminal justice system are foundations of DCJS's work. In partnership with the Municipal Police Training Council, the agency has developed model policies to address critical issues, such as body-worn cameras and use of force, and recently completed a comprehensive update of the basic training required for municipal police recruits. The 700-hour training now includes procedural justice and implicit bias and emphasizes decision-making, communication, and de-escalation skills. DCJS has also partnered with the Office of Mental Health to revise and expand course components to improve outcomes for individuals with mental illness and enhance collaboration between police officers and crisis intervention services. In addition, the agency worked with national experts to develop principled policing training, a comprehensive course focusing on procedural justice and implicit bias that is available to all police personnel. DCJS also publishes comprehensive data on arrests, case outcomes, and sentencing by race and ethnicity, so New Yorkers can see how the criminal justice system is operating in their communities. Legislation enacted in 2019 allowed DCJS to seal 3.2 million New York State criminal records for arrests that resulted in low-level convictions and arrests over 5 years old that had no corresponding dispositions. As a result of this work, nearly 800,000 individuals now have a clean record with no New York State criminal history, barring them from obtaining employment, housing, or professional licenses. Governor Cuomo's proposed budget also aims to strengthen the police profession, which further builds upon our work. His comprehensive proposal establishes minimum hiring standards for police, subjects police agencies to the same training standards, enhances the police accreditation process, and strengthens the process for decertifying training certificates for officers who are terminated for engaging in serious misconduct. The proposed executive budget will also allow DCJS to continue supporting the criminal justice system across the state in evidence-based programs that have received national attention and distinguished New York as a leader in effective public safety policy. Most recently, the Giffords Law Center to Prevent Gun Violence highlighted our investment of federal funding in SNUG in a report advocating for changes in federal funding to better address community violence. The Pew Charitable Trusts showcased our Criminal Justice Knowledge Bank and Research Consortium, created to promote and expand the use of research and evidence by criminal justice professionals. This budget also includes common sense legislative changes, adding a new domestic violence misdemeanor to flag convictions that make individuals ineligible to purchase firearms, closing a federal loophole by prohibiting the purchase or acquisition of a rifle, shotgun, or firearm by any person who is subjected to who's subject of an active warrant for a felony or misdemeanor offense, and requiring law enforcement agencies to share firearm and ballistic evidence through NIBIN and the ATF's E-Trace program, two important tools to fight the increase of gun violence. Public safety is our highest priority. This 2021-2022 executive budget proposal will allow DCJS to continue its support for programs and initiatives that promote fairness, respect, and transparency in the state's criminal justice system and help keep New Yorkers safe. Your support of our work will allow the state to address gun violence, sustain its historic reductions in crime, and continue to reduce the number of individuals who enter the criminal justice system. Thank you for the opportunity to speak with you today.
You're muted, Senator Krueger.
You know, you move around, you can't get your unmute off. I apologize, everyone. And our chairs again for this speaker are, excuse me, Senators Bailey and Dinowitz. So I'm going to give Senator Bailey the first 10 minutes.
Thank you, Madam Chair, Executive Deputy Commissioner. Thank you for your testimony. I'll jump right into it. Obviously, you mentioned George Floyd and policing, and it's obviously been something at the forefront of many of our minds, if not all of our minds, in the legislature, and the protests that came about as a result of the murder, and I'll say the murder of George Floyd, resulted in what we believe, many of us believe, to be significant violations related to use of force in Kentland. Does DCJS have any comment about those use of force? Because you mentioned it in some of your testimony before.
Well, I wouldn't comment on any specific cases because DCJS is a statutory agency, doesn't have a role, for example, in disciplinary process. I can say generally that DCJS, working with our partners and specifically the Municipal Police Training Council, are very focused on these issues. I mentioned in our testimony that we just finished a comprehensive overhaul of the training that basic recruits go through, the minimum standards. It's now a 700-hour course. I think, frankly, obviously biased, but I think it's cutting edge curriculum. It incorporates things like implicit bias, procedural justice. When it comes to use of force throughout the entire training, it emphasizes communication, it emphasizes de-escalation, it emphasizes things like legitimacy. So throughout the training, throughout our work, the principled policing curriculum that I referred to, we've trained over 400 trainers. That's a curriculum developed with national experts to really emphasize legitimacy, procedural justice, implicit bias. Those 400 trainers have now trained over 3,000 police officers. And we anticipate that that number will snowball as we get more and more trainers out there. So we share your concerns for these issues, and while we're not involved in the adjudication or discipline of individual incidents, we are working every day with our local partners to really enhance the training and skill sets that are available.
Understood. So no opinion on a controversial procedure such as kettling or the use of irritants when individuals were were protesting?
Again, no, I'm not in a position to pass on individual incidents. Just say that in general, we're working very hard to, I think, given what you've described, our overall view in terms of the role that we would like to see it for police in the community and the type of interaction we'd like to see between police and community has a lot of common ground. And we're working very hard through our platform, with regard to training to make sure that that viewpoint is pushed out and emphasized.
That's fair. So to the point of the governor's plan to make sure that there's some sort of that we have the reform by April 1st. Have any agencies submitted their plan yet?
Yes, I don't have an exact number, but we are receiving plans and they're coming in faster every week. In addition, we've done outreach. And when I say we, collectively, the administration, to both municipalities and police agencies across the state, we've offered assistance. I got an email just this morning from a police agency asking for assistance. So, we know that agencies and municipalities are actively engaged in this process. We've received plans. I know other municipalities have posted draft plans for comment on websites. So it's a process that, folks across the state appear to be very engaged in.
So for those who haven't, and if they have an issue with that, from my understanding, that if they don't submit it by April 1st, there would be a monitor that would be placed. Would that be accurate?
So there's two pieces with the executive order. The executive order itself indicated that if a municipality fails to submit a plan that's been ratified or approved by the governing body by April 1st, there could be budgetary consequences, that funding could be withheld. In addition, in the governor's Article 7 bills submitted with the budget, there is a proposal to allow for the appointment of a monitor for a police department from an agency or from a locality that has not submitted a plan. That monitor would be appointed by the Attorney General in consultation with the governor, as I understand the proposed legislation.
Okay, so with the monitor, would you have any information about the role and the duty of that monitor, the extent of the monitoring period?
Nothing beyond what's in the legislation itself, and that it would be a monitor appointed by the Attorney General, presumably working with the Attorney General.
Okay, because as it is right now, is rather nebulous, and I was hoping that we could have a little more guidance about the nature of what the monitor would do. But let's say that everybody puts their plans in, and that's great. Are there plans to ensure that these departments comply with what has been with the plans that have been submitted? And if so, what are those plans to ensure compliance?
Yeah, So far, according to either the executive order or legislation, there is no role that's dictated for DCJS in terms of compliance. That said, we are very dedicated and are working every day to try and promote the work of fostering and legitimatizing police community relations. As I said, we've incorporated and are incorporated into our training. I just recorded a video yesterday that's going out to all law enforcement agencies across the state, encouraging them to engage with us and work around legitimacy. So it's something that's built into our fabric. We're pushing this and working with law enforcement on it every day.
Certainly, and I share your desire to ensure that we continue to do everything we can to bridge the gap between community and police relations. And I think some of my colleagues in the Senate will speak more about uniformity, and I'll allow them to expound upon their own ideas. But I wanted to switch briefly to the to gun violence, and you mentioned gun violence is discouraged in our communities, and it's up at astronomical rates. We have legislation that would qualify gun violence as a public health issue. Has DCJS considered that, and have there been conversations between DCJS and the Department of Health as that's related?
We have not specifically weighed in on that piece of legislation, but I can tell you that we at DCJS have viewed gun violence as a public health issue, certainly since I've been at DCJS. And I think there's no better reflection of that than the project I mentioned, where we've partnered with the Office of Victim Services and used $2.3 million in funding to provide social workers and case managers, not only to 11 of the SNUG programs across the state, so that they are embedded within the SNUG programs and working hand in hand with the outreach workers, but also in 4 of the major trauma centers across the state: Erie Medical Center, Upstate Medical Center in Syracuse, Albany Medical Center in Jacoby. That program also embeds SNUG social workers in the medical center, so that you have a direct connection between folks who go into the medical centers and the SNUG program, and a warm handoff to make sure that folks aren't lost in the process. So, we truly do view gun violence as a public health problem, and we're looking for pushing comprehensive and holistic solutions that align with that view.
Undoubtedly, and that SUV program is just outside of my district. Pastor Jay Gooding and the folks at SUV, Stand Up to Violence, do a phenomenal job, as does the SNUG program in the city of Mount Vernon and throughout the state. So to that point, $4.9 million for SNUG. I'd like to see SNUG or programs like that replicated upstate and the Hudson Valley as well. Do you believe that $4.9 million is adequate for SNUG funding?
These are tough questions, and I think I've said this for the last several years, because as you know, the problems that our communities face are huge. And if there were an unlimited pot of money, we could find good use for, all of the resources. But I think if you look historically, when I started at DCJS, the funding for SNUG, I believe, was somewhere between $1 and $2 million. And with your assistance, it's now grown to almost $5 million. In addition, we've been able to leverage the $2.3 million from the Office of Victim Services. So in total, our support for the SNUG organizations across the state exceeds $7 million. I think it's about $7.2 million. While there's always room for more, I think that's a tremendous investment that all of you have made in those programs. The programs have grown. We've been able to increase the number of programs across the state. We're now up to 12 SNUG programs. We've been able to increase the size of the programs in cities with very high rates of shootings like Buffalo, Syracuse, Rochester. We've been able to basically double the number of staff working in those SNUG programs, in addition to the staff we've been able to put in by adding the social work component. So I agree that these are incredibly important programs, and I think that the growth in the programs and the growth in the level of investment, the fact we now invest $7.2 million, and frankly, the fact that the Giffords Law Center, twice now has held our funding and support of the SNUG programs out is a national example, represents the fact that we really are doing good work in this area.
Well, thank you, Commissioner. I implore you to continue expanding. And Madam Chair, if I may, I'll come back for a second round if questions aren't already asked. Thank you for your testimony, Commissioner.
No, thank you, Senator.
Thank you very much, Assembly.
We go to our codes chair, Assemblyman Dinowitz.
Thank you. I want to get back to the police monitor because I've looked at it and to me, it's very vague. It says the monitor will be appointed by the AG in consultation with the governor to oversee, in quotes, the operations of the police agency if they fail to comply with Executive Order 203. What exactly does oversee mean?
My understanding is that the focus of the executive order is to get police departments and communities to engage in a collaborative process and develop a plan where departments and communities can build on and enhance the relationships. The monitor would be appointed if jurisdictions do not engage in and complete that process, or could be appointed if they don't. So it's my understanding that the focus of the monitorship would be around making sure that that process is in place, is moving along, and that communities and police departments are working together to really enhance police-community relationships and move policing and police-community relations forward.
So it says that the AG must consult with the governor on the appointment of the monitor. Who exactly is really appointing the monitor? Is it the AG or is it the governor?
Again, I can just go by the language of the proposed legislation. As you just indicated, it's the AG that does the appointing, and it's done in consultation with the governor.
Right. I mean, all I can go by is the language also, and the language is just not that clear. Would the monitor be expected to report to the budget director in terms of possible withholding of funds?
As I understand it, those two are separate. The withholding of funds is in the executive order, so that's already in place. The monitor is a proposal. So whether or not the monitor ultimately is passed, the funding lever exists, and I anticipate the Division of Budget would be looking at that independent of the monitor. Now, that said, if there's a monitor appointed and the monitor reports on information that's relevant, I would certainly assume that the Division of Budget would consider all relevant information around both the process, the progress the jurisdiction's making on the process, and the police community relations in the jurisdiction in making their decisions.
Okay, I want to switch gears. I want to talk about police reform proposals. The proposal says it would require law enforcement officers to comply with background check standards that include a criminal history check, a mental health exam, prior employment, and review of previous police officer misconduct. What background check standards are law enforcement agents currently required to comply with in relation to hiring new police officers?
There are no comprehensive uniform state standards in terms of background checks right now. Many departments have robust standards, but there's 550 something police departments, give or take, in the state. To give you a good example, right now, a fingerprint-based criminal history background check is not a state legal requirement in the hiring process of police officers. I think most departments do it. Accredited police departments have to do it because it's built into the standard there, but accreditation is voluntary. So what this proposal would do would be to task the Municipal Police Training Council with developing comprehensive standards that agencies have to abide by. And then, by law, agencies would have to abide by those minimum standards in hiring. They would include things like, as you indicated, criminal history background check, mental health, physical health, moral fitness, and among other things, require that check to include looking into whether or not that officer has been terminated for cause from other departments in the past.
How is information relating to police officer misconduct currently reported? I mean, is there like a central database so that it can easily be checked if somebody is applying for a job anywhere in the state?
So currently, DCJS keeps a registry of police officers and peace officers. And there is a requirement, some grounded in statute, some grounded in regulation, that departments report to DCJS when a police officer is removed for cause. Unfortunately, that process is not currently as tight as it should be. And for example, if we have real life examples where this happened. An officer was convicted after a jury trial of assault, unlawful imprisonment, and falsifying his police report in connection with the assault on a citizen while he was working as a police officer. That was reported to us as a straight resignation, and was reported that the officer had resigned the day before the jury verdict took place. Right now, under current law, DCJS is bound by whatever is reported to us. So even though we knew that that officer had been convicted by a jury in a court of this state of those crimes while working as a police officer, it went on the registry as a straight resignation and not a removal for cause. This proposal would tighten up that process so that in situations like that, where an officer A has left the department and B, it's clear from reliable evidence, like a certificate of conviction, that that removal was for serious misconduct, the officer's training certificate could be invalidated and the officer would be barred from obtaining a new training certificate. And that's another, current, hate to use loophole, but for lack of a better word, in cases where it's properly reported to us that an officer has been removed for cause right now, that officer's training certificate, again, by law and regulation, is invalidated, but there is nothing to stop the officer from going back through the academy, obtaining a new training certificate, and being rehired by another department. This proposal that the governor has put forward would bar officers who have been removed from cause and had their training certificate invalidated from obtaining a new one.
I mean, the governor's proposals will create more work, presumably. Is DCJS equipped to handle the potential influx of extra work that the governor's proposal is talking about here?
It will create more work. Obviously we have plenty of work already. There are provisions in the budget for for up to 6 additional positions at DCJS as needed to handle the extra workload. And we certainly are ready and prepared to implement these proposals if passed and enacted into law.
So this might be a little more of a specific question. Under the proposal, the commissioner would be authorized to consider reliable hearsay evidence of misconduct in making a determination to update the central registry of police and peace officers in relation to an officer who is no longer in service. How is reliable hearsay evidence defined in this proposal?
It's not defined in the proposal, but I can tell you from my interpretation, my experience, the example I gave you where we learned that the police officer is convicted in a New York State court of assault, unlawful imprisonment, falsifying a report. We get a certificate of conviction from that court affirming that, in fact, that officer was convicted. To me, that's reliable hearsay. Another piece of this proposal requires the Attorney General, and under the new Attorney General powers that take effect April 1st of this year that you all enacted last year, that give them the power to investigate misconduct by police officers. If the this proposal requires the Attorney General's office to report the findings of those investigations to DCJS. If the Attorney General made findings of serious misconduct by a police officer and that police officer was removed, a formal communication from the Attorney General's office regarding their process and their findings, again, to me, would be something that would fall under the rubric of reliable hearsay. So it's that type of information that's envisioned, a certificate of conviction from a court, a formal communication from the Attorney General's office.
Okay, I have 45 seconds. I'm going to ask you a very quick question. This may seem out of left field or right field. Suppose it was determined that a police officer of New York State took part in the coup attempt in DC earlier this month. Is there a ramification for that could be certain?
So the initial responsibility for that lies with the individual departments that employ the officers. They have disciplinary processes. Some of them have been negotiated through collective bargaining. These provisions kick in for officers who've been removed for cause. So the first part of it is removed. So if an officer were removed for participating in that event and the removal involves serious misconduct, then yes, this proposal could be implicated. But the first part of that would lie with the department in terms of the removal.
Okay, thank you very much.
Thank you. Back to the Senate, I believe. Senator Savino.
Thank you, Senator Krueger. Commissioner, I will be brief because I only have 3 minutes. I noticed in your testimony, you referenced this new training that in partnership with the Municipal Police Training Council, that you've developed this 700-hour training that now includes procedural justice and implicit bias, et cetera. Is this basic training for entry-level officers, or is it mandatory? Is it going to be required, or is it just offered to the localities? Because I've done some research and I introduced a bill yesterday and I found out that New York State has over 500 police departments. Some have statewide jurisdiction, as you know, like the New York State Police, the MTA, and most of them small villages and town departments. All 62 counties in the city of New York have multiple departments within their boundaries with possible overlapping jurisdictions, but there's no mandatory statewide minimum training standards. So I've introduced a bill that would actually replace the Municipal Training Council with another structure and develop a statewide mandatory training council to develop these types of training. So can you describe to me what you guys have worked on, and would this be a requirement for every department, for every police officer, with continuing training through the course of their career? Because from what I've found is many cops go for their initial training when they're hired and oftentimes don't have continuing training during the course of their career, whether it's in firearms training, or it could even be implicit bias training or conflict resolution.
So the 700-hour curriculum that I referred to by statute applies to municipal police departments. And currently, for example, the state police is not a municipal police department, it's a state department. There's also an exception under current law that exempts departments in cities of over 1 million. So with regard to NYPD, the governor's proposal would eliminate that language. So NYPD would be covered, and almost all of the 550 all of the 550 or more municipal police departments would be covered. That training is the basic training that every new officer who is hired has to undergo. So right now, that minimum 700-hour basic training applies to all municipal police departments with the exception of NYPD. Under the governor's proposal, it would also apply to NYPD. Departments are free to train above that standard if they want, but they have to at least train to that standard.
And this would be for new officers.
That's for new officers. With regard to continuing education for existing officers, the New York State accreditation program, and that's a voluntary accreditation, about 60% of the officers in the state outside of New York City work for accredited programs. Any accredited agency, those officers have to have 21 hours per year of continuing education in order for the department to maintain their accreditation. But there is no legislated state standard for continuing education right now, with the exception of a supervisor's course. There's a legal requirement for municipal police departments that anyone being promoted into a supervisory role take the basic course for supervisors, which is also a curriculum set by the Municipal Police Training Council.
Thank you. Time's up.
Thank you, Assembly.
We go to Assemblywoman Walker.
Sorry. Good afternoon, and thank you so much. I have two questions. I do want to associate my comments with my colleagues in the Senate who've spoken before, as well as our chairman. But one of the things that I noticed, again, to follow up on Senator Bailey's notion with respect to SNUG and cure violence programs. So I was combing through to attempt to find where there is an association of the rise in gun violence. And I see that you said there's a 75% uptick in shootings and an 85% uptick in gun-related homicides. However, the budget request or item for SNUG-related resources stayed at 4.9 million, which does not work with the rash of gun violence that we've been working on. So I just wanted your thoughts on the idea of maybe being able to push for more resources as commensurate with the rise in crime that we've been experiencing. And also just had a quick question about marijuana arrests, incarceration, and people who are presently on parole. Is that information kept with the Department of Criminal Justice Services as it relates to, as designated by race in terms of the impact of marijuana arrests, incarceration, and parole?
So 2 questions, if I understand it. I'll try and answer both of them. And thank you for the questions. I appreciate them. First, as to funding, I think, as I mentioned before, you have to keep the historical context in mind here. And I think we've greatly increased the funding for programs like SNUG over time. With that Office of Victim Services investment, we're up to $7.2 million in funding for our SNUG programs. If you look at states across the country, I think that level of funding dwarfs what most other states do. And I think that's why we've been recognized nationally for our investment in these programs. I think that as important as spending money on programs is making sure that we're spending that money smartly. And DCJS has been very focused on using, for example, Burn JAG funding and other funding to augment the money in the budget for those programs. And so in addition to the money we provide for municipalities, we spend money out of things like Burn JAG to provide training, to provide technical assistance, to provide support. We've managed to incorporate into the DCJS budget over the years money for a statewide director for the SNUG program, money for a statewide training director. We have a statewide director for the social work program. We've written our own training programs for both the social work and other side. So the investment is growing. In addition, there's $5 million that can be used out of the discovery and pretrial funding, at least proposed for this coming year budget, to address gun violence. In terms of the marijuana, we have statistics on our website broken down by race and ethnicity. If you want specific information with regard to marijuana by race and ethnicity, we do have that. And if you reach out to our office, we'd be happy to get it for you.
Awesome. So please do send it to me, but also please put it and associate all of that with respect to any conversations regarding the taxation of marijuana here in the state, because of course, my district and particularly communities of color all across the state have been overly policed and overly affected by marijuana arrest, incarceration, and parole. Thank you.
Thank you, Assembly Woman. Back to the Senate.
Thank you. We've been joined by Senator Cooney, but our next senator to ask questions is Senator Reichlin Melnick.
Thank you, Madam Chair. So Commissioner, thanks for joining us today. I wanted to ask you a little bit about the Securing Communities Against Hate Crimes grant program. This is a program since 2017 that has provided funds to improve security at religious organizations, including nonprofit daycare centers, community centers, and residential and day camps, and protect them from hate crimes. So the current 2020-2021 budget that we're on now included $25 million for these grants, but I understand that there has not been a request for proposals put out yet by DCJS. Do you know when DCJS is planning to put out an RFP?
I believe you're correct in terms of the timeline and the information. We've been working with the Division of Budget and Homeland Security. It's my understanding that Homeland Security is still working on the prior round of funding. And when that's complete and done, we'll be prepared to move forward with the next year's funding.
And so with regard to those funds from 2019 and 20, do you know if that was fully expended? Have those contracts been paid out, or it sounds like they're still in the works?
That is Homeland Security. The 2021 was the first year it was moved to DCJS. So it's my understanding they're still actively working on that round of funding, but I'd have to defer any other questions to Commissioner Murphy.
Okay, I appreciate that. I mean, this is just because we're seeing this sort of rising tide of right-wing extremism in the country. And so there are a lot of places of worship, especially that may feel threatened. And I think it is important that we get the money out the door if we've got worthwhile recipients here who need these funds to help keep their congregations safe and help keep schools safe and other places like that from violence.
No, I certainly appreciate your concern and can assure you that we have been working on this since the budget passed last year, and we're working closely with Homeland Security. So as soon as it's ready, we'll be ready to go.
Do you know why the program was shifted from Homeland Security over to DCJS?
I do not. It's my understanding that the appropriation may have changed slightly. It may have expanded slightly to include additional grantees. So, it's possible there's some thinking that DCJS, had more expertise with regard to those grantees, but I can't say for sure why it shifted.
And I guess I'm also just finally want to note, I'm quite concerned because I understand in the current budget proposal from the governor, there is not additional funding provided for this for the next budget year. And that concerns me. I just want to know if you have any idea why are we cutting back on funding again at a time when there are more threats and the FBI and Federal Department of Justice are identifying rising threats to minority and religious communities with extremist actions?
Well, I can't directly address the question. I do know that this funding has been made available for many years. I think this might be the fifth. Last year's money may have been the fifth year, if I'm not mistaken. So there have been significant amounts of funds made available, but I can't directly answer.
All right. Thank you very much for your time.
Thank you.
Thank you. Assembly.
We go to Riley.
Thank you, Madam Chair. Good afternoon, Deputy Commissioner. Thank you so much for your testimony. I actually wanted to raise a couple of questions. I'm just going to read them off to you, and hopefully you can comment on them. The first has to be about raise the age. I was wondering if there's any data that DCJS has in regards to raise the age and the impact of cases that have gone to family court. And I didn't get a chance to mention this with the court administration earlier, but I was hoping that maybe you can nudge this a little too. It's in regards to that question. We were waiting for Staten Island to get upgrades to our family court building. And I think this would be, there's supposed to be some funding that's been in place since 2017, and it hasn't been allocated yet and hasn't moved forward. So I'm hoping that you can nudge a little on that. And the second part that I wanted to ask about was about the legalization of the potential legalization of marijuana. With my prior experience in the NYPD, two of the concerns that I really have is the driving while impaired. And I know that there's no real testing right now. So I'm hoping that we can incorporate a DRE type program. And I know that it's very expensive to train those officers. Just to put it into perspective for my colleagues and anyone that's listening, New York City has 35,000 police officers approximately, and there's only 16 DREs, drug recognition experts, covering the whole city. But that's for anyone that's actually under arrest for driving while under the influence. So then that the testing would be done afterwards. I'm looking for something that would be more along the lines of on the street recognition. The NYPD has a program operated by Sergeant Snyder and Police Officer Kessler from their highway unit that does a modified DRE program. It's a 4-hour class that I think would really help if we are really going to potentially legalize adult use marijuana. It should be done in a responsible way, and that's part of the issue. Some of the other things that I have concerns about is the black market trade on the street. One of the first homicides that I dealt with as a rookie sergeant in East Flatbush was a young 16-year-old man who was shot in the chest and succumbed to his injuries. I was leaning over him as he passed, and I found out that later on that it was in connection to a weed location, a marijuana location, a fight over turf. So these are the things that we really have to address and be mindful of. The other thing is under 21 driving with marijuana. Hopefully that we can coordinate with the Department of Motor Vehicles to ensure that anyone under 21 that operates a vehicle while under the influence will have an administrative hearing and potentially lose their license for a suspension like they do with alcohol. So thank you so much for listening. And if you can get back to me with those answers, because I think my time is up.
I will do that. And we do share a common background. I spent 22 years prosecuting homicide cases.
Thank you, sir.
Back to the Senate. Do you have anyone else?
We do. Thank you, Assembly Member. We have Tom O'Mara, the Ranker in Finance.
I'm not sure if he's with us right now.
Oh, okay. Well, I thought we had Tom O'Mara. Then I'm going to jump to me. I only have a couple of questions for you. So obviously, you know that down in New York City, where I'm from, and many of us are from, there's been quite a bit of disagreement about different policies of NYPD and reform of police, and even getting our arms around what you do when something bad happens. So apparently there's a new proposal about implementing new policies with the Civilian Complaint Review Board, and I'm curious whether you've had a chance to review that and what your opinion is.
It's my understanding, if I'm understanding your question right, those are local proposals dealing with city council. And I have reviewed them. It's not something I can weigh in on.
Okay. But you would agree this is a continuing hot topic for everyone who's running for mayor or city council or DA in the city?
I think not only is it a hot topic, but there's research that's been established for over 30 years now. I think the main body of it coming from Tracy Mears and Tom Tyler out of Yale. But if you don't have legitimacy, and if you don't have trust between police departments and law enforcement, and frankly, the criminal justice system in the communities that they serve, you're not going to make significant headway with regard to crime. So, it's a crucial issue. If we want to have safe communities, it's something we need to focus on.
I agree with you. Thank you. So for about 18 years now, I've been voting against every peace officer bill that comes before me in the Senate, mostly because I can't figure out what the heck everyone thinks the training and qualifications for these people would be. I just know that at the end of the sentence is always, if you figure out how to get them to be a peace officer, then they'll have a gun. So in your new envisionment of 700 hours of training to start being a police officer anywhere in the state of New York, where would peace officers fit in this world, or do they?
There are separate minimum training standards for peace officers. And I don't know the exact hours, but it is not 700. It's many hundreds of hours less than that. And it's my recollection that there are two separate training standards for peace officers, one for peace officers, and then a second one for peace officers who wish to carry firearms. And that training program has minimum standards above and beyond the peace officer program. But that's a separate program that's not as rigorous as the 700-hour curriculum for police officers.
And do you have concerns about people with less training somehow having what's perceived of as police authorities and the ability to carry a gun? I know with some of the bills over the years, it's been the right to chase in a car suspects, the right to search and seize without warrant, et cetera, et cetera. I mean, doesn't it surprise you that we would have all these different standards for all these different people all over the state?
I think your question, really focuses on the issue, and that is that people need to be aware of when you give someone peace officer powers, it means one thing, and there's a certain minimum level of training that goes along with it. And when you give someone police officer powers, it means something different. And there's additional responsibilities and powers that go with it. There's additional training. And to your point, yes, I think we need to be very thoughtful about who we're giving peace officer powers to and who we're giving police officer powers to, because those powers, are significant, they're different. There's different levels of training, and I think you're right to focus on that.
Thank you. Assembly. Maybe not. Let's see, where did Helene go?
I do believe we have Assembly Member Rob next on her list.
Thank you so much.
Thank you.
Voice for heaven, yes.
Thank you for being here today. I just had a few questions going back to, you mentioned in your opening remarks something that I think we're familiar with. Many of the large cities in the state have had, really remarkable increases in murders, in gun crimes and shootings, and it's alarming. And I'm just wondering if you have, any thoughts as to what may be causing that, given that, we have overall, you mentioned crime being down. We had months of last year where people were largely, in their homes because of the pandemic, yet we see these, these data points, and they're very alarming.
So I don't know that I can opine directly on what's causing it, but I think I can share some relevant data points that may help. First of all, I think it's very important to keep this in context. Well, shootings and gun-related homicides are up, and homicides are up. The last 3 years have been historic lows. We topped out at about 2,600 homicides a year in New York State in the early 90s. The last 3 years, we had less than 600 a year. We had about 550 a year. So when we say they're up against our all-time historic low. I think we're going to come in somewhere between 800 and 840 homicides for the year when we collect the data, which is a terrible increase from our historic low last year, but still substantially below, what we were experiencing in the early 90s, when I was a line prosecutor prosecuting homicide cases. So I just think it's important, first of all, to keep that historical perspective. Secondly, when we look at what's happening, overall crime in 2020, reported index crime is about flat. The one place we're seeing, places we're seeing increase is violent. Crime is about flat, but firearm-related crime is up, shootings are up, and firearm-related homicides are up. So when you look at, what's driving that, one important thing I think is to look across the country. It's not just New York State that's experiencing this. We see similar numbers in major cities across the country. And then secondly, when you look at, again, what's driving it, is it, people ask, is it the reforms we passed? Is it, something else? We're not seeing it, bail reform, for example, really focused on misdemeanors and nonviolent felonies. It made the biggest change there. We're not seeing any movement in that regard. We're just seeing it in the firearm-related crime. And so I think looking at things like COVID and the impact of COVID, looking at George Floyd and the issues around racial inequality, to me, that correlation at this point seems to be stronger, but I think we're going to need more time, frankly, to look at that over time and really draw any solid conclusions.
Yeah, and I mean, I think, I'm sure you recall last year, this hearing, there was a lot of talk about bail reform and things like that. And we were fairly early in the year, and there were some, statistics out there that were showing an uptick, and kind of, it was like, okay, well, let's wait and see when we have full data. Obviously, the world has changed in tremendous ways since then with the pandemic and a lot of other things that have gone on. So thank you for that answer. It's just, it is alarming, those numbers in and of themselves. And then when you add to it some of the proposals in this budget that are, reducing crime prevention and reduction programs, and certainly this potential for municipalities to lose money for policing is a concern, given that these alarming increases. The one other thing I wanted to ask you about, I don't know if you could shed any light on this within the department, but one of the things we talked about a lot in the regard of the criminal justice reforms was discovery last year. And if you know anything about how, there was this funding that was put in and what is going on with that, and whether the funding is going out the door or was subject to any of the withholdings that went on to try to balance the budget due to the revenue shortfalls.
Sure. So just to clarify, DCJS local assistance funding has not been cut. In fact, DCJS local assistance funding has been increased, and the increase is due to the Discovery Fund that you've referred to. But our other programs have remained flat, in the face of cuts elsewhere. In terms of the Discovery funding, 1.75 million of that was awarded to the New York Prosecutors Training Institute to support their DEMS system, which all the prosecutors' offices across the state can use for discovery. And award notices went out to the 57 counties outside of New York City just recently, giving them their award allocation to support both discovery reform and pretrial services.
Thank you.
Thank you. Senator Brad Hoylman.
Thank you, Madam Chair. Nice to see you, Commissioner. In 2020, we passed the Police Stat Act, the Police Statistic and Transparency Act, which among other things is going to require law enforcement, every law enforcement department in New York to promptly report any arrest-related deaths to DCJS, disaggregated by county and including demographic information about the race, ethnicity, age, and gender of the individuals who die in arrest-related deaths. Prior to the passage of this, DCJS, according to your website, identified the majority of the arrest-related deaths in New York through reviews of news articles. The law enforcement reporting requirements took effect in December. Have you seen compliance with the law so far?
We have seen compliance. This reporting is kind of going parallel with the use of force reporting that is kicked in as a result of the new legislation. And we are getting data and reports from law enforcement agencies with regard to both of those.
Thank you. And under the law, DCJS is going to be required to annually report that data to the legislature and to make the data available to the public on your website, updated monthly. Is DCJS prepared from a technology standpoint to make that data available on your website? And if so, when can we expect it to be available?
Yes, we're actually working right now on trying to, I guess, for lack of a better term, clean the data. We're working with departments to make sure it's reliable, make sure, for example, incidents weren't double reported. But we do anticipate that by March, that data will be up on the website.
Thank you so much. It's good news.
Thank you. It's good to see you.
Great. Thank you. Yes, Helene?
Yes, we go to Assemblyman Tanusis.
Yes.
Hi, Commissioner. Thank you so much for joining us. One question I want to ask you is, will you be able to tell us how many individuals in New York State are incarcerated because of marijuana-related offenses?
I cannot give you that figure off the top of my head. There's both inmates in the State Department of Corrections. There's incarceration in local jail facilities. So, I couldn't give you a figure.
Would you be able to look into that for us as regards to the state, obviously, state detention facilities?
As to the state facilities, and I don't want to put them on the spot, but I would suggest that Commissioner Annucci from DOCS might be in a better position to give you information on who's in DOCS right now. But we can certainly work with Commissioner Annucci to get any information that would answer that question to you.
Thank you. Thank you very much. I appreciate that because obviously this is an issue, recreational marijuana is an issue that's coming up, and obviously we want to have those facts and figures so we can make that determination adequately. So thank you very much for your time.
Thank you.
So next we have Assemblyman Palmisano.
Yes, thank you, Commissioner. I have a few questions for you. First, we a lot of talk about bail reform and the concerns that many of us have raised on that issue. Do you keep statistics in regards to that? Do you keep statistics on the number of individuals who commit crimes who have been released without having to post bail or have some type of pretrial supervision assigned to them?
So the data that we are keeping in connection with OCA is what was required in the statute. The statute set out requirements for what OCA and DCJS need to collect. And as Judge Marks testified to earlier, by statute, OCA's first report on that data is due in July of this year. DCJS's first report is due in January of next year. And we've been working hand in hand with OCA and fully anticipate that both entities will meet those deadlines. In fact, I think what I anticipate you'll find is that we'll be posting the same data on both the OCA and DCJS websites that satisfy all of the requirements in that statute.
All right. I think one of the other issues along with that is, will that also hopefully include individuals who are released on pretrial supervision on their own recognizance that, data as far as people who didn't show up for their trial hearings? Would that possibly be a part of those numbers?
Yeah, I would have to go back and look at the statute and see exactly what the reporting requirements are. But I can assure you that everything that the legislature put in that statute in terms of reporting requirements, we will have and will have posted publicly.
All right, thank you. I have a couple other questions relative to the New York State Police reinvention collaboration. It's we obviously understand that departments who fail to comply with this order risk losing state funding, as well as there's a proposed directive which requires monitors to be installed to oversee the operations of these departments at their own expense. Do we know to date how many departments fall under this order and how many departments have not complied with this order as of yet?
I believe it's somewhere in the neighborhood of 550 departments that fall under the order. And that's a rough number, but close. We've been in communication and I've yet to have any department tell me we're not going to make it. We're working with departments, as I indicated just this morning. I got a question, so our goal is to help all departments, and we hope that there's no department that doesn't have a plan in with their municipality by April 1st.
Thank you. As far as the holding of the funding, could this also apply to federal grants that flow through the state? And I guess the other, on top of that, with the violent crime that we're seeing that's happening right now in our communities, is it really a good idea for us to be withholding any funding or threatening to withhold any funding that can help protect our local communities?
So in terms of the details of what funding, I would have to defer to the Division of Budget, since they're the entity that's named in the order, in terms of the funding end of this. As I said, our goal is to make sure that we work with departments and that no department falls into that category. In terms of our major urban centers where we're seeing the increase in shootings, my understanding from our communications with them is that all of those municipalities are working hard on this and are on track to be done, by the April 1st date.
Okay, thank you.
Okay, Assembly continuing.
Assemblywoman Kellis. Thank you.
It's amazing. The technology is still, I can't seem to put the video on. I'm being asked, but lovely, wonderful. Thank you so much for this presentation and the long explanation of all of these. I'm new, so I apologize if this question is very basic, but I was going through and looking at the local assistance reductions and eliminations, and I'm pretty sure that the prisoner legal services and the New York State Defender programs are in that. I know you've worked closely with those. I'm just wondering how those programs are going. If we have any data of the impact of those programs, any information would be great to hear.
So I don't have data offhand on how those programs are working. They are both programs that have received funding through DCJS. And so you said the Defenders Association and Prisoner Legal Services?
Yep.
Yeah, so the Defenders Association in the governor's proposed budget there's a $1,030,000 allocation. The prisoner legal services, there's a $2.2 million allocation. It's my understanding that both of those sums are the same as in the governor's budget from last year, that they haven't been increased or decreased in terms of the governor's budget proposal. And again, while I don't have data, we've been working with both of those entities for the 9 years that I've been at DCJS now, and I have a very good working relationship with them in terms of the funding end of things.
That's wonderful. Can you describe maybe some of the other programs? This was an elimination of 16 million in the general fund, provided grants to localities and nonprofits. So I was curious what other programs might be in that category.
Again, as to the budget or the governor's proposed budget, my understanding is that there are no items that the governor proposed last year that were enacted as part of his proposal that were cut. All of our funding, for example, the aid to probation, we do about $25 million in funding to alternative to incarceration programs, about $44 million in funding to probation departments, about $14 million in funding to gun violence elimination efforts. As we indicated, a total of about $7 million to SNUG. All of those local assistants that were part of the governor's proposed budget or the executive budget last year, it's my understanding that those are all fully funded in the governor's proposal this year.
And two really quick questions. I heard a conversation about SNUG earlier. I'd love to hear about plans of expanding extensively upstate. And the other is, has there been any state support or discussion about promoting law enforcement assisted diversion programs or LEAD programs?
So with regard to SNUG, we currently support SNUG programs in Buffalo, Rochester, Syracuse, Albany, Troy, Poughkeepsie, Yonkers, Mount Vernon, one in Hempstead, one in Suffolk, and one in Newburgh. So we are very heavily involved in upstate New York with SNUG programs. In terms of LEAD, we did work with Albany in their attempts at running a LEAD program. We did pay for a research component to that program for several years so we could get feedback from a data perspective. It's not something, at least in the way it's operated here in New York so far, I haven't seen data showing that it's had the type of impact that I think you or I would want it to have. So we have not invested heavily in LEAD to this point.
Thank you.
That being said, I certainly agree with the idea of trying to find ways to keep people who don't belong in the criminal justice system out of the system and connect them to support systems, that could be far more helpful.
Thank you so much.
Thank you. Assembly
Thank you. Now
continuing.
Yes, we go to Assemblywoman Raj Kumar.
Thank you, Chair Weinstein, Judiciary Chairman Levine, and thank you, Deputy Commissioner Green, for your testimony this afternoon. I want to use my 3 minutes to engage you on issues of underrepresented immigrant communities and their interaction with the justice system, specifically around hate crimes. My first question is on hate crimes against a particular subset, South Asian American immigrants. South Asian immigrants here in my district in South Queens and around the state and the country have been targeted for hate crimes. These include hate crimes against Sikh Americans who wear the traditional turban and Bengali Americans. Do you anticipate any items in the budget that will combat hate crimes against this specific underrepresented immigrant group? I see the governor's 2021 budget includes $2 million in support of the Hate Crimes Task Force, first established in 2018. And in fact, before I was an assemblywoman, I worked as Director of Immigration Affairs for the state. And I remember when that task force was created. Do you foresee, or is it possible to explore possibilities for that task force to engage South Asian communities? And you mentioned the governor's Executive Order 203 requiring the local police to engage community leaders in a process to reform the police and how they serve their communities. So what are your thoughts on how to engage immigrant communities in that process? And where might the opportunities lie for collaboration?
So first, thank you for the question. I think there is data to support your concern. Well, generally speaking, in 2020, we did not see an increase. In fact, overall, we saw slight decreases in hate crime. In New York City, and the data is preliminary at this point, but we did see a rise in hate crime specifically targeted against Asian populations. Upstate, again, very preliminary data, we saw a rise in hate crimes targeted against Blacks. So I think there is a basis clearly for your concern. In terms of the governor's budget continues to provide the funding to DCJS that we need to work with the Municipal Police Training Council and our local partners on training around these issues. As part of the revamp of the basic course that I talked about, we worked with the Anti-Defamation League, we worked with others to really beef up the hate crimes training section so that every new recruit will have an up-to-date and thorough hate crimes training component. That component that's in there can also be used by individual departments as an in-service training on hate crime if they want it. So we continue to be engaged with our partners in terms of training around hate crime and trying to support entities. And then the last piece of your question, certainly it's envisioned when under the governor's executive order, when departments and municipalities are asked to engage with communities, that immigrant communities would be included in that engagement.
Thank you.
Thank you. Next to Senator Jeremy Cooney.
Thank you, Madam Chair, and hello, Commissioner. It's good to see you.
Good to see you again.
Long time no see. As someone who's from Rochester and of course served as our district attorney, you're well familiar with some of the challenges and issues we face in Rochester with policing, specifically in Black and Brown communities, many of which I represent in the 56th Senate District. My question to you is going to be framed in the lens of our new Senate Committee on Cities 2, which is focused on upstate New York cities, specifically the Big Five. And when it comes to diversity in law enforcement, both in policing and in the district attorney's office, it's something I know that it's not unique to Rochester, certainly, in struggling with. But I do wonder if you have some experience based on your time, not only in Rochester, but in the state of New York, talking with other states across the country on how they have been successful with diversifying our law enforcement divisions. Because I believe truly that if we want to have a more just system that works equal for everyone, I believe that law enforcement should reflect the communities in which they serve. And I would appreciate your thoughts and any examples or specific opportunities that we could do some more research on. Thank you.
No, I certainly agree. Thank you for the question. We definitely want police departments, as we do all of our other institutions, to reflect the communities that they serve. And frankly, I think they would be better, any institution is better at doing their job and better able to serve the community if they are. We are continue to work with groups like the IACP and others to make sure that we are up on, what others around the country are doing. As you know, this is a very challenging topic and not one that there's an easy solution to. You mentioned the Rochester Police Department, and they have been under a court order, out of federal court for years around this issue, and yet, it still remains a very difficult issue. The governor's proposal, among other things, does look to standardize hiring practices and require the Municipal Police Training Council to do work and put out guidelines around standardized training practices. And if that's passed, we certainly envision that one part of that work would be to make sure that those hiring practices take into account the desire to have diverse police departments and are reflective of that goal. So I think in terms of the governor's budget proposal and current work, those would be the highlights I'd point out.
Commissioner, I appreciate that. And I do have a bill that I've entered into the Senate, which would specifically work with the big 5 cities and address a long time question about police residency. And, begin to have those conversations, because I do believe that making sure that dollars are staying in the communities and that people feel invested in those who they are protecting really does matter. So we'll take a look at what you have in the budget, and I appreciate your time today, Commissioner.
Thank you.
Thank
Thank you. So we go to Assemblyman Bronstein, and then after that will be Assemblywoman Burns.
You there, Ed? Put your mute off.
Okay, thank you. Sorry about
Good.
that. Forgive me if someone asked you this question earlier, Commissioner. We've been going back and forth with different things today. My question is about Executive Order 203, the Police Reform and Reinvention Collaborative Plan with the localities. I guess I have 2 questions. My first question is, it requires localities to submit and to put together a plan and then certify it and then submit it to your agency. Once a plan is submitted, is there any kind of evaluation after that to see that it's acceptable, or has the locality met its obligation just simply by submitting a certified plan?
I'll have to go back and look at the executive order again, but my recollection is it required the submission to the Division of Budget. Certainly that said, we intend to review all the plans, but at least as of now, my understanding is if the plan has properly been ratified by the local municipality or governing body, that satisfies the requirements.
Because it doesn't really speak to it in the executive order. And my question is, if a locality, let's say the city of New York submits a plan, it's certified, it's put together, is there an opportunity later for the Division of Budget to withhold funding based on, some kind of subjective evaluation of the plan that they don't agree with?
And that's something you'd have to direct the Division of Budget. I can't speak to that, I'm sorry.
And do we know what kind of funding it could be withheld from a locality if they don't meet the requirements?
Again, that's something the Division of Budget would have to speak on.
Okay. Have you had conversations with the city of New York about their plan and how they're moving?
I personally have not had conversation with the city of New York, but I know, it's a collective process between DCJS, the Deputy Secretary's Office, the Budget Division, and others. And collectively, we've spoken with every jurisdiction.
Okay. All right. Thank you.
I think
Thank you. It's Assemblywoman Marge Burns. Mike Green, how are you, sir?
Good. How are you? Long time no see.
I was going to say the same thing. I have just one question for you. It may spring to a couple others, but we only have 2 minutes and 45 seconds. But look, we all hope and expect that our police departments are going to be submitting plans that meet all of the new procedures by the deadline that's been established. My question is, if a police department submits and operates under a plan that they think in good faith satisfies the objectives of the state and what they believe satisfies the requirements, but yet later on down the line, the state for any reason believes that their plan is inadequate, are they still going to be penalized? As long as they're operating in good faith and doing their best?
Ultimately, it's the budget director is going to make those determinations. And I can't speak for the budget director, but what I can say is the intent here was to simply try and make sure that police departments, municipalities, and communities engage with each other in an effort to move relationships between police departments and community forward. And certainly I would hope to the extent that municipalities and police departments have done that in good faith, I wouldn't expect that there would be any consequences for that.
I trust there's some expectation that because our communities can be so different, from a village I live in that only has 2,200 people and basically 2 full-time officers, to a larger municipality, that they deal with such different types of complaints and people that live within the communities, that I would hope those types of factors are taken into consideration as plans are evaluated.
And I believe that that's the reason why the executive order was crafted as it is, to have the approval process being done by the local governing body. So that in the village you talked about, there's a village board made up of folks who are representative of your village, and they can pass on whether or not that plan is appropriate for the village, which may be very different than the city of Rochester, who has a city council who can pass on Rochester's plan. So, my understanding is that the executive order was crafted that way to take into account the exact things that you raised there.
All right. And then again, my only fear, which I hope doesn't become borne out, is that somebody will play armchair quarterback and decide that plans that are approved ultimately aren't satisfactory. And I'd hate to see for any reverberations on the back end when they are operating in good faith.
No, thank you. I understand and appreciate the concern.
Thank you, sir. Take care.
Thank you. Oh, thank you. Back to the Senate to close.
Yeah.
Yes.
We have no more.
You have no more. That's what I thought. Thank you. Okay, to close for the Senate, the chair of our Codes Committee, second round, 5 minutes, Jamal Bailey.
Thank you, Madam Chair. And Commissioner Green, again, this won't be long at all. This is just related to the Article 7 proposal about the creation of the crime of the new domestic violence crime created in this new Article 7. I just wanted to know what DCJS's opinion on this, and will it help to I guess I'll let me take a couple steps back, right? During this pandemic, we've obviously seen an increase in stats related to domestic violence. I just wanted to know, will this Article 7, in your opinion, and the opinion of DCJS, help to stem the tide of some of these domestic violence related offenses?
So the proposal you're talking about is the one to create the new crime of misdemeanor crime of domestic violence.
Correct.
The intent is that certain convictions for crimes of domestic violence are supposed to result in a disqualifier for someone purchasing a gun. Currently, though, in order for that process to take effect, in addition to someone being charged with a crime, the district attorney has to file a certificate alleging that it's a crime of domestic violence. In addition to adjudicating the criminal case, the court has to hold a separate hearing to determine whether or not it's a crime of domestic violence. And then if in fact a finding is made, not only does a conviction have to be transmitted to DCJS, but the results of that separate hearing have to come to DCJS. And if for any reason, those things don't happen, the DA doesn't file the certificate, the court doesn't do the hearing, the result doesn't get transmitted to DCJS, someone with a qualifying domestic violence conviction can still go out and purchase a gun. This is an attempt to close that loophole. It will not criminalize any new conduct. So anything that's criminalized under this proposal would already be a criminal offense. It will simply eliminate the need for filing that separate certificate, having a separate hearing, and having 2 pieces of information conveyed to DCJS instead of 1. When this new crime is charged, the element will be the existing underlying crime plus the domestic relationship. It can all be heard and adjudicated within the course of that single case. And if there's a conviction, that gets sent to DCJS and there's an automatic disqualifier. So, our understanding right now is that there are more qualifying convictions than orders that we're receiving. So there's basically a disconnect there. And this would close that disconnect and keep convicted domestic abusers who shouldn't have guns from being able to buy guns.
Okay, and thank you for that answer. And just my final question to close. And to your knowledge, have there been conversations with advocacy groups as related to domestic violence in the formulation of this proposal?
So I think, yes, there have been conversations. I think there've also been conversations around some of the broader proposals like expanding the scope of the Office of Prevention of Domestic Violence to include gender-based violence. There've been conversations around streamlining the application process for resources for not-for-profits, that go to different state agencies, so there'd be a more common platform for that application. So in general, yes, I think both the Office of Prevention of Domestic Violence and the administration generally has been very engaged with the domestic violence advocacy community here around these proposals.
Okay, and my final question, sometimes I'm sorry, I'm an attorney too. So as related to ceiling, you spoke about the ceiling of convictions. There are some bills being proposed, like to greatly expand our ceiling statutes and actually give us a actual expungement in New York State. Does DCJS have an opinion on either the legislation or the concept of expansion of ceiling?
So for the sealing that we've done, as I've indicated, we sealed about 3.2 million records. There was marijuana, low-level marijuana convictions, low-level historical offenses like disorderly conduct, and things open for more than 5 years. That left 800,000 people with clean records. Those types of things we support. Currently, we're working on the legislation that was just passed and signed into law, which will seal convictions for loitering for purpose of prostitution. So we're engaged right now, making sure we carry that out. And so those types of sealing or expungement that you referred to, we certainly support. And are working very hard to make sure we carry out everything that's enacted.
Excellent, thank you. New York has deserved to have a clean slate to be able to move forward. And I thank you for your time and for your attention to these questions. Thank you, Commissioner.
Great. Thank you very much. I think,
Thank you.
Commissioner, we are done with you for today. Thank you for spending your couple hours with us, helping us to understand your agency and your budget.
No, thank you. It's always a pleasure to see everyone. Appreciate all of your support.
Thank you. And our next acting commissioner, Anthony Annucci, New York State Department of Corrections and Community Supervision. And just before he starts, the chairs for this commissioner are Julia Salazar and Assemblymember Weprin. And the rankers are Senator Akshar and I believe Assemblymember, the ranker is a replacement. Am I correct?
Yes, it
Yes.
will be Assemblyman Palmisano.
Correct.
Thank
For
you.
5 minutes. Thank you.
Okay, when we get there, good. And then I believe people saw the note that Assemblymember Weinstein needs to run out for something else. And so I'll be shifting back and forth between the Assembly and the Senate. So please raise your hand if you have a question. And when I get your name wrong, Assembly members, I apologize. You can blame me later. So with that, Acting Commissioner Annucci, who I think has been here in Albany as long as I have, but is still an acting commissioner, right?
That is correct.
Okay, welcome. 10 minutes
Thank
on the
you.
clock.
Thank you, Senator. Good afternoon, Chairwoman Kruger, Chairwoman Weinstein, and other distinguished chairs and members of the legislature. I am Anthony J. Annucci, Acting Commissioner for the Department of Corrections and Community Supervision. It is my honor to discuss some of the highlights of Governor Cuomo's executive budget plan. Since the governor took office, the incarcerated population, now under 33,200, has decreased by more than 22,000, marking the lowest total since 1984 and representing a 54% decline since its all-time high in 1999 of 72,773. More significantly, the total population reduction since January 1, 2020 exceeds 11,000. Even with these drastic reductions in incarceration, New York proudly remains one of the safest large states in the country. With this significant reduction in populations since 2011, the state has safely eliminated excess capacity through the closing of 18 correctional facilities without laying off workers, while achieving $292 million of savings for taxpayers. This year's closure process is underway with the transfer of staff to vacant positions at other facilities or offices, while the incarcerated population is transitioned into vacant beds elsewhere. Based on the continued decline of the incarcerated population, we anticipate additional facility closures in the upcoming 2 fiscal years. Over the past year, COVID-19 has plagued our nation and state. The department was not spared from the effects of COVID-19. Accordingly, last March, I convened a multidisciplinary COVID-19 task force to guide our comprehensive response. During this pandemic, there have been many heroes along the way. Our essential workers, including corrections and community supervision staff, came to work every day and consistently carried out their professional duties in an exemplary manner, oftentimes going above and beyond their traditional responsibilities. I am very proud of the dedication and sacrifice staff have displayed throughout the duration of the COVID-19 public health emergency, and thank them for their continued great work. Incarcerated individuals also help to support and protect fellow New Yorkers with the production of nearly 11 million bottles of hand sanitizer of various sizes, over 89,000 protective gowns, and almost 2 million face masks. As the governor has pointed out, our path forward is to continue testing and vaccinations. We have begun the process of vaccinating our staff and the incarcerated individuals in the system who are 65 and older, consistent with statewide guidance for that age group. Under the direction of Governor Cuomo, the department has also leveraged existing laws that allowed for the early release of 3,555 nonviolent, non-sex offenders, which included 791 low-level parole violators from local custody. The department decommissioned over 3,000 top bunks, greatly reducing density within dorm settings, and followed CDC and DOH guidance to help reduce the spread of COVID-19. We also modified policies and procedures in community supervision that have drastically reduced the issuance of technical warrants. Despite the pandemic, there are many accomplishments in 2020. Last year, the governor successfully advanced legislation to remove all individuals under the age of 18 from DOCS and to send adolescent offenders to the Office of Children and Family Services. This transition was successfully completed. In 2019, the governor, along with the leaders of both houses, jointly agreed to further overhaul segregated confinement through administrative action. DOCS issued and adopted regulations after a thorough review of the public comments. Leveraging the $69 million capital funding allocation, necessary infrastructure upgrades to develop residential rehabilitation units are underway, with several becoming operational later this fiscal year. The regulations further restrict the number of infractions that can result in a disciplinary confinement sanction, among other things. When fully implemented, these reforms will restrict the use of segregation for vulnerable populations and cap the amount of time someone can spend in segregation. Through the ongoing reforms, I am confident we will successfully provide incarcerated individuals with the services and treatment they need while continuing to keep staff, the population, and visitors safe. Lastly, the Board of Parole, in consultation with the department, adopted regulations that improved the standard conditions of supervision and modified the parole revocation process, advancing both alternatives to incarceration options and shorter periods for reincarceration when necessary. In conclusion, while we will continue to tackle the many challenges posed by COVID-19, we will simultaneously explore additional means to further leverage technology for the delivery of programs and the advancement of safety, both inside our facilities and within our communities. We cannot ignore the overall safety of our staff and the security of our facilities and offices. They remain a top priority for the department. Our professional, well-trained, and dedicated workforce who perform their responsibilities in a highly commendable manner, often under dangerous and difficult circumstances, will continue to be our best resource as we meet our mission. The governor's budget positions the department for success while continuing to address the dramatic decline in the population to the benefit of the entire agency, as well as the taxpayer. Thank you, and I will be happy to answer any questions.
Our first questionnaire will be Senator Julia Salazar, the new chair of Crime Victims and Corrections.
Thank you, Chair. And thank you very much, Commissioner, for joining us today, for taking the time to testify. I wanted to begin by asking you about racial disparities in parole denials and in solitary confinement. There was a New York Times investigation in 2016 that documented pretty astounding racial bias in New York's prisons, particularly bias in the use of solitary confinement and in parole denials, that had prompted the governor at the time to announce an investigation. Recently in December, the Times Union issued a report showing that these same racial disparities in parole denials and solitary confinement had actually increased since the 2016 report. Now we're in 2021. It's been more than 4 years since the governor initially announced that there would be an investigation. Would you be able to inform us why findings haven't been issued from such an investigation, and any other action that's been taken since then, specifically to address the parole board's racially disparate release rates?
Senator, first of all, thank you for that question. Let me begin by saying I've been around since 1984, 36 years plus. And in my entire tenure with the state with this agency, this is the most diverse parole board that we have. And I know the chairwoman very well. She's a person of integrity and character. I know at least 11 members are considered to be minority. I know she is very active in initiatives with me. She is the co-chair of my Commissioner's Diversity Management Advisory Council, which is dedicated to increasing diversity throughout the ranks of our agency. I know that she is very engaged, and I know that if you're going to do any type of study, you have to be able to compare apples to apples and oranges to oranges in order for you to ascertain whether or not there's any potential racial difference in decision-making. You have to have the full array of information before you. For example, you have to know whether or not someone has been incarcerated 5 or 6 times versus someone who's incarcerated for the first time on a burglary in the 3rd degree conviction. That is not ascertainable from the information that may be available on the website. One of the smartest laws we never passed in this state is 3 strikes and you're in. So people can get repeatedly convicted as second felony offenders. You also need to have access to a whole host of information that the parole board looks at, which is not available on any public website. For example, what did the district attorney say? What did the defense attorney say? What did the sentencing judge say in response to solicitation records? What is the record while incarcerated? What is the disciplinary record? What did the crime victim submit? So all of these factors are taken into consideration and considered. And therefore, you would really have to have a very, very carefully constructed research project that had access to a lot of different records in order to ascertain whether there is any potential racial impact. And I will point out that one reason why our population is going down is that the parole board has significantly increased the rate at which people are released. And this is well before COVID. In calendar year 2019 and 2018 combined, right, which is pre-COVID, our population declined by basically 6,000. So we've had that going on. Then with respect to what we're doing in the disciplinary system, I have initiated a number of different training initiatives throughout our agency. Staff are mandated to take implicit bias, racial stereotyping, and many other things. I also have commissioned my research units to generate 2 different types of comprehensive reports, one of which looks at the assignments at each facility and the racial breakdown at each facility. And that comes into my Deputy Commissioner for Program Services, and where we need to be better at assigning particular jobs, the jobs at each facility have to be balanced according to the racial population at each facility. I also get a quarterly report from my research unit on overall statistical indicators of various types at a 5,000 foot level. And where corrective action is required, we do instruct the appropriate deputy commissioner to follow up. So we are very much married to the concept of diversity and inclusion and fairness for everybody.
Thank you, Commissioner. I want to preface this by saying that I may need to cut you off, and I apologize. I mean, no offense. If I cut you off, it is only because my time is limited. I want to talk a little bit about solitary confinement. In November, just a few months ago, the Partnership for the Public Good released a report on demonstrating that if the HALT Solitary Confinement Act were implemented, it would actually yield New York State a net savings of $132 million each year. I mention this because we previously heard from the current administration that contrary to this, the executive claims there would be a fiscal cost to implementing these same changes that are outlined, and the changes to the use of solitary confinement and the length of time. My question is, in your capacity, do you have an assessment of the HALT bill or on its proposed limits to the use of solitary confinement and whether it would in fact have a fiscal impact or cost or savings to the state?
Senator, normally I can't comment on pending legislation, but there's several things that I can point out. First, I have firsthand experience of what it's like to be confined in a special housing unit cell in a maximum security prison. I did it almost as an undercover operation back in December. We selected a facility. The superintendent was simply told, be prepared for two high-profile individuals, myself and my executive deputy commissioner. We went in dressed in inmate uniforms and we stayed there for 24 hours. So I got to see firsthand all the different interactions that are there with all the different staff, from being screened by the nurse, from the counselor that comes by, having the tablet, listening to headphones in the exercise pen, the whole 9 yards. And I can go into a lot further detail. But the big thing is that we would have to expend a lot of money to transfer people after 15 days to RRUs, which are being constructed as we speak. That movement can be very costly and very disruptive. It's disruptive to an incarcerated individual to suddenly have to leave the facility. If you are somebody that commits an infraction that's somewhat serious, but not so serious that the hearing officer wants to impose a 30-day SHU sentence, he would have to be moved after 16 days. But leaving him at that facility, when he comes out, he could resume where he was, including being back in a college program if that is where he was. So there's a lot of costs that are involved with any type of proposal that is there. And I'd love the opportunity to really lay out in detail all of the reforms that we've done, all the existing alternative units that we spent a lot of money, and where we will be with the RRUs, including tablets where you can speak to your family for up to 6 hours a day from a segregated confinement cell. That is a privilege that you don't get in general confinement.
Thank you. I want to ask more about COVID-19 in docks, given that jails and prisons are congregate settings, and I appreciate that you mentioned in your testimony that density has been reduced, but I think we can probably agree that docks facilities are congregate settings. When can we expect all of the people, not just based on their age, but all people who are currently incarcerated to become eligible for receiving the COVID-19 vaccine? And when they are granted eligibility, is there a plan by docks or DOH for rolling out vaccinations?
Well, Senator, we have been in partnership with DOH since the very start of this pandemic, and they have guided every step that we've taken, including how we would roll out vaccinations. And there's a lot of work to do that. We have 27 teams of people that were assembled, ready to go to the facilities. We have OSI staff that are ready to transport the vaccine. We had to survey all of the staff to see who would be interested. We had to deal with the medical people in 1A, the correctional staff, including community supervision staff in 1B, We had to find where the elderly are, 65 and older, and then we had to transport the vaccines. And in order for us to get as many people to accept the vaccine who are incarcerated, instead of giving them information for them to just read, I had a member of my executive team and a health services person directly interview them and try and convince them to accept the vaccine. And so far, close to 80% have accepted the vaccine. We will have injected 4,000 vaccines this week. We will continue with that. We are next tackling the vulnerable population of a little over 3,000 medical problems that we will get to. I can't give you a date when everybody will be vaccinated. I can tell you that as a matter of public health, public protection and public health go hand in hand. So it's in everybody's interest to get there as soon as possible. I think the news that Johnson & Johnson has now been approved for vaccinations is a big, big step that will help all New Yorkers.
Thank you, Commissioner and Chair. I have to cut you off. Chair, you're entitled to 5 minutes for a second round of cleanup at the end. With that, I'm turning it over to the Chair of Corrections for the Assembly, Assemblymember Weprin.
Thank you, Chair Kruger. Thank you, Chair Weinstein, for your leadership and patience during all these long hearings. I just want to follow up just on what Senator Salazar brought up, because I just want to let you know, Commissioner, that Commissioner Zucker, the state health commissioner, told the Democratic Conference, I think could have been a month ago, that the intention was to inoculate the vaccines of everybody in the congregate setting, because it really applies to correction officers, correctional employees, as well as incarcerated individuals are all part of that congregate setting. And he did say that the intention was to inoculate everyone, not just those over 65. So I just wanted to point that out, and I hope you'll get to that, because just like nursing homes, has been a huge spread to the whole system, as you know better than most. A couple of questions on a couple of things you already touched on, so I'll try not to be repetitive. But I know you're planning on closing Gowanda, Clinton, and Watertown. You announced that in December. What steps are being taken, if any, to minimize the impact on the local economies, and what's happening to the staff and inmates currently at these facilities?
Well, one step at a time. The first thing is to actually close the facilities, and they'll close by March 31st. My number one immediate priority is make sure that every one of the staff members at those 3 facilities have opportunities for employment elsewhere within our system. So I've dispatched our human resource staff, director of personnel, to meet personally with all of the staff that are affected at the different facilities, as well as the unions, and to carefully explain to them what their rights and options are. So we're going to be moving a number of them in about 2 weeks, and then we'll continue after that. We're also gradually moving the incarcerated population out of there as well. That is a process that is much less complicated, because we have thousands and thousands of vacancies throughout our entire system. Ultimately, when the facilities are closed, we will maintain at least them in a fashion that they can be reused when and if another purpose comes about. So we work with the ESD, and if at some point one of them can be sold or used for a different purpose, we'll allow people to be brought on site. We'll maintain them so that the infrastructure is preserved, and perhaps one of them may be sold, or there may be an alternate purpose. So we are always mindful of trying to do our best to leave the community with other options.
I appreciate that, Commissioner, and I appreciate the working relationship we've had for the last 5 years. I'd love to hear about your undercover experience offline. I don't want to monopolize the time of this particular hearing, but I'll discuss that with you at a later date. Something that came up in our Democratic conference as we were going over the budget the other day was the $5 million for the Correctional Services Commissary. addition. Can you give us a little bit more detail on that? Because that came up.
Yeah,
in-
basically that's a dry appropriation that's funded by the population themselves. And because each facility has its own independent commissary account, and because with things like loss of visitation, more money is coming in from family members for them to be able to spend things through the JPay account, et cetera. We needed to raise the appropriation so that we wouldn't have anybody that wouldn't be able to spend. So that was something we increased, I think, a couple of years ago, and now we're raising it another 5 million.
Okay, I have a number of issues to cover, so I'm going to try to go through them quickly. As you know, I've been a huge supporter, and I think you have as well, for higher education in facilities. And obviously, we're a little bit more limited, during this COVID-19, but hopefully that'll change. As you probably know, I have a proposal for educational release, and I think that's something that you might support. Has there been any discussion about adding college programs and possibly having the educational release? And with the recent bill in Washington, which basically, provided additional TAP coverage for incarcerated individuals, I think that makes it even easier, or more likely that we can expand some of these prison programs. Can you just elaborate on that and how the TAP could help that?
Okay, very quickly, Assemblyman. Yes, thank you. I really appreciate your support for higher education. I strongly believe in education for a lot of different reasons, primarily because it's transformative. We have totally different people once they get through education. We presently have about 21 different outside colleges delivering services at 30 different facilities. And we always would love to expand and include more. It's about 15,000 individuals in our system that have high school diplomas already, so they could move on to higher education if possible. I was very pleased to see Pell Grant restored at the federal level. I can tell you that the documentary that was made in our facilities, College and Prison, the Ken Burns documentary, 4 hours, that helped significantly showcase to the whole country the power of higher education behind bars in our system. And I think it was a big factor in why Congress restored Pell Grant funding. As for your pending legislation, Assemblyman, I can't really comment on that, but obviously anything that furthers the linkages, and if that's educational release that allows people to continue their education with colleges in the communities where they live, that's fine. We support anything that builds on secondary education in our institutions.
Thank you. And just following up on the parole board and the diversity of the parole board. When I first came on as chair about 5 years ago, there were, I think, only somewhere between 10 and 12 parole commissioners, and we've obviously expanded that. We expanded allowing to go up to 19 parole. I agree with you that the diversity has expanded, and I know you and I have been part of that process. My question for you is, how many vacancies do we have now? And I know we can go up to 19, and we really should try to fill all of those spots. How many vacancies are they now? And I know that the board is much more diverse, and I actually had recommended one of my correction staffers that, Tana Agostini, and she was one of those, and I think the state was the beneficiary, of her service. And if you could kind of just elaborate on how many vacancies we have right now.
Sure. We have 16 members of the board right now. And one thing I'll just remind you about, one is the population obviously has dramatically declined. When you go down 11,000, a little more than a year, that's a significant decline. The second thing is a significant proportion of individuals incarcerated are serving determinate sentences, which means they don't get released by action of the parole board. They don't get interviewed before parole. They're released at their date by operation of law. And so anybody with a drug offense or serving time for VFO or sex offense is serving a determinate sentences. They will not appear before a parole board for potential release.
Okay, thank you. My time is running out. I have a bunch of questions, and I will reserve the right to come back for the second time as chair. But you talked about the reduction in overall prison population significantly over the last few years. I just want to ask about double bunking. Is there still double bunking, meaning two residents to a cell currently in use? And if so, why, since the prison population has been significantly reduced?
Well, first, for those double cells that had been in operation when we were very overcrowded, we had to convert a number of single cells in 16 of our maximum security facilities. They've all been taken down with very few exceptions. There's a very limited number in Auburn. I doubt if they're filled right now, and there's a very limited number, I think, in downstate. And I think the others, that would be it. So those have been taken down. But then you have the double cells that were constructed as double cells at places like 5 Points in Upstate Correctional Facility and our S blocks. Now, to the extent that there are instances where some of them will be two in a cell, yes, that still exists, but it has been significantly decreased with the significant reduction in the population.
Thank you. I'm running out of time, but I'll come back. But let me just ask one more question.
Quickly, you're not going to have any time to get an answer.
Okay, well, you know what? It's been a pleasure working with you these last 5 years. I'll come back for the 5 minutes for some of my other questions. How's that, Chair?
That's perfect.
Thank
Thank you. Thank you. And our next questioner is Jamal Bailey for 5 minutes, Chair of the Codes Committee.
Thank you, Madam Chair. Acting Commissioner, good to see you. Chair Salazar mentioned a lot of the conversation that I wanted to do, and she touched on it, and I think she'll touch more of it in her second round. It's related to the response as related to COVID. But I wanted to double down on what Assemblymember Weprin was talking about as related to education for individuals who are currently incarcerated. You mentioned the documentary related to the Bar Prison Initiative and the restoration of the Pell Grant at the federal level, which is great news. I was wondering, are there steps that we can take, in your opinion, that we can do to further put pressure on getting TAP back for individuals who are incarcerated?
That's a difficult question, Senator. Obviously, we're in an enormous situation with the budget. I mean, we all have heard the reports. We know what it's done. I think the budget director is very hard pressed to find additional funds for anything without cutting something else. I think for the most part, if you want to show support, at least, we'd love to have you at our college graduations. Come and help give support to the population. It's really an uplifting event when we have graduations and the men and the women are dressed up in cap and gowns and the family members are in the audience. And we've gotten some named speakers, people like Whoopi Goldberg and Bill Whitaker from 60 Minutes and a couple of Cardinal Dolan. So come to a college graduation and really see what the end result is from college behind bars. It's very uplifting.
Certainly, if we're really talking about actual rehabilitation, this is a huge step in that direction towards incarcerated individuals being able to resume normalcy once they are no longer incarcerated. But I guess the next question that I would have is related to individuals who are working while incarcerated. Generally, what's the average hourly rate in number of hours that an incarcerated individual would work each week?
It depends, Senator. It depends upon a particular grade. The highest graded worker can make probably a little more than $1 a day if he's in a high earning correctional industry job. But it all depends upon the particular job. And I'm very sensitive to the wages issue. I think it's an important conversation to have. And it's one of the things that in order to try and at least help offset the low wages, we keep the population harmless as best we can with things like having very, very low rates for telephone calls, for secure messages on our tablets. We make sure the vendor keeps up us among the lowest in the country. We'll never charge sales tax for anything. We did supply the tablets free of charge to them. We're never going to ask for a copay for medical care. So while we're dealing with this period when we may be restricted because of budget constraints from raising wages, I'm very sensitive to it and are trying to at least have other things to take their place.
Okay. And generally speaking, how much does docs spend paying people that work in prisons, generally overall?
By an hourly wage?
No, in total, like what is docs' outlay like for paying individuals who are incarcerated that work in prisons?
Do we know? Yeah, we'll get back to you, Senator. I just don't have that off the top of my head.
No problem. As my time is running low, I want to talk about medication-assisted treatment. I'm the sponsor of a bill to expand that, and as you know, I think it's critical, especially us being in an opioid crisis, still within the throes of an opioid crisis. How many facilities, again, in the state provide MAT currently?
Oh, it's about 7 or 8 at this point. We were really building our capacity until obviously COVID really put a damper on everything. We have methadone and buprenorphine at a number of facilities. Off the top of my head, it's Bedford, it's downstate. I think Elmira and Marcy. We have Vivitrol at a number of facilities, and we also have naloxone, which obviously is important for overcoming overdoses. And it's part of transitional services, and any individual being released who will willingly accept the kit, will give it to them. And hopefully they can potentially save a life in the community.
Sure. So I guess my final question related to segregated confinement. Senator Salazar spoke incredibly well on that earlier, and I would echo those sentiments that we should do anything we can to reduce that. But as it is right now, what are the total number of infractions that are issued or for individuals that are issued for people violating rules each year? And then what's the result of being placed in the SHU after those violation results?
Okay, so basically like the penal law, our disciplinary system has 3 tiers, tier 1, tier 2, tier 3. And I can give you the total number of convictions for each one. You can't go to SHU for a tier 2, and a tier 1 is almost like a violation. You get punished, but you don't get any kind of record that could come back and haunt you. Tier 3 is the one where you can get a recommended loss of good time, keep lock confinement, or segregated confinement. But we have significantly modified the offenses that could result in a tier 3 outcome. So we've moved a number down to tier 2. And in fact, a snapshot on January 1st of this year compared to a year ago, there's something like 400 and some odd less people in SHU. So we are clearly moving away from that direction. There's a number of things that we had agreed to with the NICLU settlement agreement, including the requirement that we tier at the lowest level, that the review lieutenant reviews that and makes sure it's the least tier for the particular act of misbehavior that's involved. Many of the things that we do that have really ameliorated who goes to SHU or and how long they stay there, and is keep lock as well.
Okay. Well, I see that my time is up, and thank you, Madam Chair, for allowing me the opportunity. And thank you, Acting Commissioner.
Sorry, I was on mute. If you would, Commissioner, get me and Helene the information you were just describing, the chart showing the tiers 1, 2, 3, what the categories are to actually fall into a 3, and the numbers of people now going to the SHUs under these new rules. I think everyone will be very interested in seeing the data. Okay.
Sure.
Thank you. And next we have, Assembly Member Palmisano, who is serving as the ranker for today and gets 5 minutes.
Thank you, Commissioner, for being here. I wanted to kind of get at talking about the prison closures a little bit. That's something of great concern to myself and a number of my colleagues. Certainly, I've seen that the governor has taken a lot of credit. I'm proud of the number of prisons he's closed in his tenure. I believe with the 3 recently announced, that'd be 20 facilities. Well, what he seems to fail to do is to take responsibility for the dangerous powder keg environment these closures and some of his other policies have created in these correctional facilities, like restricting the use of special housing units. And I call them special housing units, not solitary confinement. Even by DOC's own website, inmate on staff assaults are up over 38% over the past 5 years. Inmate on inmate assaults are you see over 1,000 per year over the past 5 years. I think it's a 31% increase since 2015. So really jamming more and more inmates into fewer facilities, especially in this age of COVID. The other area I want to just talk about really is this whole fast tracking of these prison closures, 90 days. I really believe, as a number of my colleagues do, this is really a lack of respect to these families and the communities who have been totally disrupted by these closures. And it's really adding insult to injury, no time for planning or preparation. And so this is like 7 prisons that will be closed within a 90-day period or these past 2 budgets. It's difficult enough. It's not enough time for a family to plan for moving, to relocate for schools and homes. It's just not appropriate. And especially in this era of COVID, we really should be rejecting any measure to close a facility within 90 days. The statute calls for 1 year. But I do want to talk about the prison closure. I know in this budget, he's talked about a 2-year budget, 2-year period. That creates more uncertainty. So have you identified how many prisons you might be looking at as far as for closure, medium, maximums? Number of beds, how many prisons are you talking about? Do you have any idea right now?
We're basically looking at closing the equivalent of prisons that would amount to 1,800 beds in that neighborhood, Assemblyman.
Would that involve mediums, maximums, both?
We haven't made a final decision yet. There are a lot of different factors that we look at. Let me just back up 1 second, if I may. It's the toughest decision to do, to close a
I understand
correctional facility. I do not underestimate the impact on the staff or the surrounding communities.
I know you understand that, but it's still a concern. Because I guess even in this age of COVID, what practical matter does it mean to jam more and more inmates into fewer facilities and fewer space? I do want to talk about the issue of violence. I mean, how high does the violence in our facilities? We already talked about 38%. And the contraband numbers, the drug numbers, drugs getting into our facilities, or 4,000 incidents each of the past 5 years, before the administration and DOCS is going to implement meaningful reforms. Instead of taking away resources like the ability to use special housing units. I mean, where is the secure vendor program? Several years ago, that was a program you had in place that started out and you canceled it abruptly to help screen these drugs getting into our facilities. I have not been made aware of any new facility or program that you're utilizing to deal with the screening of these programs. Where does that stand? What about the use of K-9 units at every facility? Where does that stand?
Well, you asked a lot of things. Let me try and answer them one by one. First, 75% of the assaults happen in maximum security facilities. We haven't touched maximum security facilities. Facilities that are closing are medium. Second, we have thousands and thousands of vacant beds throughout. You can't possibly say that we're jamming people when we're closing facilities. Third, the secure vendor package program is something that's very important that I want to get back to. I had to stop it when we got hit with COVID. We learned from the first misstep, and I'll take full responsibility for that. We've met with the advocates, we've met with the unions, they've given us positive feedback. We've gotten feedback from the superintendents. I do want to get back to that. The presence of drugs is a significant concern. It's a health risk, both for the population and for staff. I think ultimately getting to that will put us on the right track and help reduce drugs. But in the meanwhile, our staff are fantastic in our package rooms in discovering contraband that's secreted within cans of vegetables and fruits and things of that nature. So I can't agree that closure somehow is linked to violence at all. There's no connection whatsoever to that, because we are at a level that we haven't seen since 1984.
One last quick question. Who is supervising?
Sorry.
Oh,
You
I'll
can't
pass that
pull
on.
off a question and answer in 2 seconds.
Thank you.
It was a good stab, though. I like that.
Thank you.
Sorry, my job is to be mean here today.
Fine.
Senator Borrello next.
Yes, thank you, Madam Chair. Thank you, Commissioner. I represent the 57th Senate District, and Gowanda is in my district. And I have just wanted to bring up a couple concerns. First of all, thank you for being here. But there have been FOIL requests put in by the Gowanda Area Redevelopment Corporation. And they've gotten a bit of the runaround. And I understand sometimes the request is made to the wrong agency, but DOCS did receive a request. You know, you're claiming $89 million in savings for closing these 3 facilities. So the request was made to see those savings and exactly where those savings are. And somehow they were notified that in order to produce that, it's going to take until April 2nd. This is a request that went in January. So my question to you is, if you made the determination to close these facilities based on savings, then how could that data take 3 months to procure and deliver to this FOIL request when that should have been what you used to make that determination? Shouldn't you just be able to pretty much instantly turn that over? Why would it take so long to show what savings would be made?
Senator, I'll have to look into exactly what the response to that FOIL request. You said it was a FOIL request submitted by
Yes.
the
Gowanda.
organization.
Yeah, I'm sorry. It's the Gowanda Area Redevelopment Corporation, and it's been into use since January 25th. I'm sorry. The first response was from January 25th, and they're saying April 2nd.
Okay, I will look into that, but basically, the closure is all personnel that ultimately are relocating to other vacant positions throughout the system. So that, for example, the closures going forward are projected to reduce our overall budget fill level by 800 positions. And so when you factor into that, all the costs, the fuel costs of maintaining a correctional facility, the sewage treatment, all those other costs, they're complicated, but you come up with a number that basically says this is how we get to 89. I don't know why they've said until April, but I'll follow up on that.
Well, yeah, because it was literally 2 days after the prison's going to close, which is my concern. But also, let me also add that there's other factors there too. You may not be aware, and I don't expect you to be aware of this, but the Collins facility's heat system is supplied from the Gowanda facility. I don't know if you're aware of that or not. So when you start talking about savings based on labor, that's one thing, but you're going to have to maintain that facility in some manner. And also, there was a brand new infirmary, I'm told, at Gowanda that there's going to be upgrades needed to Collins. So, I'm a business person, and you can't just look at one side of the equation. The other side is, what's it going to take to maintain that facility or quote unquote mothball it and still have it there so that it can be used to supply heat to the Collins facility. So I'm just curious what that final number really looks like.
We'll get back to you on that, Senator. We are relocating an infirmary into Collins, but I think it may be backwards about where the heat is coming from as well. So I'll get a final answer for you on that.
Thank you.
Thank you. Next up, Assemblymember Mark Walczak. 3 minutes.
Thank you, Chairwoman. Appreciate it. Acting Commissioner, you said you were very proud of the corrections officers that work for you and how they've acted during the pandemic. I appreciate that sentiment. I certainly am. How did you come to announce prison closures for those COs and for their families 4 days before Christmas?
If you're asking why that particular timing, Assemblyman, it was not an easy decision to make. We were balancing a number of things. Had COVID never happened, we probably would have announced June 1st, July 1st, the latest. COVID happened, that complicated everything. And we're balancing, obviously, the decrease in the population, which is happening at a very rapid pace, something an average.
I'm sorry, I only get 3 minutes, so I hate to cut you off there. But Chairman Weprin brought this up in his question. He was talking about Watertown Correctional and the correctional facilities that you're shutting down here, which the governor has the prerogative to do through you. You said in planning here, the first thing you have to do is close the facility. I would disagree. I think your job, whether acting commissioner or commissioner, would be to create a reasonable plan for prison closure and communicate that plan. Your next would be to take care of the employees that are under your department. And then the following would be to take care of the inmates and make sure that everybody is safely done there. Leaders plan so that the next phase is not close the facility and then figure out what happens next. But I wanted to talk to you about safety and staffing and facilities, since you brought that up as well. You said state safety of staff and facilities is of paramount importance. Is your analysis a key component of that?
Yes, we look at everything. We look at how things are working at the facility. We look at the infrastructure, we look at the capital, we look at the proximity to other facilities where we can move staff. Most of all, we look at the actual infrastructure of the facility itself.
You
and
may
what the costs are gonna-
you may recall, Commissioner, back in September, on September 1st, a number of us legislators penned a letter to you asking that you reinstate the urinalysis program because of the danger that drugs in our facilities pose to both COs and inmates. You took 2 months to respond, and in your response on October 28th of last year, you said you were working as expeditiously as possible. Those were your words in that letter. Your staff then in last December said that the urinalysis program would start in January, which would be last month. Do you have a urinalysis program that is running in all of your facilities now?
We have a urinalysis program that's an interim measure with a vendor that can, if there's reasonable suspicion to believe that someone has taken drugs, we will have that test done for this interim period. We have selected 2 new vendors, one an outside lab, one a supplier of the test. We have sent out the distribution of the kits to every facility. We are ready to implement. It will probably be done, I'm almost sure it'll be done before the end of this month. So understand that when you're dealing with things like COVID and vaccinations and relocating staff, to stick to a schedule is not the easiest thing.
Obviously, I would love more time, Commissioner, but mine has expired. You'll be hearing from me soon.
Thank you very much. Next questioner is Latrice Walker. You still with us, Latrice? Perhaps not. Oh, there she is. Hello.
All right. So thank you. Thank you so much for your testimony this afternoon. I have, of course, I want to associate my comments with my colleagues who spoke to you about solitary confinement. Particularly, I was told when I first got elected that 25,000 people were going to be returning home to my district between 2015 and 2020. And so I'm pretty much about at year 5 now. And the level of support that is needed for so many individuals who have gone through such volatile incarceration conditions it definitely feeds the supportive housing network within my community. And a lot of folk are really left without a lot of supportive services. And so I really think that the detrimental effect that this type of housing unit has had on our communities has been troublesome. So I would like for you to take a look at that. Of course, want to also associate myself with comments with respect to elder parole and releasing people who have paid their debt to society and are behind bars. But I had an opportunity to visit the Queensboro facility recently. And I think that that type of a facility is really necessary for most people who are transitioning out of the upstate criminal justice system. But I've noticed that a lot of facilities were closing down, including Arthur Kill, and a few other facilities in New York City. But I think Edgecombe is still there. What do you think about maybe allowing some reentry services to be utilized in order to help people to facilitate their reentry back into our communities? I also want to just say that this the pay situation with respect to the tablets. I think I'd like to discuss that with you because during COVID, as you know, that was some of the only solace that many people who are incarcerated sort of had as they went through that whole process, and having it be based on, people sending them money or a pay schedule, it seems to have been problematic. So I did want to talk to you about that. And as well as, of course, death by vaccination, as we've seen and happen in the federal court system. But I did want to hear, and also about your thoughts on voting rights of people who are presently on parole and what the process and procedure is with respect to providing voter registration cards, et cetera, and registering those people to vote as they're walking out of your doors.
Okay,
In
a
a
lot there.
nutshell, but we can follow up later on in the 20 seconds that you have left.
Okay, a lot there. First of all, the whole reason or big reason why the governor merged our former agency and Division of Parole is he wanted a seamless transition. He wanted people to have a smooth handoff from going from an institution in the community. And he felt putting us all under one agency has really helped further that, because we all staff, we can prepare better. We have transitional services. We can identify housing. We give people social security cards, birth certificate to get free access to their rap sheet to prepare for job interviews, etc. Fundamental purpose of the penal law changed to include reintegration as a fundamental purpose. Governor created the Reentry Council to focus on those issues and to remove obstacles. We have staff that are called reentry managers that are devoted to hook up for reservices. We have reentry councils at a number of different counties, and I'm sure in your county as well, where we work with the local officials to hook up the individuals with services. The governor has issued pardons to thousands and thousands. I can get to you the total number of individuals to make them immediately eligible to vote. So before they even walk out the door, I give to them information, or at least those that are maxing out, on the importance of voting and how to register to vote. If they get the pardon when they report to the parole office, they're given that information, they're explained how to register to vote. You already passed the statute back in 2009, I think it's 75 of the correction law, that says if someone's maxing out, that's when they're immediately eligible to vote. So we give them that information on registering the importance of voting. And then if they're on parole and they're about to get discharged, we give it to them. But before that even happens, with the governor giving pardons to so many, they're eligible to vote. They're informed of that, and they have written materials to explain that to them.
Thank you. I'll follow back up with you on some of my other questions, but I did want to highlight too, reentry housing is so very important, and I could totally use your help on facilitating that.
Sure.
Thank you. We've been joined by Senator Pete Harckham, and it's his time to ask questions.
Thank you very much, Madam Chair. Commissioner, thank you for your testimony. I want to align my comments with those of Senator Bailey. I chair the Committee on Alcoholism and Substance Abuse and co-chair of the Senate Task Force on Opioids. And we know from families, from treatment advocates, from recovery advocates, that there are scores and scores and scores of our inmates who are not getting the treatment they need. I know you've made some strides, but inmates coming out of incarceration without medication-assisted treatment are among the highest risk for overdose death, because they still have the cravings, and when they come out and they use, their body no longer has the tolerance, and we end up losing a lot of them. It's also one of the #1 reasons for recidivism. So, you know, I implore you to work with us. I know you've done some things, but whether it's Senator Bailey's bill or we do it, you know, in-house through the process, we really need to do more, because we know there are scores and scores of people who are incarcerated who are not getting the treatment that they so desperately need.
I totally agree with you in terms of the importance of MAT. We've expanded that. We have a wonderful partnership with OASIS. We have an application in to try and become the first corrections-based certified OTP. That is something that I think could really expand treatment. Right now, we have an initiative where somebody who's already on MAT, namely methadone or buprenorphine, the sentence is 2 years or less, they can come into our system and be maintained on that and then continue it in the community. But COVID obviously put a huge damper on everything. So I look forward to when COVID's in the rearview mirror, and we can build upon the good work that we've already done and expand upon it, including MAT.
All right, I look forward to offline working closely with you on this, because I think it's an important step that we need to take.
Thank you very much, Senator. Next from the Assembly, Linda Rosenthal.
Hi, hi, Commissioner. Good to see you. Last year we went over the MAT in prisons, and when I was chair of the Committee on Alcoholism and Drug Abuse. Now I'm Social Services Chair. I asked you questions about the availability of MAT in prisons and jails, and the bill that Senator Harkin referenced, Senator Bailey, I have the Assembly version. Last time, I think you said there were maybe 6 prisons statewide that had a MAT program. How many do you have right now?
It's more than that. And at one time, it also included PDPs for the Vivitrol. I can't think of them all. I don't want to give you misinformation, Assemblywoman, so let me count, but it's at least 8 from my
Okay,
recollection.
but how many prisons are there?
Right now, there are 52, but 2 are
So-
closing, plus the Clinton Annex.
Okay, so that's really quite a, not a great ratio when we have the tools to make sure that people, can recover from addiction when they're ready to. And I see that the governor cut the funding for jail-based MAT by a tremendous amount, by 50%, saying that, people have been let out of jails and prisons, so there's not such a need. What's your view on that?
Well, the reality is that the population is significantly reduced at the jail level and at the state level. When you look at our population and you measure basically a 1-year decline in 5 figures, that's astounding. It took from 1981 to 1999 to increase by 50,000. In 3 years, we've decreased by 17,000. So that has ramifications for a lot of different things, including what your ultimate needs will be for all kinds of things like mentally ill inmates. and
I
substance
understand,
abuse.
but we've really not made much progress since last year, and that's shameful because people will die. People who leave will die because of the overdose effect when you're, you understand all that. And I think that the state really needs to prioritize that because we have solutions, we have treatments, we have a toolkit, and we're just not using it. I'd like to ask you about women's health in prisons. Women who are incarcerated have complained about a lack of access to health care services, prenatal care, trauma-informed care, and many other aspects. Are the staff in your facilities provided any particular training on the health needs for women, particularly those who are pregnant? And before you answer, I'd like to say I echo my colleagues' views on the vaccines, elder parole, and all of that. Thank you.
So obviously for the women, we have many different programs, many relationships with outside volunteers that come in, and specially trained healthcare staff to meet all of their needs. I was very adamant that I don't want in any way, shape, manner, or form for any of our female population to feel neglected. So if you go to Bedford Hills or you go to Taconic, you can see the nursery, you can see the children's center, you can see the RMU, the regional medical unit that we have to care for prenatal and post birth and many other things that we do for them. I'd like you to just come and see for yourself what we do, but it is very,
Well,
very important to me.
I certainly would. One last.
Nope,
bit
you're
about-
way past 0. Sorry.
I see
Look at the
0.
clock. Look at the clock.
It says
Sorry.
0.
Nope,
Thank
I know
you.
you're past 0. Assemblymember Burns.
Thank you very much, Chair. And I also want to thank the acting commissioner for being here and being so gracious with answering a lot of questions, and there's more to come. I want to go in a little different route. I want to talk a little bit about the pause on in the moratorium on having state-ready prisoners sent from our local county jails to state facilities. The reason I want to talk about this, Commissioner, is because it has a big impact on our counties, both financially. Steuben County, it's about $2,500 a day. And so we have a significant cost factor. And also, at least in one case, we have an inmate that's ready, that is parole eligible, but he can't be reviewed until he gets to state prison. They can't review him while he's sitting in the jail, and he could potentially be home right now. Right now, just in Steuben County, there's 147 total inmates, 25, 17% are state ready. In Broome County, 414 total inmates, 76 are state ready. That's 20% of their total capacity. So my question, sir, is when you look at the impact of the cost of the moratorium on the counties, compounded by the fact that we could actually have inmates that could be released if they could just get transferred to prison to be processed out. And also, sir, you've been talking at length about all the vacancies in the state prison system, which don't exist in our county jails. When we take all of these factors into consideration, sir, with the deepest respect, would you agree with me that this moratorium should be immediately lifted? And at the very least, the moratorium should be immediately lifted on a regional basis in areas like ours that do not have COVID concerns with transfers to state prison.
Assemblyman, I take your concerns very seriously. We did not take this step lightly to stop intake. We're reviewing it every day with a view toward trying to reinstate it as soon as possible. The challenge with accepting state readies means that we have to start movement throughout the entire system. You can't just accept people into reception centers and leave them there. You have to, it's like an assembly line. You go from reception centers to general confinement facilities, and that starts the movement among all 52 facilities. So for the period that we had these spikes, which happened predictably right after Thanksgiving and Christmas and New Year's and those holidays, we needed to stabilize the system. We are seeing good results now. The numbers are coming down. So we're going to meet very shortly to discuss this.
Will the moratorium not be extended? Can you promise it will not be extended anymore?
I can promise that we're going to give it very, very careful consideration, Assemblywoman. It's a difficult issue. The one thing I can tell you is everybody gets reimbursed either actual costs or $100 for every state ready that's not accepted within 10 days of declaration of state ready. There's additional funding that's in our budget to try and make the counties whole for that.
Thank you both. Next, Assembly Member Burdick.
Thank you to the chairs and also to to Acting Commissioner Nucci. And I want to thank you for your good work and the partnership that you have with the town of Bedford in my district and work that you're doing on early release program and so forth. I do want to align myself with my colleagues who would like to see an expansion of early release and to get on a path to terminating solitary confinement. That takes me to a question that Chair Weprin had raised about the impact on local economies of closures. And actually in Bedford, there's, as you know, a shared service between the town of Bedford and the department, in which the department is a customer of the water and sewer district. And a closure of either of those facilities would have a devastating impact. Are there any question as to whether there's any plan for closure and where there might be some carve out of the 90-day with respect to that, which that could be the only one in the state that has that kind of arrangement. And another question I have, really unrelated, is that I'd like to get direction, and we could do this offline, on who I could work with in terms of plans for solar and electric vehicle charging installations. So if you could address those, that would be terrific.
So Assemblyman, it's good to see you. We welcome you to your new position. We have a long working relationship with Bedford and the local officials, and you were one of them, and we value that relationship very much. It's a slippery slope for you to ask me whether or not any of our 52 facilities, soon to be 50 facilities, can be off the table for closure. Because if I answer your question, then somebody else is going to ask a similar question about their facility, and it's just something I can't do. But I can tell you that we only have one maximum security facility for women in the state, and that's where most of the programs are. So if there were ever a set of circumstances where we were to even consider that, there would be a lot that we would have to factor into. The other issue is there's a lot of issues, a lot of initiatives that we're doing for the environment and clean energy. We have a whole arrangement with NYPA to put in electrical panels on our vacant property. And the idea that you suggest may be worthwhile. It depends upon the logistics, but one of our engineers in our facilities planning would be the person that you can have a liaison with to even discuss the logistics of whether that could be doable or not at various facilities.
Is that Keith Rupert that I'd be working with?
He's one of them, but he works under a deputy commissioner, so it would be both.
Super. Thank you so much. And again, thank you for the very positive collaboration and partnership.
Sure.
Thank you very much. Our next questioner is Assembly Member Harvey Epstein.
Thank you, Commissioner. Appreciate your time. I know a lot of some of my comments my colleagues already mentioned to you about solitary confinement and how the HALT bill will save money. I hope you will consider that saving, because that's a really critical thing. It helps people to get out of prison and will save us money. The vaccinations for inmates, we were given a commitment that it would happen at the same time as other folks in the prison system, and I hope that still goes forward. I was at Greenhaven just earlier this week, and I'll say that there were floods by where the cells were, leaks. There were safety issues. You mentioned school programs. BARD has a program there, but with 1,600 inmates, only 30 are enrolled in the BARD program. Dozens and dozens of inmates wanted to join the school program, but they have no access to it. There's a technical school program, and it's about 200 students. But the college program, which is advancement, where people can get a college degree, and the recidivism rates are so low, we didn't see that. So I'm wondering, just on Greenhaven alone, that the facilities need some work. We would want more money to our prison system on capital, redo our solitary units and move forward. I saw you were redoing a solitary cell there, but not in a new way to avoid solitary confinement. Can we get your commitment to look at solitary cells and redo them in a way that's more humane and not in violation of the UN rules around solitary confinement?
Well, I can't make specific commitments about how we spend capital. What I can tell you is I experienced it myself. All of the things that we're doing is moving in the direction of making the conditions more humane as we build our RRUs. The existing programs that are alternatives to SHU at Midstate and at Lakeview and at the step down to the community at Wendy, all are designed to provide out-of-cell structured treatment and programming. So the earphones that you can listen to the radio on, the tablet that you can make phone calls on, while we're moving to ultimately get the RRUs, are ways that we are ameliorating. One thing everybody should keep in mind, the very purpose of this is separation. If we lose the ability to separate those aggressive individuals.
Left. So if I can just follow up on that issue. We talked a lot from inmates who have limited access on the J-Pay system. I'm wondering if we could get access to them. Maybe we could get a tablet and they could just be emailing our offices so we could follow up. Would that be something you'd be open to?
I'm sorry, you want access to what?
The tablets, J-Pay, so the inmates could email our offices directly and communicate with us without having additional costs associated with that.
I believe there's a way that they could send you an email, but they'd still have to pay for the stamp. But I'll
Right.
double check on.
Yeah, if there's a way to make it more accessible for us, and I wanted to second point, the early release time and the costs associated with inmates. And I know I've run out of time.
You
So
have run out of time, Harvey. Everyone can submit their questions to Helene and I, and we'll write the commissioner, or we're asking him, he'll send us back, or you can write him separately or follow up with him separately. But we've got to keep going.
Thank you.
Equal opportunity whatever, moderator. Okay. Next is Carmen De La Rosa.
Commissioner,
Thank you for being here and for coming before us. I want to also echo the sentiments of many of my colleagues here. I'm the main sponsor of the elder parole law here in the Assembly. And we know, because you said even in your last budget hearing, that at 55, people who are in prison are considered seniors because of the conditions they live under. My question is more towards the medical necessities that these people who are either terminal or have very high critical needs, medical needs. What is the cost associated with providing some of the services that they require across the system?
I can't give you the specific dollar figure, but you are correct. The older you get in prison, the more costly level of medical care you are required to receive. And we do have arrangements with outside hospitals. If somebody needs hospitalization, they go on a secure ward until they're better. They may recover in one of our regional medical units, but clearly people, the older they get, if they have hypertension, high blood pressure, some of them may have cancer, whatever it is, we have to provide the treatment, and we will do that. The medical parole issue is another important one, and it is something that I try and prioritize whenever I get an application, but read the statute in terms of who's eligible and who's not. There's a hurdle that has to be overcome. It can't just be for somebody that's terminal. They have to be so infirm that they can't potentially pose a danger to society, which is a high hurdle.
Yeah.
So I know people want a lot more medical paroles, but there is the law that we have to abide by in that area.
Certainly. And I did visit Fishkill Correctional Facility 2 weeks ago, and I saw their infirmary, state-of-the-art machines to deal with dialysis and infirm people. But I also did walk through the wing where the developmentally disabled people were, as well as people who were on their deathbed. These people do not pose a threat at all. They can't even walk. So I just want to bring that to your attention. But I also wanted to ask you about the cost of something like dialysis machines, for example, for the department. What does something like that cost you all a year?
It's not cheap. The dialysis is expensive, and we have them at several facilities. But it is not cheap by any means. One thing I will caution is that some of these individuals that are infirm, like in the unit for the cognitively impaired, it's not easy when it does come time for them to be released to find a nursing home that would accept them. That is a very difficult chore for us.
That was actually my follow-up question. Can you explain the biggest hurdle to finding housing for these people right now?
If some of them are sex offenders, it's very, very difficult to find nursing homes that would accept them. And some of them, if they have no place, if they have no family, then your only option is a homeless shelter. One of the things I prioritize is the work of social workers to reconnect people with their families. In Adirondack, where we have some elderly people right now, we have social workers that are reconnecting them with family that they've been disconnected with for many, many years. When you reconnect with family, you potentially have a home to go to when it's time for your release. So that's a priority that we're pushing.
Thank you. I'll come back for a second round later. Thank you.
And you won't, unfortunately, we're only allowing chairs to have a second round, but you can follow up with the commissioner in a variety of ways.
Thank you.
Thank you very much. Next is Assembly Member Ra.
Thank you. Good afternoon. I just wanted to first start with my colleague, Mr. Palmisano, had a question at the end that he tried to sneak in, but he was spoiled by the chair. So I wanted to ask it for him. It was regarding the youth that were transferred from DOCS facilities to OCFS secure facilities last year pursuant to last year's budget, and who is supervising those youth?
They're with OCFSS, that agency.
Okay, and so they're supervised by their staff within the
Right.
agency? Okay, thank you. The other questions we just had regarding staffing at your facilities. I mean, obviously, I know of many entities throughout the state, especially in your type of facilities, that had to deal with staff, quarantines due to exposures and all that type of stuff. How have you found that during this almost year now with COVID? Do you have enough correction officers to cover when there are absences due to COVID or quarantines?
It was a big challenge at times. It depended upon the specific facility when we had high numbers. I've been having regular phone calls with my superintendents, and we do monitor it carefully. We have a plan to go to 12-hour schedules if we reach a point where there's too many staff that are quarantined. I mean, obviously, the things that we've stopped, visitation stopped, medical that's not an emergency, deathbed visits, et cetera, has allowed staff to be present to do other responsibilities. But it's been a big challenge. And again, I'm just so grateful for the staff helping pull us through this very challenging time.
Okay. And are there any plans at this point to run academy classes in the near future?
We do foresee that we'll have a need for a couple of classes down the road in the upcoming fiscal year. And we do foresee parole classes as well, a couple. We don't have them yet scheduled, but there clearly is a need, given the rate of attrition, which is about 54 or 58 a pay period of correctional staff.
Okay. And one other thing I wanted to ask about, so years past, and it's been a few years now, but docs used to issue an annual report on recidivism, and I believe it would take a few years of rolling data. And my understanding is there hasn't been one released, I think, since 2012. Is there any plans on releasing updated stats with regard to recidivism?
3-year study, I think, is what you're referring to. Let me check with our research unit when the next one is going to come out. We'll get back to you. I can tell you that they have been working tirelessly to keep accurate statistical numbers on daily rates at every one of our facilities, how many tests are performed, how many positive, how many have recovered, et cetera. So they have been doing extraordinary work so we can have real-time data and put it on our website.
Okay, thank you. We're definitely, interested in those reports. I think they're important for the legislature to look at when we're making, decisions on all different types of things. So thank you,
Sure.
Acting.
Thank you. Assembly Member Tenusis. Apologize if I pronounced that wrong.
Hi, Commissioner, how are you? Thank you for being here today. I asked this question of the prior speaker, and he mentioned that you may be able to help us better. Would you be able to tell us how many inmates in the state system are there because of a marijuana-related offense?
Yeah, we ran this analysis on December 12th of last year. Someone else had asked the question, and there was a total of 21 whose most serious crime of commitment was a marijuana offense.
Out of how many inmates in the entire New York State?
Today we have 33,100 something, I think.
So it's 21 individuals from 33,000 New York State inmates are there for a marijuana-related offense.
The top offense is a marijuana offense, yes.
Thank you very much. And thank you for your service.
Thank you.
You're ceding back your time? Yes.
Yes, thank you.
Thank you. And Assembly Member Anna Kellis.
Hi, thank you. A few questions. One, I'm just going to jump right into them for the lack of time. So it was so good to meet you. But first question, to clarify something that was brought up earlier with respect to solitary. Recognizing that that people in prison are already being moved anyway because they're being moved into solitary. I'm trying to understand the opposition with the financial justification. If they're already being moved into these facilities and out of them into the solitary, and you are already building the rehabilitation units, I'm trying to understand where the expense is that you were talking about.
The expenses primarily in additional staffing that are going to have to transport them on day 16, if that's the day that we have to move them under the bill, to a distant RRU. Whereas there will be shorter sentences like 30 days and they can stay where they are. Plus, you have to pack up all their property and transport it with them to another distant RRU. If they can stay where they are, the property can remain there, still be packed up, but not have to be moved to a distant
But
facility.
I'm sorry, I just don't understand.
Most of
You
that
have to
expense,
transfer them anyway, correct? When you bring them out of solitary.
sorry?
I'm just trying to understand. I mean, you would transfer them anyway when they're coming out of solitary. So the timing of
not going
having
to transport them to, we're not transferring them to another facility. Their cell could even be remaining there for them to be back into that same cell.
And another question, thank you. How many people leave the prison system, do you know, or keep track of and go into the homeless shelter system?
It's not a low number. I can get it for you, but it is not a low number. And
Yeah, that would be really wonderful to get that. I'm curious, is there any program in place to coordinate with DSS potentially to work with people before they leave the system to get them into services?
yes, well, first of all, let me back up. We work 4 months prior to a release date with the individual, trying to get them into approvable housing. If they come up to the release date and we can't find them, we coordinate with the local DSS. We give them notification so that they're aware on this day, this individual is coming out and he will require some type of services. We also have, contracts with Housing Limited, but we do have the ability for housing. We also have relationships, there's two entities, CEO and PLS as well. They've secured funding, stipends to give to individuals who are releasing to certain areas like the Bronx and Manhattan or other parts of the state so that they can help pay for some type of housing when they get there. So there's a lot of different things that are out there. But even before COVID, it was a big challenge. It's only that much more difficult now.
Yeah, that data would be great. Thank you so much.
Thank you. Okay, we're going to our final two chairs for their second 5-minute rounds. First, Chair Julia Salazar.
Thank you, Chair. Commissioner, if I may follow up on Senator Bailey's question regarding Tier 3 violations, could you briefly define what is no longer considered to be a Tier 3 violation?
We just published the regulations on that. There's a number of them that are no longer Tier 3. I don't have them off the top of my head, but I certainly can pull that information together and get it to you.
Excellent, thank you. And I want to ask, when DOCS reports or records the number of people who are currently held in a special housing unit in state facilities, does that include people who are kept in keep lock in their own cells, meaning people who are confined for 17 hours or more for disciplinary purposes? And if it doesn't, could you tell me how many people are currently kept in keep lock or for the disciplinary purposes in their general population cells?
Yeah, if you're in keep lock in your own cell, you're not in SHU. We do keep track of that population. We do have separate amenities for them, and as you mentioned, 5 hours time out of cell to still go to programming, et cetera. It is possible that you could be serving a keep lock sentence in an SHU cell, in which case other things kick in and which you will earn an earlier release. You get more credit if you're serving keep lock in an SHU cell. So I will get you, if you want, the total number breakdown as of a particular date.
Thank you. And I wanted to go back to COVID-19 regulations. Actually, how many people who are incarcerated have applied for medical parole since the pandemic struck last March, approximately?
It's a high number. I don't remember it off the top of my head, but it is a high number that have applied. But remember, a lot of people applied because they felt I am at risk because I have asthma or I'm a smoker or whatever it is. And that's not a ground under the statute, the way it's written, 259 R&S in the executive law, of the standard you have to meet. You actually have to have a condition that's either terminal or so debilitating that you can't reasonably pose a risk to the public. And we've had a bad experience where even someone in a wheelchair who ended up in a nursing home was able to sexually molest another patient in that nursing home, even though when they were in with us, it took them a half an hour to go 30 feet in their wheelchair.
So I guess the question is more broadly, how many people have been released from prisons in New York specifically for COVID-19 related reasons, including medical parole? It sounds like you don't have the number exactly. Actually, you know what? I'll just ask you, what was the rationale for the COVID-19 related release eligibility that docs had set up and limited to people who were within 90 days of their release date, limited to those who were convicted of non-violent crimes? What was the rationale for that eligibility?
It was a balancing of public health and public safety. These are individuals that were scheduled to be released within 90 days. So we created the legal means for that to happen by transferring their legal status to a residential treatment facility. And then in that basis, they physically were allowed to go home if they had one, they had approved housing. We didn't want to just release them into the homeless shelter. So they were non-sex, non-violent individuals and the less risk to the public, but achieving less density while they were still in the correctional system.
And for the COVID-19 related release mechanism that docs had initially set up last April, I understand it was limited to people aged 55 and older, in addition to the previously mentioned criteria. What was the rationale for that age criteria initially? Is 55 the age at which docs defines people as aging or elders in prison?
It's something, that researchers have basically said it's a good measure. The 65 and older in the community translates to 55 and older in prison for two reasons. One, a lot of the cohort that are incarcerated have neglected, public health, their health concerns. Many of them are smokers, many of them are drinkers, maybe they use drugs, whatever. When they come to us, they're already, at a disadvantage. Prison is stressful. That can also exacerbate things. So 55 and older is a decent benchmark to look at and consider people to be, the senior cohort, so to speak.
Thank you, Commissioner. That's my time.
Thank you. So since I'm on the north of 55, I'm not sure how I'm feeling about this discussion, but we'll leave that alone for now. I am going to allow Assemblymember Aubrey, who snuck in with this hand very late in the game, to jump in for 3 minutes before I go to Assemblymember Weprin to close. Hello, Assemblymember Aubrey. You're muted. I feel you're driving and you have no voice. There you go.
I have a voice now.
Okay.
Good. Commissioner, good to see you. I think you've got to be the longest acting commissioner that I've ever heard of in the state system. And I know there's no Tony Award, there won't be an Emmy, but it's good to see you. Glad that you're still around. I have two questions. One, what is the current budget for the prison industries component of the correction system?
I have that number, but I just haven't memorized it. It's a separate appropriation in our budget, but I can get you that number, Assemblyman.
Okay, that would be helpful. And the second, the rules that were agreed to, or the agreement made by the leaders 2 years ago with the governor in regard to the maintenance of SHU, took a very long time to get approved. Is there any reason why it took so long?
The rules were studied for quite some time, and we had to get public comments from people. It was just a lot of different complications to consider them, but they've been adopted. They definitely changed things in dramatic ways, and we'd love to be able to explain to staff everything that has been done to get us to where we are today, everything that will be done to get us to where we are as the ROUs come on board and all the different amenities that you can get as conditions of confinement.
Those rules also now have been adopted for localities. Is there any assistance that is going to be provided through the executive budgets for those localities to implement the same rules?
I can't speak to the localities, Assemblyman. I'm unaware of, whatever arrangements have been made and what role an entity like the State Commission of Correction might play vis-a-vis them. I don't have any firsthand knowledge of that.
Okay. Thank you very much. Sorry to hold you up. Thank you, Senator.
This is my
for-
Academy Award, by the way.
All right.
I could never trust you to keep straight, Take care, my man.
Good seeing you, Assemblyman.
Thank
Good
you,
to see you.
Assembly Member. And now to close, Chair of the committee, Assembly Member Weprin.
Thank you, Senator Krueger, and thank you, Commissioner, for being patient through these many hours of testimony. I understand I have a bill that just passed out of committee. It seems like a long time ago, but it was actually this morning. And it would basically give you more authority to release inmates to home confinement, similar to the federal system. And I know you've pointed out that medical parole is not necessarily the end all, and it's not solving some of the problems. So the question I have for you is that something you would support? And we're hoping to have that in place.
Assemblyman, I love the working relationship you and I have and the mutual respect, but as you know, I can't comment on pending legislation, so I will not be able to give you any feedback on that.
Okay. I'm going to just ask a couple of questions about aging in prison, because I know that's been coming up, and I know there's strong support for some form of elder parole bill, which has been around for a long time. How many people 55 years or older are currently in DOC's custody? And I know you're obviously focusing on 65 for the vaccine, but can you give us some kind of figure on how many we now have over 50?
I might be able to. I have somebody in my office trying to look that up very quickly. I know it was slightly more than 1,000 for 65 and older.
So 55 is much higher, obviously.
Yeah, no, it is much higher.
What would be the average cost of incarcerating an older person? And how does that compare to a younger person? Because I know there are a lot of medical issues associated. And as you pointed out at a prior hearing a number of years ago, that people age much quicker in prison, and 55 is really, in the outside world, is equivalent to someone much older.
How many? Earl, to answer your early question, it's about 5,000 individuals that are 55 and older in our system. And I believe someone else previously asked the difference in the cost. There is a higher cost for individuals that are older, and their medical needs are exacerbated, but I can't give you a dollar figure. It'd be something very hard to quantify, really, when you look at the different units that we have, and the dialysis and the regional medical units and the unit for the cognitively impaired. I will tell you, though, that we are trying to institute good programming for them to make them feel at ease and make them still feel important. We may, start a feline program at Adirondacks and college program. You're never too old to go to college. So, we do try and keep them feeling useful and important and having value.
Okay, thank you, Commissioner. I know the issue of tracking deaths in prison, and illness as well, has been a current issue. Let me ask you a question. If an inmate serving a DOC sentence dies in a hospital or ambulance, how is that death classified?
It's counted as a DOC's death. It will require an autopsy to be performed by the coroner. Every doc's death, a facility death, is by a coroner. In fact, the correctional law specifies that we send people to outside hospitals. They are legally still in our care and custody. We just enforce appropriate security measures. So every single individual, if they're in the ambulance on the way, they're in an outside hospital, whatever they are, they're counted as a death of a correctional facility. Autopsy is required. We reimburse the locality for the cost of the autopsy.
Good. I'm happy to hear that, because that has been an issue, as you know, with nursing homes, and certainly, we would consider that a death as well from a correctional facility. I've got 30 seconds. Let me just ask let me see what I didn't cover. How often are inmates tested for COVID? Or is it only symptom related and requests?
No, we basically tested the entire system. We started with those that were displaying symptoms. We expanded that for asymptomatic, then we expanded it to those in quarantine. Then we did certain cohorts like the seniors, and then we finally did the entire system. And right now, we continue to test anybody that's displaying symptoms or in quarantine, including asymptomatic. And now we also superimposed on top of that a randomized selection, depending upon the size of the population at a particular facility. We go to different housing units, and various people are selected randomly so that we can get real feedback as to the presence of COVID in our system.
Okay, thank you, Commissioner. Thank you, Madam Chair. I think my time has expired.
Yes, it has. And Commissioner, not really, but your time has expired with us. So thank you very much for being here with us. And I guess for being the longest living acting commissioner in New York State.
Thank you very much. It was my pleasure.
All right, and now we're going to call up our 8th government representative for today's hearing. And that is, and I see that he's here patiently waiting, Acting Superintendent Kevin Bruin, New York State Division of State Police. Hello, Acting Commissioner. Acting Superintendent, excuse me.
Yes, thank you very much.
Thank you.
Thank you, Chairs Kruger and Weinstein, and distinguished members of the Joint Committee for the opportunity to discuss Governor Cuomo's executive budget for the Division of State Police. I am Kevin Bruin, Acting Superintendent. I've served the agency in various capacities for 17 years and as Acting Superintendent since November 2020. I'm truly honored to lead the dedicated sworn and civilian members of this great agency. I would like to thank the legislature for recognizing our critical mission to protect and serve all New Yorkers. Your support has enabled the state police to earn its reputation as one of the top law enforcement agencies in the nation. For more than 100 years, the state police has consistently provided a high level of professional public service. We learn and adapt to the needs of a constantly changing society, and we strive for continuous improvement in every aspect of our work. Our mission priorities include improving highway safety, providing professional police services and investigative support, detecting and preventing terrorism, and preparing for and responding to emergencies and disasters. 2020 brought several challenges to New York, none more so than the COVID-19 pandemic. I am proud that our troopers have worked continuously for the state as we played and continue to play a significant role in the state's response, including the transportation of thousands of test samples from across the state to the Wadsworth Laboratory in Albany, assisting in establishing, operating, and securing state COVID testing sites and vaccine sites, supporting other agencies and local agencies and enforcement operations to help stem the spread of the virus. As you know, the state police is unique in that we are the only full-service law enforcement agency with statewide jurisdiction. In response to emergencies or natural disasters, the state police has the ability to deploy a large number of professionally trained police officers throughout the state and beyond on short notice. For instance, last summer, following the death of George Floyd in Minneapolis, our troopers were deployed throughout New York at the request of numerous local and city police agencies to assist with efforts to assure public safety. Over the past year, the governor and the legislature have enacted several police reforms, including a new body-worn camera program directed at the state police. Since its passage in June, we have worked diligently to implement this program. The governor and the state police recognize the dynamic nature of terrorism and extremism of all types around the world and domestically. Our role in the state's counterterrorism efforts help provide a wide range of initiatives and capabilities, enabling New York to remain one of the safest states in the country. New York does remain a top terrorist target, and our expanded presence in the city, primarily at mass transit hubs, bridge and tunnel crossings, has enhanced the collective effort of the state and our partner agencies to detect, deter, and respond to terrorism. Disaster preparedness is a top priority of the governor, and we continue to partner with the Division of Homeland Security and Emergency Service to improve response readiness. This partnership has enabled the state police to better coordinate with state agencies and provide local support to communities following significant events. Illegal drug use, in particular the availability of heroin, opioids, synthetic drugs such as fentanyl, along with the toll they inflict, remains a critical public safety issue. Building on the resources and training provided over the past few years, the state police will continue to aggressively investigate drug-related offenses, particularly criminal trafficking, as well as assist local police agencies with their investigations whenever requested. Our highest priority continues to be the safety of the public and our troopers who protect them. With your support, the executive budget continues to provide our troopers with the necessary equipment, training, and other valuable resources to achieve the best levels of safety as they carry out their duties. Again, I am exceedingly honored to represent the nearly 6,000 dedicated men and women of the Division of State Police that serve and protect the people of this great state. They do so selflessly, with tremendous pride, and at sometimes with great personal sacrifice. I thank you for your support on behalf of the state police, and I welcome any questions.
Thank you very much. Our first questioner will be Senator Jamal Bailey, Chair of Codes, 5 minutes.
Thank you, Madam Chair. Thank you, Acting Superintendent, for your leadership and for your testimony. I guess I just want to get into the conversation about the body cameras. So what is the exact amount of body cameras that will be provided in this contract?
I'll have to get you the exact number. The number is going to be sufficient to cover the troopers on patrol who will need to have them, as well as backups should they go down, and they need to be recharged and the data needs to be uploaded. So we have to have a certain number to cover that.
Okay. So I guess that was my next question. So on patrol, is it so they would be given to individuals who are actively on patrol at that time, and would they be switched out from member to member? Would they be permanently assigned, or how would the body cameras be assigned?
The body cameras are assigned to the members, partially because they need to be recharged. The shift lasts 12 hours. The data they collect needs to be uploaded. The upload speeds, as you can imagine, the connectivity is better in some places than it is at others. So there will be enough body cameras so that an individual going out on patrol will have one.
Okay, undoubtedly hiding the need for more broadband around the state, and especially in the upstate regions. So the access to that body camera footage, would that be limited to that individual officer, or would that be available to other folks such as superiors or other officers?
Well, it's going to be available to other officers, other troopers, investigators. It may be available for other purposes as well. There'll be audits to make certain that the troopers are engaging the cameras when they should be. The data can be uploaded and in association with a criminal case and provided to the district attorney and ultimately the defense. It'll be stored and it could be used and foiled should someone want that body camera footage for an auto accident or something that they deem necessary.
Okay. And if an officer is found not to have properly engage the body camera, are there going to be disciplinary procedures? If so, what would they be?
Well, you can't specify exactly what the result of a particular disciplinary procedure would be, but I have to tell you, the state police, we have a rule for everything, or it feels like it sometimes. And if you are given a piece of equipment and we have rules that say you need to engage it under specific circumstances and you don't do it, you will get supervisory attention, and it can escalate depending on what happens.
Okay. I mean, that's the, well, I guess I would ask one more policy related question that I asked Commissioner Green from DCJS, and you may have a similar answer, but I figure I'll ask you as the state police superintendent. Any position on the use of kettling or certain irritants during protests? Is there a position that the state police has on that?
Well, the position that we have is that the interaction with mass demonstrations and protests are delicate, and they need to be handled with planning. They need to be handled with training. They need to be handled with express supervision. I wasn't familiar with the term kettling until I heard you use it. And I'm now aware of it. We don't use that practice in specific because, as I understand it, that practice would force people into an area where they can't get out of, and we simply don't do that. But the fact of the matter is that those what starts out as a peaceful protest can turn difficult, and we have to have the rules of engagement and the operational plan that we have set out before we engage with the public. So before anything happens, we need to lay those things out. We do have a highly trained specific unit that will often do this sort of work, and we have a very explicit manual that governs their action, that lays out, this is for people's First Amendment rights. People's First Amendment rights need to be respected and ensured that they can carry on peaceful protests.
Well, one, let me thank you for your testimony. And let me also thank you to the women and men who serve our state. We appreciate the sacrifice that they make for our state. And on a personal level, I appreciate you opening up the gym to us on Tuesday nights during better times on Washington Avenue so that some members and we can play basketball. So I just want
anytime, Senator, just don't ask me to play.
Listen, when we're back, you have the keys, literally and figuratively. So
I'll open the door, but I'm not playing.
I appreciate you. Thank you very much.
Now we've jumped to what really Jamal Belli cares about. So thank you.
Apparently.
Basketball and policy.
I know. It's a good mix. Assembly Member Dinowitz.
Thank you. So when the New York passed the SAFE Act, it unfortunately ended its own attempt at creating a database to collect and submit all ballistic evidence of weapons sold in New York. Do you know when will the state create its ammunition database to track sales to residents who may be assembling deadly stores of ammunition as mandated by the SAFE Act? Because it's kind of been a long time already.
I think you're referring to the NIBIN system, which was shut down, which was collected expended brass when a gun was sold, and the creation of and that was true, that was shut down. I don't believe anyone uses it anymore. And you're talking about the recurring issue of the ammunition database to check whether someone's lawfully able to purchase ammunition. That continues to be an IT issue, and it continues to be not in a current position to be deployed effectively.
Okay, I would just urge that we try to address that issue. 2 years ago, the legislature enacted a law that allows law enforcement to remove firearms from people charged with domestic violence offenses, and it also allows courts to revoke or suspend their firearms licenses. This information is then reported to the state police and DCJS, presumably for inclusion in the statewide license and record database established by the SAFE Act. Now, from what I understand, this license and record database, like the ammunition database, is still not operational 7 years later. Is that true? I understand it's true, but I just want to double check that. Is that the case?
No, I understand that as an ongoing effort for as far as that part of it is going.
Ongoing to establish it, or that it's already working?
No, it's an ongoing effort to make it operational.
Right. It's, okay, I mean, it's been a couple of years already.
Yeah,
So
there's
do you
some-
have any, I'm sorry, go on.
The challenges are significant due to the nature of the way and the length of time that we've had the pistol permit database and pistol permit records. They are on many different platforms, and that data has to be cleaned up. In addition, we have the ongoing re-registration and registration of the assault weapons and the pistol permits. But I understand
So
your
do you
concern.
have- Yeah, I mean, do you have a timetable at this point, or is it pretty much open-ended?
I don't have a timetable, but I can get one.
I'd appreciate it. And what about the ammunition database? I mean, that's a pretty long delay. Do we have a timetable for that?
I don't, but I can follow up with IT. It's largely an IT program at this point. It's a heavy lift to work that out.
Okay, thank you very much.
Okay, thank you. Senator O'Mara has popped into the scene. Hello, Ranker on Finance.
Hello, Chairwoman. I've been here all along. Just been
I know,
quiet.
but we haven't heard from you all day, so I was a little worried about you.
The superintendent, thank you for being here today, and thank you for your long and really great role and career in law enforcement with the New York State Police.
Yes, sir.
Can you kind of describe for us with the prospect of the legalization of recreational marijuana, first of all, how is enforcement going to be handled with that, since we don't have a breathalyzer type test for that? And what additional resources is the state police going to need in regards to impaired driving while intoxicated under the influence of marijuana?
So we enforce driving while impaired right now. We do so successfully, and it largely is not going to change. It will change in one significant way with the governor's program bill, and that is it will allow us to take saliva like a breath test. There is a test at the lab that is ready to go, and I've spoken with my toxicology people, and they feel that they can handle the test and the increased, if there is some increase, number of tests. But the approach to intoxicated driving is going to remain the same. We teach at the academy right now, every person graduating as a trooper from the New York State Police Academy is what's known as an A-RIDE. An A-RIDE is not a DRE, but it's an enhanced detection training program. It's a 2-day course in the detection of drug-influenced driving. Also, within the year, we're going to have every trooper trained as an A-RIDE. So we're going to have that in our back pocket as well. But the core policing mission will remain the same. Observations of erratic driving, pulling someone over, gathering evidence by paying attention, engaging the driver in conversation, and observing the driver's behavior, gathering the evidence of impairment, getting the saliva sample and having it sent down to the lab to determine impairment.
On the saliva sample, I'm not familiar with that. Is that going to indicate like a blood alcohol level, a THC alcohol level, or a THC blood level?
That's a good question, and I asked it myself recently, and the answer is no, it's not. What it's going to do is detect the presence of THC. The challenges with THC and determining based on a particular level impairment remain. That's an ongoing scientific kind of discussion.
Well,
that's why the troopers' observation of impairment are critical. Do you have marijuana in your system, and did it impair your driving?
But I think that's going to be problematic, since THC stays in your blood system far longer than alcohol does. So I would think that would be unfair evidence in many cases, perhaps, for somebody that is not under the influence, but may have smoked marijuana 10 days before.
Well, you've hit upon the exact issue. And that is why I said it's two pieces. One, do you have marijuana in your system? And is there evidence of impairment? Sufficient evidence of impairment beyond a reasonable doubt or probable cause, depending on the place you're at. That's the standard we have now. In other words, and that's the standard we've had for years. Is there evidence you've taken marijuana? And can the police, the trooper, county sheriff, or a city police officer, by evidence or testimony or other things, indicate that your driving was impaired?
What will the policy of the New York State Police be as regarding marijuana use of state troopers?
They will not be able to use recreational marijuana.
Okay, thank you.
Thank you. Next up is Assembly Member Chuck Levine.
Thank you, and thank you, Acting Superintendent. Two things I'd like to discuss. First of all, following the brutal assault on the United States Capitol on January 6th, when I learned that the state police were going to be watching our state capitol, that gave me great comfort. So thank you, and please thank the members of the state police for that. Secondly, Scott Beigel was a New Yorker. I don't know whether his name is offhand familiar to you, but he, being a New Yorker, didn't make
Marjorie Stoneham, I think.
Yes, yes. But being a New Yorker didn't make him a hero, but protecting his students at Marjorie Stoneman Douglas High School nearly 3 years ago in Parkland, Florida, and saving them during which he was murdered was a hero. So the state Senate today passed the Scott J. Beigel Unfinished Receiver Act, making it illegal in the state of New York for non-licensed gunsmiths to possess the component parts that are used to make do-it-yourself ghost guns, and making it illegal to sell those. Now, we have seen people arrested in New York State, on Long Island, in Port Washington, in Orange County, in Syracuse. And in 2020 in Syracuse, the police confiscated 25 ghost guns, and the list goes on and on and on. And the FBI instructs us that between 2010 and 2020, there were more than 2,500 arrests for ghost guns. So question I have for you, and let me just set it up this way. The District of Columbia and other states are considering making the possession and sale of the component parts of these do-it-yourself sophisticated tactical weapons illegal. Question I have for you is this a cause for concern? Is the ready and easy ability to build these weapons from purchases online in the open source market, is that a cause for concern for those of us in the state of New York?
Without commenting on potential legislation, non-serialized guns, untraceable guns are a concern. If you had asked me that question 5 years ago, even 2 or 3 years ago, I would have said they're not prevalent in New York. 1, 2, 3, 4, 5 cases a year. And I would have said they'll largely appear in Western, meaning Western United States, in gang-related kind of context. But that is not true in 2020. We've seen a substantial jump upstate and in New York City of the use and recovery of ghost guns.
Thank you, Acting Commissioner, and please give our warmest regards and gratitude to the men and women of our state police. Thank you.
Thank you.
Thank you very much. We have Assembly Member, well, actually, because he's a ranker, let's do Assembly Member Lawler for 5 minutes. Ranker on Government Ops.
Thank you. Appreciate your time today. Just following up on the cannabis legalization. Currently, there's only one state that puts a cap on the potency of marijuana and the THC levels, and that's the state of Vermont. Do you believe that as we debate the issues surrounding this, that we should have a cap on the potency of marijuana if it is in fact legalized?
Yeah, thank you for the question, but I'm not going to comment on pending legislation. We leave it to you guys, and if it's signed into law, we'll enforce it.
Okay. Following up on my colleagues' questions related to the trying to determine someone's THC level, obviously an oral swab, if that is in fact the case, that we're going to go down that road. How long does that take to get a result on that?
Well, there's two things, well, three. First, we don't have a test that will determine the level or concentration of the THC in the bloodstream. It's that two-part test I said, presence, and then we have to independently verify, right? The other thing is that there's two oral swab ones. One's a roadside test, like a pre-screen device in an alcohol case, where the trooper could have a small handheld thing. That's been experimented with, and the case and the test I'm referring to is a forensically valid test. It would be a test that would be gathered at the either roadside or at the station, and then transported to the lab, and the test would be run there.
Okay. And do you know, generally speaking, how long it takes to get a result on that test?
I don't. I suspect that it depends on the volume in a particular time frame, and that may affect how the trooper proceeded at that point, in terms of whether somebody was arrested and charged or done something else with. But clearly, if the trooper has taken a sample like that, the person was exhibiting substantial impairment. Otherwise, they wouldn't have been asked for a sample. So there'd be actions that had to be taken roadside to ensure safety, among other things.
Okay, so generally speaking, at that moment they would treat it as they would a DWI.
They would treat it like as a DWAI.
Right.
The test that I'm talking about is forensically valid, meaning it's like a blood test. So it's at that level of precision. Now, it's not measuring level, but it's measuring presence. So it would be something that they would have to have sufficient probable cause to charge DWAI drugs.
Okay. Totally switching gears. The last legislative session, this body repealed 50A of the Civil Rights Law. You're familiar with that?
Yes.
Okay. This is more of a comment than a question, because I'm sure you're probably not going to want to opine on this. But are you aware that under the rules of the New York State Assembly, Rule 8, that the members of the State Assembly exempt themselves specifically from being subject to FOIL?
I have not made a particular study of the rules of the Assembly, no.
Okay. Do you, just so I'm putting this out there for you to be aware, obviously there's a clear hypocrisy between what this body has chosen to do with respect to the officers who serve under your command and their personnel files, and making them subject to FOIL while expressly exempting themselves. So just wanted you to be aware of that, and happy to send you Rule 8 of the rules of the New York State Assembly, so you can see that at some point.
Thank you.
Okay, I have no further questions. Thank you, sir.
Thank you.
Thank you. I'm sorry, I'm going to ask you a question just in follow up on the marijuana. So it's my understanding that New York State Police can pull you over for appearing to be driving dangerously right now. They can give you field sobriety tests. They can take away your right to drive your car, and they can do follow up with chemical tests that may or may not be available depending on what you have in your system, because obviously you could have alcohol in your system, you could have marijuana, you could have, I guess I'll say, hundreds if not thousands of prescription drugs. So that's correct, that your police have the authority to do that now?
Yes, I would only say that we don't have the authority to take away anyone's right to drive, but temporarily we would have the right to stop you from driving while we conduct an investigation.
Thank you. Yes, I wanted to make sure I got that right. Oh, somebody, okay, I think they went back on mute. Thank you. Next, we have Assembly Member Tanusis.
Thank you. Thank you very much. Thank you, Superintendent, for being here. I just wanted to follow up in regards to Senator O'Mara's questions regarding the possibility of passing the recreational marijuana. I found myself as a prosecutor a few years back prosecuting these cases that I found that cases that were solely based on the testimony of police officers were substantially weaker compared to those cases that, for example, driving while intoxicated, where an individual, a portable breath test was conducted, then they would be taken to an IDTU room where they would blow on an intoxilizer, and we had a whole scientific machine that we were able to bring forth in court to show that the person was driving while intoxicated. Are you somewhat concerned that if recreational marijuana is passed this year, that the cases that are brought forth by arrests by your troopers will not be quite as strong as those cases of prosecuting while intoxicated? Because in that case, there is an actual scientific machine. Defense attorney could attack the machine. You could talk about procedure, where in this situation, a state trooper is testifying about his observations. A state trooper without any type of test is basically going to be testifying on assumptions.
Well,
So are you concerned about that?
Well, you're lucky.
And I'm sorry to interrupt you, just as a follow-up question, when will that machine be available, the machine that you were telling us about?
So it's available now. We have it.
Okay, thank you. If you could
And
answer.
you're lucky that you're not here at the academy calling it a machine, because they would make you run laps. It's an instrument.
God knows I could use the laps, by the way. Thank you. Are you concerned at all, Superintendent, about that?
You know, the one of the things that's going to address it, first of all, I expect New York State troopers, and it's been my experience that they do this, is to conduct careful investigations and to testify clearly and accurately to the point where a jury would trust what it is they're saying and let the chips fall where they may. But it is an artifact of body cameras that I don't know as anyone's thought about clearly, but an activation of a body camera, if someone is behaving in such a way that mirrors what the trooper saw and is describing, and her body camera footage plays that back, a juror and juries presumably will have an even higher degree of reliability about their testimony.
But it's not as strong as an intoxilizer, though, correct?
You know, I disagree with that. You know, I think the intoxilizer and the instruments that we have are fantastic. I think that the testimony properly done, the evidence gathered, observations from the vehicle, observations from the car, things that are recovered from the car, other witnesses can build very strong cases. And quite frankly, this is the environment we're at now with DWAI cases. And, you know, I haven't seen any significant issues. I know what you're saying, that we're not going to end up with a particular threshold, but we have if the legislation is passed, we have the instrument, we'll have the methods to collect it, and we'll have the forensically valid results.
Thank you for your time.
Thank you, sir.
Thank you. Assembly Member Latrice Walker. Is there, Latrice? Don't think so.
I'm here, but of
There you
course
are.
there's like, we
Okay.
have conference going on, as well as a number of other things. So I apologize for
Okay, just wanted to make
juggling
sure
back
you're
and
there.
forth. But thank you very much for your testimony today. Mr. Superintendent. I have a really quick question. So there was a budget request for body-worn cameras for the state police. However, the request didn't match, I believe, what had been previously stated was the need for the state police in order to get that done. And so how much is the request this year, and what is the difference between what you indicated in the past was required than what is being proposed in this year's executive budget?
Well, I'm not exactly familiar with the prior request. I know we have made requests and wanted to pilot body cameras, particularly in some of the more extreme environments in the mountains and other things. But based on the passage of the law, which had in June, which had very specific activation requirements, we ended up having to get essentially only one product met that need. So that might account for what you're seeing. It's my understanding that the cost is roughly about $8 million a year.
Okay, all right, no problem. So what we did see was a request in the past for about $15 million. But it looks like there's about $7 million in this year's
Yeah,
budget.
and these are recurring costs. Yeah. Again, because the law was passed with very specific requirements, there was really only one product on the market that would meet the needs. And that then dictated kind of everything else from there. That comes with, it meets our needs and it meets the requirements of the statute in terms of activation, signal activation.
Okay, all right, well, just wanted to, so you're saying it's only gonna cost you $8 million in order to fully implement state body worn cameras for this year, and my face is moving on the Jeopardy.
That's all right.
Hollywood Squares board.
Yep, that's my understanding of the costs of the cameras. But
Okay,
there are additional costs for personnel and other things, but that is the cost of the cameras.
so there is an additional cost, but is that being taken into account for with respect to the budget request that you've put in?
Yes,
Okay, all right, awesome, thank you.
thank you.
Thank you. I see we've been joined by the Chair of Government Ops, Ken Zabrowski, and it's been a busy day for everyone. Please give him 10 minutes on the clock. Thank you.
Thanks, Chair Kruger, and I won't need the 10 minutes. Let me just say, Superintendent, thank you, and please thank your officers for all the work that they have been doing during these difficult times. I know they're out on the roads, they're in our communities. When this pandemic started, by no means did their jobs stop. They had to figure things out at times where we had absolutely no idea how this was being transmitted, where it was being transmitted. They had to do their jobs. So, we please express our gratitude for all their hard work and what they do in protecting us.
I will.
I just wanted to reiterate a little bit on the body cam question. And my understanding is that it's a multi-year request. Certainly, I believe we're going to be funding 1 year this year of $8 million, but I believe it was a 5-year request or estimate of about $8 million a year for 5 years, which significant amount of money. So my understanding is that would cover the total cost for not just, I think, the 3,000 or so cameras now, but all the logistical and other hardware, software things that go through it for the next period. Is that your understanding?
Yeah, that is my understanding. That is all the products associated with the camera and support with the camera.
Okay, all right. We appreciate that. And, certainly I'd love to keep in touch with you for both the, the rollout of this program as to how you think it's going. Is there sufficient funding? Does it provide, your officers with the, the proper support, so that they can do their job, and further on, obviously, with a host of other issues. Just wanted to say that, we're there for you for continued collaboration going forward. So thank you.
Thank you.
Okay, thank you. And Assemblymember Mike Riley.
Thank you, Madam Chair. Thank you, Superintendent, for your testimony. what a couple of things I wanted to ask about was, I know you mentioned the AROD training. New York City Police Department is doing an offshoot of the DRE program, which is like a 4-hour class. Do you think there's a possibility of the AROD training being administered to local police departments throughout the state to help with the legalization of marijuana if it moves forward? Because I know the DRE program is expensive, and many times it takes the patrol officers away from their duties for some time because of the extent of the training. Could you tell me how much that training is, the DRE program, and if it's feasible for AROD?
Well, the ARIDE program, in order to be qualified for the DRE program, you have to be an ARIDE. And as I said before in testimony, that every new New York State trooper is qualified as an ARIDE as they come through the academy. And by the end of the year, we'll have the entire road trooper force trained as ARIDEs. DREs are akin to, as you know, a test. It's a very extensive training, medically based, and all the rest of it. There is only so much bandwidth that the training academies that will do this. At one point, there were only 2. I think there's plans that they'll add 2 more online, but there's only so many slots. I think New York City has about between 12 and 16.
Yeah, 16.
And I have about 110. My goal is, and it will take time, is to make that number, that fixed number of DRAs, closer to 200. But we have, resources and ways of dealing with the issue up front. And I'm certain that other departments will be and other agencies will be looking at ARIDE training.
Thank you, Superintendent. So I also wanted to touch on the fentanyl analogs. I know that we have some legislation that's in to allow the Department of Health Commissioner to add any necessary analogs. Do you think that would help with investigations?
Well, I don't comment on pending legislation, but fentanyl is extremely serious and extremely dangerous.
And I wanted to touch on one last thing about I know my colleague earlier mentioned ghost guns. When that legislation came up, I raised one issue that unfortunately the possession of a ghost gun right now would be an e-felony. And, as you know, if you have a firearm with a untraceable serial number, it's a D felony. Do you think that it would help with investigations if it was a D felony for a ghost gun? Because as we know, as an e-felony with bail reform, it's currently eligible for a desk appearance ticket.
Well, I hate to repeat myself and say I'm not going to comment on pending legislation, but I'm going to do that. I am going to say the ghost gun situation has me concerned.
Thank you, Mr. Superintendent. I appreciate it. Thank you, Madam Chair.
Thank
Stacy.
you, Mike. Our last, I think, Assembly member, or the last hand I see up, is Chris Burdick.
Thank you. I appreciate it. And thank you for the testimony. And I also echo the words of Ken Zabrowski to thank you and your officers for the heroic work that you've done during the pandemic. We greatly appreciate it. There's been a great deal of discussion in this line of questioning regarding enforcement issues in the event of the possible legalization of recreational marijuana. I echo the concern on training for local police departments and do hope that there can be coordination in that regard. I think that would be very helpful. I had a question regarding if you happen to know whether any of the funds that would be raised from this in taxes and fees would be going to any kind of drug prevention, drug abuse prevention programs. It may not be your wheelhouse and I can check elsewhere.
It is not my wheelhouse. I do not
Okay,
know.
and a different question is the question regarding enforcement. Have you folks looked at what's going on in other states with respect to whether or not the measures that they use, the instrumentation that you described, have been effective in getting dangerous drivers off the road? Do you feel confident that you're going to be able to do that effectively?
We've looked at data from other states on a wide range of issues about legalization. I've had contact and conversations with my opposite numbers in other states. And I keep going back to the fact that we do this already. We do this job already. We make arrests for impaired operation based on the use and THC intoxication. We do it. And I feel like I have every confidence in my troopers that they'll be able to do this.
That's very helpful to know and reassuring. Thank you very much.
Thank you. So it is my wheelhouse since I'm the lead sponsor of the MRTA bill in the Senate that Crystal Peoples-Stokes carries in the Assembly. And so the answer is, in our bill, we hope that up to 25% of the revenues from legalized adult recreational use marijuana would go towards drug treatment for serious, dangerous drug addictions and education to discourage people, particularly young people, from using drugs, Chris. So that's the answer to that. I also want to thank the acting supervisor. I am very confident his state troopers are perfectly capable of handling impaired driver stops, because as he just said, they do it every day. You know, there's a lot of things people can have opinions about with marijuana, but the one we really all need to agree on, it's already here. It may not be legal, but it's already be here and being used more than pretty much any other drug in the state of New York. So many of these questions aren't really new questions. I do have one final question for you, Superintendent. So the last year and the pandemic has changed almost everything in our lives. What are the state police doing in my city nowadays? What do you have them doing?
In New York City,
Yes, sir, I'm from New York City.
we provide a number of roles and do a number of missions in New York City. Our presence, obviously, at the transportation hubs, the train stations, the bridges and tunnels. We are also at the airports. We have investigators that follow, that are on the hate crimes task force in the city. We have investigators assigned to the Joint Terrorism Task Force and investigators that work closely with the Drug Enforcement Agency on very large narcotics cases, just to name a few of the missions.
And so you still believe that the number of state troopers assigned to New York City is the justified use of your budget costs?
Absolutely. It gives us flexibility to do things, act in certain missions that are specific, and flexibility to act. I feel that it is justified. I have to tell you also, it has been a particular benefit with recruiting minority members. The folks in the city are able to see the troopers doing their work in the great uniform, looking great, and they can picture themselves doing the job. And it's been a true benefit to us.
That's very good news. On behalf of us all, thank you for your work. Thank you for your members' work. And we are going to excuse you for the day.
Thank you.
Thank you. And because it is now 6:10 and we started at 9:30 this morning, I am allowing myself a 3-minute nature visit. And everybody should just either also explore nature for 3 minutes or whatever you like. Just don't go anywhere because it's very fast. 3 minutes. Thank you. starting the part of the hearing where people who have asked to testify will be called up in panels. You'll have 3 minutes, each person on the panel. Then people who want to ask you questions, whether they are chairs or not, only get 3 minutes in total to ask the panel question and get answers. So I like to describe this part as speed dating. But it's also important to know that when you hear a question from a legislator, you know you want to follow up with them afterwards because you know you have more information for them than you can possibly give them in this ridiculously short period of time. For people who did not get to sign up to testify because they asked too late and there were no more slots left, and I apologize, we had to turn a lot of people down, you can still submit your testimony. It will still go to all of us. It will still be up for the public to view. And I always advise the testifiers, if you think you're going to read your testimony, that will be a mistake. You only have 3 minutes. You want to highlight the most important part of your testimony as far as what you're prioritizing in relationship to the state budget this year. The one thing I can say with confidence is we are all readers. All the legislators actually can read. And so we have full testimony in front of us or on our desks or on our computers or all of the above. So having said that as the rules of the road for the rest of this hearing, I'll now introduce our first 3 panelists, and they will do it perfectly, and then everybody will know what I was talking about. So we have Kristen Brown from the Empire Justice Center. We have Laura Abel from the Lawyers Alliance for New York. And we have the New York Legal Services Coalition, Molly Clifford. Hello, good evening. Kristen, you get to go first.
Thank you. Thank you so much. Good evening. My name's Kristen Brown. I'm the president and CEO of Empire Justice Center. We're a statewide legal services and advocacy organization for low-income New Yorkers outside of New York City. For my time today, I'm going to highlight 2 trends and focus on the importance of your continued support for allocation of the Legal Services Assistance Fund. We can all agree that COVID has really revealed deep structural inequities in our society and made existing problems more acute and complex for people in low-income communities. In the area of legal services, we find problems such as unemployment, eviction, lack of benefits, intimate partner violence, and removal proceedings that may have been navigated separately through different attorneys and organizations are now melded by the pandemic into a single landscape, often with an attorney as the main person who's triaging services and providing advice in a number of different areas. And this is a shift that we have had to navigate to meet the needs of our clients. A second noticeable trend is the digital divide. Reliance on technology has created very deep disparities between people who have tech skills and resources and those who don't. For example, during nursing home fair hearings and foreclosure proceedings, our clients often lack computers, technical skills, and reliable internet access to take advantage of virtual hearings. For Empire Justice attorneys, the pandemic has made it harder to collect evidentiary proof, maintain attorney-client privilege in the virtual setting, and have sidebar negotiations. The Chief Judge's Permanent Commission is studying how to examining the digital divide, and this is something we urge the legislature to look at. These trends are just part of the urgent need to fund civil legal services to help low-income communities cope with the pandemic and navigate structural complexities. For Empire Justice, the JCLS and Legal Services Assistance Fund money allows us to provide representation to immigrants, individuals who are unemployed, families with special needs, students, among others, and to provide training and technical assistance for students, as well as frequently asked questions for folks. We've had over 9,000 people access our unemployment frequently asked questions. To support this work, we urge you to support the Legal Services Assistance Fund, including domestic violence legal services at last year's levels. I also want to highlight that in spite of your much appreciated support last year, none of the LSAF or domestic violence funding for the current year, which goes to provide services all across the state, has been paid to providers, nothing. We understand this is a very challenging time for most people and there's a budget deficit, but the LSAF funds have their own revenue source. They don't come out of the general fund, and they do play a crucial role in pursuing life's basic necessities for low-income New Yorkers. So we look forward to working with you all to make sure that this crucial funding is available for both this year's LSAF and the one to come. Thank you for your time.
Thank you. Next, Laura Abel.
Thank you. Thank you for this time, and I will be brief. I'm Laura Abel. I'm Senior Policy Counsel with Lawyers Alliance for New York. We are a nonprofit law office that provides business and transactional legal assistance to the nonprofits that serve low-income communities in New York City. Last year, in the last days of budget negotiations, as the pandemic was closing everything down, an unfunded administrative burden on thousands of charities was inserted into the Public Protection and Good Government Article 7 bill. The apparent goal of that provision was to track the flow of resources from 501c3 public charities to 501c4 social welfare organizations that engage in a lot of lobbying or in certain types of issue advocacy. But perhaps unintentionally, the bill swept way too broadly. As a result, thousands of charities that have nothing to do with social welfare organizations have a new, completely unnecessary bureaucratic hurdle this year. They have to take the annual financial reports that they already file with the Charities Bureau and file them again with the Department of State. They have to pay a second filing fee and deal with the Department of State's different and earlier filing deadline. But perhaps most importantly, they have to worry about a potential threat to the privacy of their major donors. The Charities Bureau has decades of experience and careful procedures in place to protect the privacy of people who contribute to these purely non-political charitable organizations. The Department of State doesn't. This year's One House bill should fix last year's overstepping. They should eliminate the dual filing requirement. They should implement measures to protect privacy. In my written testimony, I've pointed you to an assembly bill that has language that could fit very easily in the One House bills. Thank you.
Thank you. And Molly.
Thank you. I'm Molly Clifford, and I'm the Interim Executive Director of the New York Legal Services Coalition. We're a nonprofit consisting of 49 civil legal services providers. Collectively, we serve every New York State county and provide high-quality legal services to hundreds of thousands of low-income families in New York every year. Civil legal services address a fundamental gap in access to justice, the gap between low and moderate income households in need of legal aid and the number who can be helped by our providers. For decades, that gap remained at a troubling 80%. Thanks to ongoing support from the legislature, state agencies, and the judiciary, CLS providers in New York have narrowed that chasm to approximately 60%. While this is a positive trend, there are certainly significant needs that remain, made worse by the pandemic, particularly among low-income New Yorkers and communities of color. At the coronavirus peak, our network effectively pivoted their workforces to meet heightened demand to ensure New York's families, hit disproportionately hard by the pandemic, have a sense of stability during this time of crisis. Amidst these staffing demands, staff continues to work within our many practice areas, including domestic violence, eviction, foreclosure, and immigration matters. Some matters, especially economic and housing stability, are being exacerbated by the pandemic and will affect families throughout 2021 and beyond. We're particularly concerned about the eviction and foreclosure moratoria, which upon expiration will bring a tidal wave of evictions and result in sharp increases in homelessness in the communities we serve. We stand ready to meet these new and shifting demands and appreciate the joint efforts of the legislature and OCA to support legal services funding. We respectfully ask for continued state support in two key areas: restore and increase funding for civil legal services through the Legal Services Assistance Fund, and restore 10% for civil legal services programs in the judiciary budget, including $85 million to help bridge the gap and continuing the $15 million supplemental appropriation for the IOLA to fund its grantees. The JCLS program is by far the largest source of support for our members. On average, our members' budgets consist of over 50% in state funding, and JCLS comprises nearly half of that amount. It is especially important because it gives our providers the flexibility to allocate funds where there is the most substantive needs in their own communities. JCLS program has been reduced by 10%, and we caution that the resulting cuts will be borne by our most underserved and marginalized communities. We appreciate that local assistant reductions are being reduced to 5% under the governor's budget. Should sufficient federal funding be realized, we urge that these amounts and judiciary funding be restored in full. Thank you very much.
Thank you very much. Any questions? I don't see any hands up. We're going to move quickly, so if you don't pick your hand up. Nope. All right. Thank you very much, ladies. Appreciate your being with us tonight. Thank you. Next panel. New York State Health Foundation, Veterans Advocacy Project, Center for Court Innovation, Fund for Modern Courts, and the New York State Coalition Against Domestic Violence. Sometimes I was stretching a little when combining into panels, but I did my best to be thematic. David Sandman from New York State Health Foundation. Nope, you're on mute. See if you can get your mute off. There we go.
Great. Thank you, Madam Chair, for the Zoom advice. Thank you for the opportunity to testify before this hearing. I'm Dr. David Sandman, the President and CEO of the New York State Health Foundation, and I am here today to speak on behalf of creating universal access to Veterans Treatment Courts, or VTCs, for every veteran in New York who needs one. And a simple transfer policy that is proposed in the executive budget would make universal access a reality. VTCs provide an alternative to incarceration for veterans who encounter the criminal justice system and who have a mental health and/or substance use issue. They provide treatment and services instead of jail. And I've provided details in my written testimony about the history and benefits of VTCs and why a transfer policy is needed. I use my brief time today to tell you about a veteran whose name is Nick. He comes from Western New York. Nick is a Marine sergeant who joined the military after the 9/11 attacks. He did 2 difficult combat tours in Afghanistan, and when he came home, he felt isolated, had a hard time readjusting. He was drinking heavily, became addicted to drugs. He ended up homeless, living in his car in a Walmart parking lot. And when he was found, he was arrested for narcotics possession. Nick was not a danger to anyone besides himself. He didn't need jail, he needed treatment. And Nick's mom had heard about the Monroe County Veterans Treatment Court. As Nick puts it, the judge was the first authority figure he'd ever encountered since leaving the military who showed him respect. She thanked him for his service. She helped him to get out of jail, got him into treatment, and Nick says that it saved his life. He graduated from the VTC, and today Nick is thriving, has a family, completed his education, and himself works in government service now. The evidence is clear. VTCs work. Research shows that they are associated with lower rates of recidivism. They have positive impacts on alcohol and drug use, mental health, housing stability, employment, and interpersonal relationships. There's lots of vets like Nick out there. Not all their stories are successful because depending on where you live, you might not have access to a VTC. Only about half of the state's counties have one, and the transfer policy proposed in the budget will fix this. It will allow a case to be moved from a county without a VTC to a neighboring county with one. It's simple, effective. It means that vets won't languish in a justice system that's not equipped to deal with their challenges. It's a point of pride. The first VTC in the nation was started about a decade ago in Buffalo, New York. As their birthplace, it's only right that we should have the largest and best system in the nation. and a transfer policy will allow New York to become the national beacon and remain the beacon for veterans treatment courts. Thank you.
Thank you very much, Doctor. Next, Veterans Advocacy Project, Coco Culhane.
Hi, thank you. I'm the Executive Director of Veteran Advocacy Project, and David's a tough act to follow. I want to echo everything he has said, and I was thrilled today to hear how much support there is for veteran treatment courts. And you know, if there was a theme to my testimony here, it would be to leave no one behind. You know, one person is not more worthy of redemption or recovery because of the county they live in. So a transfer policy is an easy way to increase access to justice. My organization specializes in working with veterans with less than honorable discharges, and I just wanted to also say that the support services for these courts, the peer mentors, all of the different components that come together are so important because there's a very high ratio of veterans with less than honorable discharges in Veterans Treatment Court, and they can't access the VA. So we're talking about a population that is extremely vulnerable. Often they have been discharged less than honorably due to symptoms of post-traumatic stress or traumatic brain injury, such as self-medication, getting into fights, things like that. And when they get out, they're seen as having a criminal record, and they, having a less than honorable discharge is the second highest predictor of homelessness. If you've been discharged for misconduct, you are almost 3 times likely to die by suicide than other veterans, which are already at way too high of a rate. So we're talking about a really vulnerable population that's essentially been failed by the military justice system and is now entering the civilian one. And veteran treatment courts are so important and so vital. My organization works with several. We're so lucky in New York City to have, I think, 6 or 7 courts now. The thing is, it's easy to forget. We have so many resources in the city. It's easy to forget that veterans around the state really don't have those options. And in particular, even in New York City, these veterans can't work with the VJOs, the Veterans Justice Outreach social workers, who are such a vital piece of connecting these veterans to treatment. So again, just that's why these support services, all of the different players that come together to make veteran courts, veteran treatment courts what they are so important. And I hope that the legislature will support those programs that are working with all of the veterans, because everybody does deserve that second chance. Thanks.
Thank you very much. Next, the Center for Court Innovation.
Good evening. My name is Shane Karaya, and I work at the Center for Court Innovation. Based on the amount of time, I'll dive right into the areas that our upstate and downstate programs and research seem well suited to contribute to public discourse on. In the first topic, reducing unnecessary incarceration, last week we released a fact sheet on the impact of bail reform in New York State, exploring popular opinions, what the data says, and what we know from operating pretrial diversion programs. We hope that this will be useful in exploring the issue through facts. For example, in response to attempts to tie gun violence to bail reform, we provide an analysis that shows that of the 528 shootings through June 20th in New York, only 1 was released due to bail reform. The second topic is shrinking the footprint of police. During the summer calls for police reform, we released a document spanning 6 areas of practice we operate programs in that can help shrink the footprint of police. As an example, we suggest supporting families when they appear in other parts of the justice system. In our Strong Starts program that supports children under 3 in child neglect cases with a clinical coordinator, we have data that shows 50% of those parents were previously the subject child of a prior neglect proceeding with their own caregiver. The goal of me sharing this example of shrinking the footprint of police is because it seems slightly off-center from police responses, and yet a criminal arrest can trigger a child neglect proceeding and have intergenerational impacts if not sufficiently addressed. Meaningfully helping them at this point of their needs can have a profound long-term impact. The third topic is housing as a justice issue. Many New Yorkers are anticipating a crush of housing court cases when current protections end. It's important to understand the spectrum of effective models for protecting tenants. Models such as housing resource centers can help residents stay in their homes for issues like avoiding default judgments for non-appearance or lapsed annual certification for public housing. These are both issues that require legal information, not necessarily legal representation, to keep New Yorkers housed. Finally, on the topic of anti-gun violence, we want to add research to the calls for increased access to gun violence prevention programs. Over the summer, we released a report entitled Gotta Make Your Own Heaven, where we utilized participatory research with credible individuals within the communities we serve to examine why youth are carrying guns. One finding is that a lack of safety from other youth and police are motivating gun possession. We hope that the state can continue to support programs like ours that are asked to create a sense of safety in environments that are more expansive than the funded catchment areas that we operate in. Thank you for giving me the opportunity to sprint through this overview of what we believe our research and programming can help to continue the sense of public safety and trust in New York.
Thank you very much. Our next is Fund for Modern Courts.
Good evening and thank you. My name is Bill Silverman. I'm the chair of the Fund for Modern Courts. I'm also a partner at Proskauer, where I have the privilege of running their pro bono program. Modern Courts is an independent, nonpartisan statewide court reform organization. And I'd like to emphasize two main points tonight. First, the 10% spending cuts that have been imposed on the court system have in fact affected access to justice. We are seeing significant cuts in staffing based on the hiring freeze. We're seeing cuts to legal services organizations that at a time when the need is getting much worse, much greater. And we're seeing obviously the separation of the 46 senior judges. Those cuts could not have come at a worse time, at a time when COVID-19 is affecting the most vulnerable among us. Those cuts are occurring at a time when the court system is already under-resourced. As we all know, in 2011, the court endured a multi-million dollar, $170 million cuts. Given the growing backlog of cases, the central role that the courts play in access to justice, we believe that the budget should be approved. And we'd also like to see the 10% cuts restored at some point. I want to briefly address the issue of backlogs because I think it raises a question of fairness and equity during COVID. We're not seeing massive backlogs in the Supreme Court where people are generally represented and where proceedings are virtual. We're seeing backlogs in the family court. We're seeing backlogs in the housing court. These are courts that serve poor people. The backlogs are affecting people of limited means. They're affecting people of color, and they're affecting them disproportionately during a time of crisis, and that's unacceptable. So this leads me to the second point that I want to make today, which is that we need to restructure the court system. Having 11 separate and distinct trial courts in the best of times is completely inefficient. Having them now during a time of crisis makes it very difficult for the court system to consolidate resources. It makes it difficult for them to reassign judges. It makes it difficult for them to get resources to the courts that are serving people of limited means. Pre-COVID, I think we were making progress, and I urge the legislature to take up court simplification at the earliest possible time. I want to thank you for this opportunity. I also want to thank the elected officials, the people who also are testifying, and all the staff for your public service. Thank you.
Thank you very much. And then the New York State Coalition Against Domestic Violence, John Gerhardt.
Thank you for the opportunity to speak today. I'm Joan Gerhardt, the Director of Public Policy. That's okay.
I called you John by mistake. I apologize.
That's okay. I'm Joan Gerhardt, the Director of Public Policy and Advocacy at the New York State Coalition Against Domestic Violence. NYSCDV was established nearly 45 years ago, and we represent about 100 programs serving thousands of domestic violence survivors and their children across the state. Rather than review our specific budget priorities, which are described in detail in our written testimony, I'd like to use my time today to give you a sense for domestic violence in New York State and the challenges presented to domestic violence survivors and service providers, both before the pandemic and now. New York consistently has the highest demand for domestic violence services in the country, despite some states being more populated. And as has been widely reported, this demand has significantly increased during the pandemic. Thousands of adults and children are in need of domestic violence services in New York each day. More troubling, thousands of requests can't be met because of declining or stagnant funding. Since last March, in order to meet the rising demand and do it safely, domestic violence programs have spent thousands of dollars on unbudgeted items like PPE, cleaning supplies, non-communal food service, and new technologies. New York's domestic violence advocates have acted heroically, staffing shelters at their own personal risk, learning to provide services to survivors in new ways that still enhance safety, even providing crisis and trauma counseling to survivors from their own homes. And yet, at the same time, domestic violence programs are getting less funding. That's because New York's antiquated per diem reimbursement system only reimburses programs when survivors are in shelter. During the pandemic, many survivors haven't chosen to enter shelter. Plus, many shelter beds can't be used due to social distancing and quarantine requirements. Add on to that the 20% reduction in county contracts with local providers, and you have a perfect storm. It's not an exaggeration to say New York's domestic violence programs are barely getting by. They're using financial reserves, opening lines of credit, reducing staff, just to keep the doors open and the lights on. Domestic violence programs reported to us in November that their shelter occupancy decreased as much as 30, 40, even 55%. That means that the revenues New York provides to programs decreased in kind. We estimate these losses to the statewide system to total approximately $1 million a month. That's $10 million since the pandemic began. Obviously, this isn't sustainable for long. We urge the legislature to make emergency funding available to those domestic violence programs that can demonstrate documented losses. The state must ensure domestic violence services remain available and accessible to all who need them. Thank you.
Thank you. I really shouldn't eat my food at the same time, sorry. Are there questions for anyone on the panel? So I have one for the domestic violence. So the state's rules and your contracts are the bed has to be filled in order for you to be reimbursed. So what would you suggest we change so that the state was paying you, but paying you for empty beds? That's a challenge for us.
Well, it shouldn't be. You know, programs have operating costs just like any other not-for-profit. And we're bifurcating the services right now that these programs are providing. Residential services get reimbursed through this per diem, and all the other non-residential services that programs provide are, with contracts with the county DSSs. We'd like to see these services merged. New York State is the only state that does it this way, and that we provide funding to programs for the services in totality that they provide. So removing it from a per diem entirely.
Thank you. I see Senator John Liu with his hand up. I did see Senator John. Yes, there you are.
Thank you, Madam Chair. I know they don't want me to show my face. Oh, there we go. All right. Thank you very much. I want to thank this panel for the testimony. I just have a quick question for Mr. Silverman. You spoke of supporting the reorganization of our state's judiciary. And are you in support of the proposals that the Chief Justice has already made? Is that the specific proposal and reorganization that you support?
Yes, Senator. That's exactly the proposal that we support.
Okay, that's very helpful. Thank you very much. Thank you, Madam Chair.
Thank you. And the chair of our Judiciary Committee, or in the Assembly, Chuck Levine.
Thank you, Madam Chair. This will be the best political speech of all time. Sincere thanks to each of you for what you do. Thank you very much.
Thank you. Indeed, thank you all very much for what you do. All right, our next panel, we have the PBA of New York State, Manuel Villar, the New York State Police Investigators Association, Timothy Diamond, the Police Conference of New York, Richard Wells, the New York State Association of PBAs, Michael O'Meara, and the New York State Troopers PBA, Thomas Mungier. And I will ask Manuel Villar to start us off. Do we have you?
There we go. I think we're unmuted. Hello,
Okay.
Chairwoman
Hello, Chairwoman
Hello.
Kruger and Weinstein and other members of the Public Protection Committee. Thank you for your continued support and interest in the men and women of the Police Benevolent Association of New York State. My name is Manuel Villar. I'm the founding president and current vice president. I'm also a 37-year veteran of the New York Sergeant of the New York State Park Police. I'm here today to advocate for the merger of the Park Police into the New York State Police. Senate Bill 4647, there'll be a same as in the Assembly index soon. The Park Police is a division of OPRHP and is currently under command and control of the Division of State Police. New York State parks, by their very nature, are geographically challenging, beautiful, and yet dangerous places. To perform these duties, state park police officers receive the same training as state troopers, plus specialized training to be prepared to assist patrons when crimes, accidents, and other life-threatening incidents occur. State park police, with their specialized training in snowmobile, high-angle rope, swift water rescue, to name a few, are a critical part of New York State's response to natural disasters, weather emergencies, and other catastrophic events, including the current civil unrest in multiple cities throughout New York State. During the current COVID-19 crisis, State Park Police have been at the forefront of protecting testing and vaccine sites, some located at various state parks, as well as non-state park locations. Several state park police officers, including myself, have all contracted COVID-19. The lack of state park police levels is quickly reaching crisis proportion. In the past 15 months, we've seen a 15% reduction in staff. In fact, since 2000, state park police have graduated over 500 officers, only to have 53%, 255 officers leave for other police departments with better pay, 20-year pension, and disability protections. The cost to New York State to train all those police officers over 16 Park Police Academy has been roughly $80 million. The second issue adversely impacting our members, and not only the Park Police, but all 4 police forces in the PBA, is the slow walking by the governor's office of the 2015-2018 Binding Arbitration Award. This has left PBA members stuck at salary levels from 2014. Our members have not had a raise since 2014, despite having a binding arbitration award in place. Because of state parks' inability to operate and maintain a viable functioning state park police force, for the safety of the public and our members, we are requesting that the state legislature pass the Trooper Park Police merger bill that we have submitted and include the governor's program bill enacting the terms of the 2015-2018 binding arbitration award. We believe this would go a long way to making state parks much safer, as well as spending tax dollars wisely. Again, I'd like to thank you for this opportunity to speak to you, and I'm happy to answer any questions anyone may have.
Thank you very much. Just a smidge past the 3 minutes. Timothy Diamond, New York Police Investigators Association.
Yes, ma'am. Good afternoon, Senate and Assembly members. My name is Tim Diamond, and I am a senior investigator with the New York State Police, and I am the elected president of NYSPIA, the New York State Police Investigators Association. I represent approximately 1,100 investigators and senior investigators across the state of New York. And we cover all the heavies. We handle the felonies, the murders, the rapes, the robberies, the human trafficking, the gang violence. That's the stuff that my membership does. NYSPIA's members are hand-selected from the most highly trained uniform troopers and represent some of the best that our agency has to offer. The state police and my membership, along with every police agency in the country, is dealing with historic policy change, a job expectation that seemingly changes by the day. Our members have displayed a strength, a resilience, and a compassion that I'm incredibly proud of through what has been one of the most difficult times law enforcement officers have dealt with nationwide. We as an agency have proven to be highly adaptable to the rush of current law enforcement reforms, and we continue to take a leadership role in the law enforcement community, maintaining the highest quality services to the citizens of New York. Our highest priority this year is the same as most years. It's the replacement of retired members. Our members are leaving at a breakneck pace. We have approximately lost 20% of our senior investigators statewide. Those investigators supervise all of these investigative units around the state, and losing them has caused our investigator ranks to now be depleted. We are now at what I would say a critical point where we need a class of troopers. We can't have investigators if we don't hire troopers. Second, the automobile fleet. I'm happy to report that our fleet has improved. And a lot of that is a testament to the work the legislature's done on the fleet. It is more diverse. It is younger. The diversity of our vehicles in the field helps us, our undercover units, to remain concealed, which, as someone that was a senior investigator in the violent gang unit, is very important to me. I have an issue on here for a UC gun program. We're looking for support from the legislature to provide our undercover members, and there's about 300 of them scattered throughout New York State in all cities, towns, and villages. We would like to get them a weapon that is easily concealed so they can remain safe in the field. If they are made to be police, it puts them at risk, and we want to keep them safe. The proposed legislation of adult use cannabis and online gambling will generate revenue. It will also generate some black market crime that we are going to have to act on. That's a sprint through. Thank you for listening to these important issues. Law enforcement reform is a leading discussion topic right now in the country. As the reforms are implemented, there's no question New York State Police will be looked upon to lead the charge professionally and respectfully. If the police, legislature, and members of these communities can bridge the gap and be the glue, we can cause positive change while keeping our community safe. Thank you.
Thank you. That's certainly what we all want.
Yes.
Richard Wells, Police Conference of New York.
Good evening, everyone. Richard Wells, President of the Police Conference of New York, which is a coalition of over 200 local PBAs throughout the state of New York. My comments this evening will be kind of an expansion on Commissioner Green's testimony earlier as regards training of police officers. We're asking that the legislature consider establishing a statewide training curriculum for police officers, especially as regards to in-service training. Currently, the certain standards that are in existence by the Bureau of Municipal Police and the Municipal Police Training Council have minimum standards that must be met, but that's as far as it goes. In-service training is conducted sporadically throughout this state and very infrequently. Some jurisdictions don't do it at all. There are police officers that after they leave the academy go through their entire career never receiving any further training. This is not good, especially in light of the current circumstances we find the police profession. Academy lengths differ throughout the state. In-service training is not done frequently enough. Changes enacted by the legislature on the use of force, retraining is necessary. Police officers encounter violent people every day. It is obvious that physical force, use of pepper spray, other chemical weapons, or tasers are now considered suspect and frowned upon. Police officers are confused and bewildered on how to do their jobs. Cops are expected to keep the peace, enforce the law, make arrests without using any substantial force, deal with violent, emotionally disturbed persons, control riots. This necessitates innovative and increased training. Increasing the length of the academy should be considered. In-service training must be frequent and substantial so police officers are current on all law changes. In the past, cost has always been cited as a reason not to do in-service training. The legislature should give consideration to sufficient resources, applying sufficient resources to local police departments so that they can send all of their officers for training on a regular basis. Consideration should also be given to imposing sanction on municipalities that fail to provide such training. The cop on the street is held responsible for every action that he or she takes while they're working. They, however, do not and cannot schedule their own training. Police unions have no say in police training. Police chiefs have budget and personnel constraints. Adequate and meaningful training will be difficult to implement. It will be expensive and time-consuming. But if the goal is to have police officers adapt to the changing standards in the use of force and laws of arrest, then it is incumbent upon the legislature to provide the funding and means to accomplish it. It cannot be an unfunded mandate. If it is, it will never happen. The bill submitted yesterday by Senator Savino might be a good place to start this process. Thank you.
Thank you very much. Michael O'Meara, New York State Association of PBAs.
Good evening.
Evening.
Thank you for letting me address you. I wanted to start to talk about training as well. I'm Michael O'Meara. I am the president of the New York State Association of PBAs. It's an umbrella group that represents about 45,000 police officers in New York State. It's the largest umbrella group of police officers in the state. Senator Savino did submit Senate Bill 4706. I believe it was yesterday. And I believe that's a great place to start because we have not had many conversations with legislators about police reform. 4706 proves that police reform does not have to equate to police punishment. Police reform can be a hand-in-hand process that we can help accomplish in this state, and we embrace that. To expand a little bit on what Richie said and what the commissioner of DCJS said earlier, think about this. We've expanded our program to give new police officers 700 hours of training. That's the basic minimum course. Sounds like a lot, right? But if a young man at 21 enters the police academy, or a young woman on January 1st, by the end of April, they're a police officer walking around with a gun, with a mace, and with a taser. And after they leave that police academy, they don't go back for any training whatsoever. There's no training. We don't go for training. You can go, I'm in my 31st year. I've never put my hands on anybody in a training aspect, except when I'm in the police academy. When you explain that to people, they're horrified. They would think that in a profession where we are engaging the public at such a high level, that we would have to be trained. Senator Bailey has a great bill in. And after our history over the last year or two, you'd think that's funny that I'm saying that. It's a great bill. Mandates that police departments have to train police officers in firing their weapon at least once a year. Can you imagine that we have to legislate that? Because there is no policy, there's no procedure. So once we leave the police academy, we're out there. We're out there with the public. We don't go back. We don't get retrained. We don't hire people, police and police unions. We don't hire people. We don't train people. We don't deploy people. We don't equip people. We don't investigate people. We just represent police officers because we have a duty of fair representation. And somehow that makes us evil in some aspects. But all I'm telling, and thank you for letting me speak, is that we need to have some budgetary money for in-service training for police officers. That's mandated that police officers should be trained at a high level, not just 4 months when they're in their 20s and then just go out and do the job. So I appreciate Senator Savino's bill, and I appreciate you letting me speak. Thank you, and have a good night. I hope it ends quickly for you.
Thank you. And the last panelist, Thomas Mungier, New York State Troopers PBA.
Thank you, Madam Chair, members of the committee. I appreciate this opportunity. This is actually my 12th time addressing this committee, as my time as president of the Troopers PBA. I represent 6,000 active and retired troopers, the uniformed troopers that you see on the side of the road. This is almost like the movie Groundhog Day. When I first started doing this job back in 2009, in 2010, I addressed this committee that we hadn't had an academy class. And we went 3.5 years without an academy class, and our levels of manpower got dangerously low. And we had to start cutting services for the public. Well, our last trooper we hired was in 2019. Last year, we did not have a class. And this year, there's no money budgeted for a class. So I'm offering a cautionary tale that I'd hate to see us go down that road, what we were a little over a decade ago, with our manpower levels dwindling to dangerous levels. And again, this is not the time to cut police services in our statewide capacity. I know that my superintendent had testified earlier today the different duties that we have, and more duties are going to be heaped upon us with the legalization of marijuana and so forth. Right now, I could use 300 troopers. I need a class of at least 250 to get them up and going. And it takes 18 months to train a trooper and get them onto the road so they can ride by themselves. So we have to actually do this somewhat quickly. And again, I hate to be in this situation this time next year testifying before you when my manpower levels dwindle even further. I'll echo my counterparts with the training in the New York State Police. We do have in-service. We have a vigorous in-service training program. And I believe it is to use that as a model to bring all of the police officers in the state up to that level with yearly training, and to also enact the different policies, the different law changes, the different training techniques that are out there. All police officers should have a yearly refresher in order to do this. And again, the New York State Police has a vigorous in-service training program. It works. I believe that the state police operates at an extremely high level, for training purposes. And again, I saw Senator Savino's bill. Very interesting, and I think she's on the right track. And let's get through this next year all together as working as a team. Thank you.
you. And Senator Savino's had her hand up, and we all keep talking about her, so I think I'm calling her first. You there, Diane?
Yes. Thank you, Senator Krueger. Am I unmuted? Yes, I think so. Okay, so first I want to thank the panel for testifying and sharing their experiences. I also want to thank them for actually, I guess, writing the memo in support of my legislation. But in all honesty, I do appreciate them because they helped me understand better just how difficult the police reform process will be in New York State when the governor last year tasked each and every locality and each department with coming up with ways to make our police better and to reform their practices. One of the things that became glaringly evident is that we did not have a standard across the state. As Tommy Mungir spoke, the state police have the highest standards and they train regularly, but it became very clear very quickly that that was a rare instance across the state, including the largest police department in the state, which is the NYPD. So my legislation that we introduced yesterday answers that. And we also heard earlier tonight the commissioner of DCJS talk about how they proposed a new training curriculum of 700 extra hours, but it's not mandated, it's not required. And as we heard from Richie Wells, if we don't mandate it and require it, and we don't provide funding, it will not happen. We all have an interest in better police and better police practices. Every one of us wants that. And I think if we follow the bill that I introduced and we can even improve upon it, working together, we'll wind up with exactly what we want. Everyone wants better police. So I want to thank everyone for helping me draft the bill. And I want to thank you guys for the work that you're doing, keeping us safe, and keep yourselves safe. Thank you.
Thank you. And we have been rejoined by Helene Weinstein, who
Thank you.
didn't
So we
take
have
all her
a
vacation. She had another big assignment for the assembly.
so we have a number of assembly members with questions or comments. So go first to Assemblyman Levine, then Lawler, then Rod, then Palmisano, in that order.
Thank you, Chair Weinstein. I want to thank each of you. And please thank your membership for protecting us all. I have a quick question, a follow-up question for President Diamond. So we want to get more compact firearms for undercover officers. Do you have a sense of how many of these firearms are going to be needed? What kind, and how much would that cost?
Yes, sir. And I appreciate the question and the interest in that topic. So we're looking for a subcompact weapon for approximately 300 members. We're looking at estimated costs of around $150,000, which it's a big number, but if it keeps our undercover members safe and concealed, I think it's a very worthy way to spend those funds.
Do you have a particular make or model in mind?
We are taking a look at a bunch of different makes and models. The biggest concern for me is that it's something that is subcompact, easily concealed in the waistband or pocket. And the most important thing is it doesn't look like the same weapon that our uniformed state troopers wear and our suit and tie investigators wear.
Thank you very much. Thank you all.
Thank you.
The Senate, I believe you have Senator Liu.
Senator John Liu, thank you.
Hello.
translations on the bottom of the screen.
Okay.
I don't know
Everyone
if you
else
can
put
hear
their
me,
mute
Madam
on.
Chair, but
We're going to pass through our best.
Madam Chair?
Yes.
Okay, thank you very much. I appreciate this panel's input. I do appreciate the comments about the police reform that has taken place, not only in New York, but across the country, and attempts at more police reform. I think the comments have been constructive. I think Senator Savino already spoke with many of us rather eloquently, and understand that you all pretty much universally support her bill, so that's helpful. And also appreciate the support mentioned for Senator Bailey. I do want to say something though. One of the comments was that we need to train our police, which is definitely true. Train them and not always look to punish. I would only add that that I don't think there's a universal intent to punish officers, but asking for accountability is not synonymous with punishing. So, I would ask that you are tremendous leaders in law enforcement here in New York State, and you have a voice far beyond as well. So accountability is not the same as punishment. And with that, I really do want to thank these gentlemen and their members for the work that they do. The work is vital. At the same time, in government, we need to fine-tune what responsibilities of government should be carried out by which agencies. Thank you, Madam Chair. If any of the gentlemen would like to respond, I'm all ears. But that's all I have to say, Madam Chair.
Thank you, Senator Liu. If any of them would like to respond, they have. Oh, nope, they lost their 1 minute on the clock. They could have had 1 minute.
My office is always open to you.
Okay, thank you.
Thank you. We go to Assemblyman Lawler, please.
Thank you, Madam Chairwoman, and thank you to everybody. I'm actually proud to represent one of our esteemed panelists here in the State Assembly. I think one of the things that's critically important as we move forward with any potential reforms is obviously that law enforcement is included in the discussion. I think what is evidently clear over the last few years is that law enforcement really hasn't been part of the discussion on some of these criminal justice reforms that came down the pike. One thing I just want to point out to all of you, which you may or may not be aware of, is that last year, obviously, the legislature repealed 50A of the Civil Rights Law, which impacted, obviously, the personnel files for many of your members. One thing you should be aware of is that under the rules of the New York State Assembly, Rule 8, this body exempts itself from being subject to FOIL. So just so you're aware of kind of the hypocrisy of some of the bills that get passed. So when we talk about accountability and not punishment, that actually does seem like punishment and not really accountability when we're not holding ourselves to the same standards that we hold your members to. With respect to marijuana legalization, I have a quick question for you. There's only one state of the states that have, in fact, legalized marijuana. There's only one state that has capped the potency of marijuana. Do any of you have an opinion on whether or not you think if we do end up legalizing recreational use of marijuana, that we should cap the potency of it?
Well, I'll just say that you should, whatever laws that this esteemed body passes, we're tasked to enforce. So if you do decide to cap it, we'll act accordingly in our enforcement acts out on the road.
Okay. With respect to in-service training, I agree. It's critically important. I know where I live down in Rockland County, we have great in-service training for all of our officers who work in our various police departments within our municipalities. So I absolutely agree with your comments that, in-service training is critical and providing the funding for that, especially as we make some of these criminal justice reforms to make sure that all of your members have the necessary and adequate training that they need to do their jobs, responsibly, and so that they can enforce the law and uphold standards. The academy class, I think that's a critically important point. I know last year the Rockland County police exam was canceled. So I agree. I certainly agree with your assessment for the state police and all of our police departments that we need to, in fact, get these police exams and classes on the books and get the funding for it, because I think one thing we've seen is a lot of people have retired as a result of some of these reforms. So we definitely desperately need to fill some of these positions. So I appreciate your comments on that.
Thank you. The last assembly, I see two assembly members more.
Yes, so we go to Assemblyman Ron, then Assemblyman Palmisano.
Thank you, chairs, panelists. Thank you all. Thank you to all of your members for their service during, the last year has obviously been between COVID and a lot of the unrest and things we saw last year. And they kept being out there each and every day to keep the public safe. So thank you to each and every one of your members. I was just wondering if, in particular, maybe for Mr. O'Meara regarding this proposal in the budget that deals with the governor's executive order that requires, changes at the local level with the potential of funding being withheld and the potential of a monitor being put in to oversee a local department. How have, from the departments that are members of your organization, I'm sure there are some that probably have already put in plans and others that are going through that process. I'm just wondering if you have any perspective on how that is going.
Yeah, we've had a lot of perspective on it from our member associations. A lot of the police unions actually were not even represented on a lot of those panels. So, but my take on that is that it's going to be these numerous reports from all over every corner of New York State that are all going to be different. But last year we passed a bill that the Attorney General of New York State is the single person that looks into police misconduct. So you have 40 to 50, I believe, police academies in New York State. Everybody learns something different. We keep on changing laws. And like we said, we're not trained up to the laws. We're just told about the laws. And now we're going to have these commissions from all over the state coming up with ideas and plans on how the profession of policing is going to change. And, that's okay. I mean, we have to, learn to adapt and move on, but we don't get training. They did the compression bill in New York City, and the plan is to show a video on how police officers who learned to take people down and, go on their back or sit on them, they learn this in the academy. We're going to show them a videotape now to teach them to not do it. So, if that's the case, I watched a lot of karate movies when I was a kid. I should be a black belt, but I'm not. You have to go through training. You have to go through training. You can't just, can't be handed a piece of paper or shown a video. This is, as you all know, this is serious business. And we all know that too. We represent police. So we have to treat it seriously. We have to allocate the funds, and we have to train our police officers to match what these commissions are going to come up with.
Well, thank you.
Assemblyman Palmisano.
Yes.
Phil, you're muted.
Muted.
Oh,
There you go.
sorry about that. Good evening, gentlemen. I don't have any questions for you tonight, just a few comments if I may. First, I just wanted to take this opportunity to say thank you to you and your members for your selfless dedication, commitment, service, and sacrifice to protect us and keep us safe. Each and every day, you and your members leave your house and say goodbye to your spouse and our kids, and not knowing whether you're going to return home safely. Although, unfortunately, some of the policies coming out of Albany the past couple years certainly doesn't reflect this appreciation. I just want you to know, on behalf of myself, my family, my community, and certainly a number of my colleagues in the legislature, how very truly grateful we all are to you for all that you do, have done, and will continue to do for all of us. So on that note, I just want to say thank you. God bless you, and please be safe. Thank you for being here.
Thank you. We go to Assemblyman Chris Burdick.
Thank you, Madam Chair, and I want to thank you all for your testimony. And I also want to echo the thanks that have been expressed for your service to the state and to keeping us safe. There has been a good deal of concern and discussion regarding the potential legalization of recreational marijuana. And this afternoon, there was a very enlightening discussion with Acting Superintendent Kevin Bruin of the New York State Division of State Police. And there was a fair deal of discussion regarding how will we be coping with driving under the influence of marijuana. And I think that for some, that's regarded as something new, something untried. But one of the things that became clear, that the comment that was, this is nothing new. We're already enforcing. It doesn't have to be legalized in order for us to enforce this. They're already looking for those who are driving under the influence, testing for TCH and so forth. And I'm wondering if you could comment on that. I don't know which panelist would feel best in addressing it, but I'd like to get your take on it and your feeling about the preparedness to go forward should recreational marijuana be legalized.
Yeah, I'll take that, Tom Mungier from the Troopers. I am a drug recognition expert, and but that beside, we do that. Police officers every day, they go out there. The charge is DWAI drugs, and it's based on a police officer's observations on how somebody drives. Whether somebody's under the influence of alcohol or some other substance. It's your initial stop is based on the observation and how somebody operates that vehicle. And then our investigation then continues through there. So just because marijuana is going to be legalized, it doesn't change the way we investigate and do business. We're out there anyway. Will more people be under the influence? I guess that remains to be seen. I do believe we need more funding for drug recognition experts throughout the state. And I think it also comes back, and this segues back to the training that
I just have
police officers should.
a couple seconds left. So you feel fairly confident that you'll be prepared for this should this occur?
Absolutely.
Thank you so much. I appreciate it.
Thank you. Thank you to the panel for all of the work your members do. I've worked with many of you over the years. And I go back to the Senate. I believe we have no more members who want to speak.
I was on mute. Apologize. I just want to let everyone know that we are very open to working with all of you on additional changes we can and should be making in New York. And I really appreciated your honesty about the fact that this has been tough times for you. And this has been tough times for a lot of communities as we evaluate the need to learn to talk to each other and to get things right. And it sounds like you all think we need improved training. I come from New York City, just for the record. They're not doing anything once you graduate the first time. Our NYPD Training Academy, I describe it as a combination of a trip to Star Wars and Harvard at the same time. So they're not letting anybody go back and continue their training once they've graduated. That's extremely disturbing. Because I think we could probably provide the facilities for the entire state at that campus. So again, thank you very much for your work and for your being with us tonight. And our next panel, for those who are keeping track, panel D, the District Attorneys Association of the State of New York, Anthony Jordan from Washington County representing, the Defenders Association, Susan Bryant, the Chief Defenders Association, Laurette Mulry, a group called Students Demand Action, Audrey Semple, student leader, and the New York State Dispute Resolution Association, Regina Ritzy. And I'll start with the District Attorneys Association if you're here.
I am. Chairwoman Weinstein and Kruger, thank you for letting us speak with you this evening on behalf of the DA's Association. On behalf of our president, Sandra Dorley, she sends her regrets, but she was not able to get out of a prior commitment. When we've been looking at this year's executive budget, but certainly in following the discussions in the legislature, there's some areas in the criminal justice system that certainly continue to remain in very sharp focus. A few of the areas that I think matter certainly to our organization, but I suspect many on this current panel include pre-arrest and judicial diversion. These provide great opportunities both for the accused, but my experience is they do a great amount of good toward reducing recidivism. Certainly, as we look at the legislation to add greater access to mental health in Veterans Court, that is a great and important initiative. I think what we find, though, as we look at these, the implementation of these initiatives, there's a significant resource gap in the state. And I think as we look at bringing about these programs, I would ask that you consider those issues so that accused can have access to these diversion programs, and then DA offices can certainly make them available. Certainly discovery and the changes that came about as part of the 2019-2020 budget brought about a change to the criminal justice system, unlike any, I suspect, in the last generation. Our offices spent months working together collaboratively I won't use the full 3 minutes.
Yeah, I'm not sure what happened with the clock. It was our fault, so just keep
That's
going.
right. No. But we spent a great deal of time trying to come up with how to comply with the spirit of the law. And certainly none of this would have been possible without that collaborative effort amongst the offices and the contribution of NIPT, which is the New York Prosecutor Training Institute. Their programs, their case management system, but most importantly, the digital evidence management system that they helped develop has made our ability to turn over voluminous amounts of discovery in a very rapid period of time possible. So we would ask that you certainly continue to look to fund their efforts, but also much of the burden of discovery fell squarely on the backs of the localities on very tight budgets. And there was not a commensurate amount of support for the localities. And we would just ask so that we can all continue to comply with not just the letter of the law, but truly the spirit of the law. What is it for and what is the goal to look to provide that type of funding? I know there's been a lot of talk about body-worn cameras with the state police and what a significant step forward and continued in transparency and accountability. But body-worn cameras are great, but they are very expensive. Not only the expenses that we heard Acting Commissioner Bruin mention for state police to purchase, but the cost to the localities to review, to store, and to deliver that, the body-worn cameras. And much of the state public defender's offices are also part of county government. And so there's going to be duplicative storage of all of that data. So we would just ask, not only do you look for funding toward the state police side, but also for our localities again in that area. And I'll wrap up sort of quickly here. A lot of talk about decriminalizing marijuana, a lot of focus on driving, but there are other public safety and public health issues that, as you explore this, we would just encourage the continued discussion with all of the experts, as I know you will, but also include our offices, because we are on the front line of trying to move these cases through the system. And lastly, DASNY, we're here, we're ready. We want to work with you to try to bring about these important initiatives, and certainly would look to help explore the resource gaps that we see that exist throughout the state. So thank you very much.
Thank you. Next is the New York Defenders Association.
Hi, good evening, Chairs Kruger and Weinstein and the rest of the members that have stayed on. I appreciate your time and the opportunity to testify. In fact, this is earlier testifying than ever before, so I greatly appreciate that. My name is Susan Bryant. I'm the Executive Director of the New York State Defenders Association, and I'm proud to talk to you today about the work of the Defenders Association and to ask for your ongoing support. So NISD is a nonprofit organization that provides a wide range of services to public defenders around the state who represent individuals in criminal and family court proceedings. So we are really the counterpart to NIPD, which my previous panelist spoke about. And we've been funded by New York State since the early 80s to do this work as the Public Defense Backup Center. And for 5 years, we've also run a Veterans Defense Program, which you heard about yesterday, many of you, from our Deputy Director, Roy Deal. So the key issue I wanted to bring up with you is your support and funding for the State Defenders Association's ongoing work, as well as on the current state fiscal year. So we are asking the legislature, both the Senate and the Assembly, to add an additional $1,059,000 to NISD's budget in the upcoming state fiscal year, because the executive in the proposed budget, as has happened in the past many years, has proposed half of the money that we need in order to maintain our base operations. So we are also asking for to make sure that we receive a reappropriation for the $1,059,000 legislative add from last year, which has not been put to contract and we have not been able to seek reimbursement for. I know we're in the same situation as many others and appreciate your support with regard to that. As you heard from Bill Leahy earlier today, the Director of Indigent Legal Services Office, NISD's work is critical to public defense and improving the quality of representation. In the past year, we've taken responsibility to educate and train defenders on the existing laws, as well as many new laws, which we are grateful to the legislature for passing, including bail, discovery, speedy trial reform, Domestic Violence Survivors Justice Act, the Driver's License Suspension Reform Act, Raise the Age, all of those things we provide training on. We also run a case management system that's similar to NIPD's, which is in 91 sites in 53 counties. And we're expanding that to help with the discovery process. And also for family court, we support the ILS request for $5 billion additional dollars, because families, particularly Black and Brown families, are disproportionately involved in our family regulatory system. And they really need quality representation, and the state really needs to step up in that regard. We also support the Indigent Parolee Program appropriation of $600,000 and a reappropriation of that funding. Thank you so much for your time, and I look forward to speaking with you further on these issues.
Thank you. Next is Laurette Mulry, Chief Defenders Association of New York.
Thank you and good evening. As you said, my name is Laurette Mulry. I'm the president of the Chief Defenders Association of New York, which is an association of public defenders and chiefs of legal aid societies and assigned counsel plans across New York State. Collectively, we oversee programs that provide the mandated service of indigent criminal and family defense in over 300,000 cases annually. I would like to thank Senator Kruger and Assemblymember Weinstein and this venerable legislature for the opportunity to present on the limited topic of the Public Protection Article 7 Bill Part J, which allows for the expansion of electronic court appearances. On behalf of the public defense community, I would like to state unequivocally our unified opposition to virtual appearances at critical stages of court proceedings, most notably at first court appearance or the arraignment stage. When New York paused back in March due to the COVID crisis, our court system never faltered and continued operations in a virtual format. And we understood this and we were grateful for it because it protected public health and safety and continues to do so to this day. However, once the exigency of this pandemic subsides, in-person arraignments must be restored to our hallowed court system to assure due process, to allow public access to the courts, and to prevent further racial and digital divide within our justice system. Virtual arraignments deprive the accused of effective assistance of counsel, which of course is predicated upon building trust with our clients, which are very difficult to do on a computer screen. Furthermore, due process would require that a person being hailed before a court to answer charges should actually have the right to be present in court, right? For a judge to look them in the eye, to be able to assess their credibility, demeanor, and humanity. Indeed, New York State has already made a commitment to, and I quote, ensuring that each criminal defendant is represented by counsel in person at his or her arraignment. This is language that comes directly from the Hurl-Harring settlement agreement to which New York State and 5 counties are parties. This commitment was further extended to the entire state by virtue of the executive law in 2017. Therefore, in New York, client and counsel are legally mandated to appear in person at the arraignment stage. Virtual arraignments produce harsher results for the accused. Studies have shown that bail outcomes of virtual arraignments were over 50% higher than when done in person. This may be attributable to the inherent dehumanization of defendants appearing in a virtual setting. Virtual arraignments further broaden the justice gap for those who are poor, who lack resources like computers or smartphones or Wi-Fi. This digital divide threatens access to justice and may disproportionately affect communities of color, further perpetuating a racial divide in our court system as well. Virtual arraignments are less efficient. The ability to speak to clients is limited. The processing of paperwork is hampered, and definitely technology issues abound. Each case takes much longer, and arraignment calendars often go well into the early morning hours in many places. Furthermore, public access to the court is denied. Family members and friends who ordinarily could vouch for our clients and assure a contact, supervision, or place to live in the community are not present. Virtual arraignments have come at a huge cost for our clients in terms of their constitutional rights. The true majesty of our court system, which preserves these rights and should do so equally for all, must return to in-person arraignments in post-pandemic New York, and we respectfully ask for your assistance in this matter going forward. Thank you for the opportunity to speak. Sorry I went over.
Thank you. Everybody's doing very well with this time frame. So, okay. Next, we have Audrey Sample, Students Demand Action.
Hello, thank you for having me today. My name is Audrey Sample, and I am the founder and group lead for Students Demand Action Rochester. I joined the movement to end gun violence as a teenager, shortly after my beloved medically fragile sister passed away at home, surrounded by family. In the aftermath of her death from the flu, well-meaning friends told me, there is no worse way to lose a child. These remarks always struck me as inaccurate because I know there are families who lose children without a peaceful goodbye. Grief connects you with everyone who has ever lost someone. I know the hollowness of waking up each morning, knowing the person you love most in this world is dead, and yet I cannot imagine how much more complicated my relationship with grief would be if my sister's death could have been prevented by greater access to community resources or sensible legislation. I urge you to include S1049, Community Violence Intervention and Prevention Act, in the budget. I have a responsibility to help prevent other young people from knowing this hollowness, and you as a legislature do too. Despite some of the strongest gun laws in the country, which have had a significant impact, New York still struggles with gun violence. In New York, on average, 370 people die by firearm homicide, and 1,522 people are wounded by gun assault or shooting by police. We need investment in community-led safety initiatives. If we want to end gun violence, we need access to resources that are not dependent on a survivor's level of comfort with police. Currently, victims who report to the police receive services at higher rates. From 2000 to 2009, 14% of victims who reported to the police received services, while only 4% of victims who did not report received services. Violence intervention programs successfully reduce violence by implementing alternative public safety measures that are locally driven, informed by data, and often don't require police involvement. The Federal Victims of Crime Act funding has been underutilized in supporting gun violence survivors. S1049 allows New York to address its gun violence epidemic via trauma and community-informed programs. We must act now to prevent gun violence. We owe this to survivors. We owe this to New Yorkers. Thank you, and please let me know if you have any questions.
Thank you very much. I'm glad for your family's loss. Regina Ritzy, New York State Dispute Resolution Association.
Thank you. Good evening, Madam Chair and honorable members of the committee. Thank you for the opportunity to be with you here this evening. My name is Regina Ritzy. I'm the Executive Director of the New York State Dispute Resolution Association. And I'm here this evening on behalf of NYSDRA, the New York State Dispute Resolution Association, and the statewide network of community dispute resolution centers, or CDRCs. CDRCs help people address and resolve conflict in their lives, improving lives and strengthening communities. The CDRCs are actually a network of 20 independent nonprofit organizations, which provide mediation and related dispute resolution services. The 20 independent CDRC centers serve every one of New York State's 62 counties. Funded in part by OCA, the Office of Court Administration, independent funding, contracts, and grants. CDRCs match OCA funding nearly dollar for dollar through grants, contracts, and other fee-based services. The New York State Dispute Resolution Association is the association, the membership association of the CDRCs and their mediators. We support the work that they do. The centers actually are staffed by a dedicated group of staff members. The work itself, the mediation work, is primarily, though, done by pro bono volunteers, community members who are professionally trained to provide mediation and other services. Nearly all of the work that they do is provided at no charge to the participants. Conflict in our lives is not new, but as New Yorkers struggle to adjust to the disruptions of COVID, conflict has been exacerbated, and housing conflicts, family conflicts, conflicts with neighbors in any part of our society have really just been exacerbated, and the need for conflict resolution has just grown. The CDRCs offer an effective alternative to the courts and are actually an important part of the Chief Judge's Excellence Initiative. The CDRCs work in concert with the courts to handle cases that are referred out and also receive self-referrals and referrals from other organizations. They handle housing, family matters, and many other situations where conflict is disruptive and impacts people's lives. The CDRCs have been hard hit by cuts in 2011, and the funding since that time was never fully restored. I'm here today to ask you to support the funding for the centers. I stand with the Civil Legal Services in asking to have the 10% recent cuts restored, and also to help prevent any further cuts. We're also asking for the preservation of the $10 million in the DCJS aid to localities budget. By funding effective dispute resolution services of the CDRCs, you can have a positive impact in the lives of New Yorkers. Thank you.
Thank you. Do I see any hands up? I do. I see Jeremy Cooney from the Senate's hand up. Hello, Jeremy.
Hello, Madam Chair. It's good to see you. It's getting darker outside, but we're all still here, and I'm glad we are. I want to direct my question to Ms. Sample from Students Demand Action. Audrey, it's great to see you here, and thank you for hanging around with us tonight. I'm so grateful for the work that you do in Greater Rochester, specifically around communities of color. I've seen you out doing that work over the past several years. You know as much as I do that Rochester still struggles with gun violence. We had a quadruple shooting last week in my district on Lyle Avenue. This continues to be an issue for us, and we're very concerned about it. But I want to direct my question really about the healing that you noted before, specifically for survivors of gun violence. Where are we missing the mark as a state? Where could we do better, whether it's a program that is happening in other parts of the country that Students Demand knows, but where could we be offering more resources to survivors of gun violence who are dealing with the trauma that we're seeing right in our hometown of Rochester? Thank you.
Thank you, Senator Cooney. Well, as I noted before, I feel really passionately that in New York as a whole, but in our city specifically, where so many Black and Brown people do not feel safe with the police, and white people as well, that we need resources that don't rely on them contacting law enforcement if that's something that they don't feel comfortable with. And so one of the most popular violence intervention program models is called Street Outreach, which provides both immediate crisis response services and long-term stabilization support to individuals and communities affected by gun violence. A 2017 evaluation of a street outreach model known as Cure Violence, implemented in the South Bronx, found that its street outreach efforts were associated with a 37% decline in gun violence injuries and a 63% decline in shooting victimizations, while a similar neighborhood without such a program did not experience the same rates in reduction. So I think that we really need innovative solutions, and we need creativity and people with compassionate hearts and again, creative minds to come to the table on this. And I'm happy that you have fought with us from the beginning and continue to fight with us. And I really hope that, that the legislature can include this in the budget.
I thank you. And with compassion and creativity, we can accomplish a lot. And I know that Students Demand Action will do just that. So thank you for all the work that you're doing. Thank you. I yield my time.
Thank you. Assembly.
We go to Assemblyman Ra.
Thank you, Chair. Good to see you, Mr. Jordan. Just had a quick question for you. So I had asked DCJS earlier today about the $40 million that was appropriated last year for the Discovery Compensation Fund. And he did tell me that I guess there was some amount of, I guess, 1.75 million that had been spent on this DEM system. But I was just wondering if you are aware of any funding going out the door, directly to local DA's departments.
So late yesterday afternoon, we actually received an email from DCJS. And what they've done is they've structured the award by, I think they use some formula of arraignments and maybe county size, but it's not exclusively for Discovery, and it's not exclusively for DA offices. So what they've done is it looks like they've bundled together pre-trial services, so to addressing release under supervision or release with conditions, to fund that. Also providing funding for the Sheriff's Department, local PDs, and then the DA offices. My understanding, although it's very early, but in terms of trying to understand how it's going to get rolled out, it looks like in counties with county executives, the notice may have gone to the county executive. So that is, it could create, where is the money going to go? How is it going to be used? So certainly some is better than none, as we often tell our kids, but I think if it's a one shot, it helps address some of the costs that our county has incurred, but certainly the amount that we were seeing that we expect if we're able to complete all of the grant application process would be about what probably is necessary each year going forward. So hopefully it's not a one-time deal, and it wasn't just for Discovery, and it goes far beyond just DA offices. So it'll be interesting to see how all that works out.
Thank you.
Good to see you as well.
Back to the Senate.
Actually, we thought we had a senator, but we lost them. So I'll give it right back to the Assembly.
Okay, then we have Assemblyman Lawler, I believe is the last member we have.
Thank you, Chairwoman. Tony, it's good to see you. I'm sure you.
Different Dean on this side.
That's right. I'm sure you missed these budget hearings. So I just wanted to ask quickly. I know in your comments you had mentioned really about the cost for some of these criminal justice reforms that came down on the district attorneys. Offices. So I just want to give you another moment to expand on some of the unfunded mandates as part of these criminal justice reforms and the need for funding in the state budget. So that's one. And then second, I just wanted to get your comment with respect to the legalization of recreational use of marijuana. New York, of all the states that have so far legalized marijuana, there's only one state that has capped the potency of marijuana, and that's the state of Vermont. So I was just curious if you had a comment with respect to whether or not, as New York State looks to pass the legalization of marijuana, whether or not you think there should be a cap on the potency of marijuana.
Sure. I think with funding, I think it's a noble effort, and it was an important change in terms of really rearranging completely how discovery happens in criminal cases. But to make sure it actually works and works well, I think that the state should look at funding for all affected agencies. So a lot of the funding has focused on the defense side, which is important, but I think they should also focus on our ability to turn that discovery around and get it reviewed. And it's only body-worn cameras is going to have a significant impact on those costs.
Especially on the IT side of it.
Well, and body time. I mean, you have to review the body camera footage because you have to make sure there's nothing on there that shouldn't be made public. You could have kids in compromising situations, social security numbers. It's not even relates to the case. So and you can't substitute reviewing body camera footage with a computer. And as I speak, if I were the Public Defender Association, they're saying the same thing, right? Because their people have to review this footage now. So it goes both ways. With marijuana, I would really encourage. We had a great presentation from folks from Colorado, and they talked about many of their experiences, and I think those can be very instructive. Potency certainly would be a concern as a person, but it's also the deliverables. How is it going to be deliverable? Is it edibles? Is it candies? Right. It's things that we've often struggled with in the cigarette world, right? With not making it attractive to kids. So I think those would be some of the same public health and safety concerns we would have.
And on those edibles, the potency is about 98%. So that's why I asked specifically about capping the potency. Thank you.
Anyone else?
No, we have no one else, Senator.
Right. I just have to say that Assemblymember Lawler and I have to sit down separately and discuss my marijuana bill because I think he's getting a bunch of the issues slightly off, but we're not going to do that in tonight's panel. But let's make a date to talk about this. Thank you.
Happily, Liz. Happily.
Thank you. All right. The next panel, the Osborne Association, Elizabeth Gaines, the Vera Institute for Justice, Shayna Kessler. Sorry. The Cattell Center for Equity, Health and Justice, Yona Zeitz, and Moms Demand Action for Gun Sense in America, Barry Graubart. And everybody here, let's start with the Osborne Association.
Hi, thanks for having me. I'm Liz Gaines from Osborne. We are a 90-year-old nonprofit that works in 30 prisons, Rikers Island jails, New York City, Newburgh, and Buffalo. And I want to be in that conversation about cannabis that you guys are going to have. And hold on to your idea and don't compromise. It's not just about where the money goes. It's also making sure that it's not big pharma and big cannabis that takes over, but that our communities get the licenses to produce, process, and sell. But that's really not why I came. It's been a brutal year. The nonprofit sector has really stepped up. And I know that it's easy to thank police for their service and sacrifice, but I'd like to also thank the frontline people in public safety who've been doing this work. It's not been done with state money. The CEO raised money for a private stimulus package for people coming home. We raised thousands of dollars from private donations to give people coming home smartphones and reentry kits so that they could come home in this time of COVID. We've even had to raise private money to do our work with policing. We're working with the Buffalo Police Department and NYPD on training specifically around policies and protocols of what happens when you arrest a parent in front of a child. With all the talk about police training, it's a great idea, but the issue is police community relations, and the training needs to include, as Buffalo and NYPD have included us, members of the community to be part of that training. Obviously, the Rochester Police needs some work responding to children and people with mental illness, but it's broader than that. And so your investment in police training, including the community, will contribute to race equity as well. Look, the docs population has gone down dramatically, but one group that's persistently and sadly stuck because of the persistent and perpetual punishment of people sentenced as violent offenses decades ago. Parole reforms are on your agenda, and I hope we get them this year. Elder parole, fair and timely parole bills are critical to offer an opportunity for long-term incarcerated individuals. They have a recidivism rate that's about 0. They often committed their crimes as adolescents, yet they're excluded from the early release docs executive order. They're excluded from work release. They're excluded from educational release, although they are highly represented in the prison college group. And the community would benefit from them. I hire as many as I can. I hope you'll pass legislation for parole reforms, prison reforms, sentencing reforms, and the other campaigns we're part of: Parole Justice, Justice Roadmap, and HALT. We also have some budget requests we don't have time for. Senator Kennedy's funded us our work in Buffalo and our elder parole reentry program for Adirondack and the 8,000 older adults who are incarcerated. I'm out of time, but not out of energy.
All right, thank you. Our next testifier is Vera Institute of Justice.
Thank you very much. Good evening. Thank you so much for your time. My name is Shayna Kessler. I'm a senior planner with the Vera Institute of Justice. I'm pleased to testify today in support of an increased commitment to the Liberty Defense Project, or LDP, which funds the New York Immigrant Family Unity Project, or NYFUP. Governor Cuomo included $10 million in his fiscal year 22 executive budget for LDP. And today I'm asking you to support this critically important work with an additional $5.3 million investment for a total of $15.3 million in FY22. This would support a $6.5 million allocation to NYFUP. The Vera Institute leads national efforts to advance universal representation so that everyone at risk of deportation can have access to a lawyer. In spite of extremely high stakes, immigrants are not guaranteed a lawyer if they can't afford to hire one. With New York's investment, though, NYFUP became the country's first and only statewide universal representation system for detained immigrants, providing a beacon of hope for those torn from their homes by immigration enforcement. This investment in NYFUP brings critical benefits to our state, especially during the pandemic. 1 in 3 New York children has an immigrant parent, and more than 1/4 of the state's workforce is foreign born. During the pandemic, immigrants are responsible for work that sustains our economy and safeguards public health. With immigrants 3.5 times more likely to obtain release from detention with a lawyer and 10 times more likely to prove their right to remain in the United States, NYFUP has reunited families, promoted economic stability, and maintained confidence that New York stands with immigrants in this difficult time. While the Biden administration is making promising changes, reversing the brutal anti-immigrant harm of the past 4 years and paving the way forward will only be possible with legal advocacy. NYFUP presents a powerful example to Washington of an immigration policy that centers human dignity. It is also critical to addressing systemic racial injustice by interrupting the arrest to deportation pipeline that leads to racial profiling and the criminalization of communities of color. More than 40 jurisdictions have followed New York's lead by funding deportation defense. They recognize that investing in representation for immigrants safeguards health and stability during this challenging time. There's also overwhelming public support for the work. A poll found that 93% of New Yorkers support government-funded lawyers for people in immigration court. The $10 million for LDP in the governor's budget is a welcome start, but to keep the program strong, we urge the Senate and Assembly to fund LDP at $15.3 million, which would enable a $6.5 million allocation to NYFUP. Thank you very much for your time.
Thank you very much. Cattell Center for Equity, Health, and Justice.
Yes, good evening, and thank you, Senator Krueger and Assemblymember Weinstein, for inviting our testimony this evening. My name is Yona Zeitz, and I'm the policy coordinator at the Cattell Center for Equity, Health, and Justice. And we're a community-based organization that focuses on ending mass incarceration and building community power. And for tonight's testimony, I will be talking about the parole system, and in particular, the problem of reincarcerating people for technical violations of parole. And this issue is unjust, and it exacerbates racial inequity within our justice system, and it provides no commensurate gains to public safety. And in particular for this hearing, it comes at an immense fiscal cost. And so the Cattell Center, along with the Less is More campaign, has been working to pass the Less is More Act, which would address this issue and should be included in this year's budget. And so what exactly is a technical parole violation? It's anything from missing an appointment with a parole officer to failing an alcohol or drug test. And so these are not new criminal offenses, but yet New York reincarcerates more people for these type of non-criminal technical violations of parole than any other state in the nation. And so this is a failure in terms of our public policy. And so right now, there are currently 5,000 New Yorkers that are incarcerated in jails and prisons for these type of non-criminal technical parole violations. And so that means about 4,000 people in state prisons are incarcerated for these violations. And that makes up about 12% of the entire prison population and about 1/3 of all new admissions to state prisons. And so this is one of the main driving forces of mass incarceration in the state. And the racial disparities are quite stark. Black and Latino people are incarcerated at much higher rates for these technical violations than white people. And along with the human and racial aspect of this bill, it also comes at an immense fiscal cost. New Yorkers, we spend over $600 million annually at the jail and prison level, incarcerating people for non-criminal technical violations of parole. And so at the state level, the Nonpartisan Council on State Governments issued a report stating that New York State spends about $369 million annually incarcerating people at the state prison level for technical violations of parole. And then at the county level, the counties are responsible for the full cost of incarcerating people in the jails as they're awaiting alleged violations. And so in New York City alone, that was about $300 million a year. And so the Less is More Act would fix this issue. And so the bill is currently in the New York legislature, and it's being sponsored by Senator Brian Benjamin. And it actually just moved out of the Senate Crime Victims and Corrections Committee. So thank you, Senator Salazar, for helping make that happen. And so we're hoping that this bill can be included in the budget. And also, it's worth noting that we have broad support for this bill. So there are over 230 groups, faith leaders, and other organizations that support this bill, along with some broad support from public safety officials. So we have over 7 DAs signed on in support of this bill. We have county sheriffs. We also have some former probation and parole officers that support this bill. And so we want to get this done in this budget year. And so thank you for the time, and I'd be happy to answer any questions.
Thank you. And our last speaker for this panel, Barry Graybart from Moms Demand Action for Gun Sense in America.
Hi, my name is Barry Graubart, and I'm the Deputy Chapter Leader for the New York chapter of Moms Demand Action for Gun Sense in America. In that role, I work with numerous survivors of gun violence from across the state on a daily basis. So thank you, Chairman Krueger and Weinstein, for inviting us to testify on this critical issue. And I'm urging you today to include Bill S-1049, Senator Myrie's Community Violence Intervention Program Act, in the budget. We know that in New York, gun homicides disproportionately impact Black and brown families living in neighborhoods shaped by long-term underinvestment. Adequate funding is critical to providing these key services to victims of gun violence. A few things that we do know about access to these victim services. So on average, fewer than 1 in 10 victims of serious violent crimes receive assistance from a victim services agency. Victims of serious intimate partner violence are 3 times more likely than other victims of serious crimes to receive those services. And in our Black and brown communities, we know that crime victims are less likely to report their crimes to the police. And as a result, we know that a large percentage of victims of serious crimes in these neighborhoods are just not receiving the services they require. Instead, a patchwork of small community-based organizations try to fill the gaps where they can, but it's not enough. What's the cost to this failure? Well, the data shows us that Using VOCA funds to resource community-based services to gun violence victims allows us to interrupt these cycles of violence. And funding community-based organizations is the best way to increase access to these services. Community-based organizations are small. They're often founded by a gun violence survivor, and they're staffed by volunteers. These organizations are amazing, but they operate on shoestring budgets, and they really could increase their service provision and their impact through increased funding. So in conclusion, I just want to say VOCA victim assistance grants, they're plentiful, and they're a largely untapped funding source for gun violence victim services like hospital-based violence intervention, street outreach programs, trauma recovery centers, and more. States, cities, and community-based organizations have a unique opportunity to drive VOCA victim assistance funding to these and other gun violence victim services. New York has struggled to utilize these funds due to unnecessary constraints, which make it harder for these small organizations to participate. The CVIP bill S1049 is really an important step toward removing those constraints and delivering on the vision for gun violence prevention that I think we all strive for. In my last 20 seconds, I want to just thank, I know Senator Hoylman is in the room. I want to thank Senator Hoylman and all of the Senate for passing two critical bills today on banning ghost guns, S13 and S14. Chuck Levine is also, we will get to the assembly and has been a big, both of those bills are named for gun violence survivors to honor them, who I know very well. So thank you all.
Thank you very much. Any hands up? Well, then we're going to thank you all. Oh, sorry, Helene.
No, just, we don't have anyone.
Oh, okay. I didn't want to cut you off. And really it's just the hour that is keeping us all from, following through with you tonight. But thank you very much for your testimony and for being with us here tonight. All right, our next panel, which is actually our last panel for this evening, Journeys and Refugee Services, Sarah Bertozzi, Unlocal, Terry Lawson, and Center for Judicial Accountability, Elena Sassower. Starting with Sarah. Are you here, Sarah? Does anyone, any staff see whether she checked in?
Nope, she's here. Hey, can you hear me?
Here. Oh, there you are. Now we can hear you. Hi there.
Sorry about that. Hi, thank you. Good evening. My name is Sarah Bertozzi, and I'm the managing attorney of the Immigration Legal Services Program at Journeys and Refugee Services. And my testimony also supports funding for immigration legal services in the New York State budget.
Thank you. Please.
Thank you. Our legal department maintains offices in Buffalo, Rochester, and Binghamton, where we provide immigration legal services, access to which is one of the most critical needs of immigrants in New York State. Immigrants of all statuses require legal assistance on their immigration matters, including refugees, asylees, asylum seekers, DACA recipients, green card holders, and even naturalized US citizens. And their ability to access and navigate our federal immigration system is also dependent on immigration attorneys that represent them before US citizenship, USCIS, which is US Citizenship and Immigration Services, and Immigration Court. Specifically, immigration attorneys fight civil detention and deportation for asylum seekers seeking safety in the US. They apply for green cards and naturalization to secure and advance immigration status. They obtain work authorization to seek lawful and meaningful employment. And they petition to reunite families that have been separated by violence, conflict, and war. These needs are great and are critical to safe, healthy, productive, and meaningful adjustment to life in the US. However, due to a lack of resources, particularly in underserved areas like upstate New York, there are not enough immigration legal service providers to adequately meet these needs. And immigration cases are primarily successful with the representation of an attorney who can assist in the navigation of this turbulent field of law. 78% of immigrants with lawyers win their cases versus 15% who do not have legal help. And consequences of denied cases are severe. They can include prolonged family separation, even deportation to dangerous countries. In response to these significant challenges, New York State has made a substantial investment in immigration legal services in 2012 with the creation of the Office for New Americans, or ONA, and in 2018 with the launch of the Liberty Defense Project, or LDP. ONA and LDP provide funding for nonprofit immigration legal service providers to meet these needs, and our legal department could not operate without this funding. However, each of our offices maintains a wait list. In Western New York, we're the only refugee resettlement agency to access that has attorneys working on these cases, and in the Southern Tier and Finger Lakes regions, access to representation on your legal case is a rare opportunity. So consequently, we are advocating for the maintenance and expansion of ONA and LDP funding in the New York State budget, specifically asking for increased funding for LDP to $15.3 million from its current $10 million, and an increased budget for ONA to $9.1 million from its current $6.4 million, maintenance of which will allow us to keep our commitment to clients with open cases, and expanded funding will allow us to help even more immigrant New Yorkers. Thank you for your time.
Thank you. Our next testifier, Terry Lawson from Unlocal.
Thank you for this opportunity to testify at today's hearing. My name is Terry Lawson, and I'm the new Executive Director of Unlocal, a community-centered nonprofit that provides direct community education, outreach, and legal representation to New York City's undocumented immigrant communities. I would like to begin by discussing the work of Unlocal in the context of a recent case of ours that has been in the news. Javier Castillo Maradiaga is a 27-year-old Bronx resident who came here with his family when he was 7 years old. He was referred to Unlocal because we are one of the founding partners of the Rapid Response Legal Collaborative, which is funded in part by ONA. In December 2019, Javier was unlawfully transferred from NYC Department of Corrections custody to ICE in violation of New York City's detainers laws. Though Javier's criminal charges were subsequently dismissed and sealed, he remains to this day in ICE detention and has been nearly deported 3 times since President Biden's inauguration. To stop Javier's deportation in the span of just 2 weeks, Unlocal has filed 2 stays of request for a removal, 2 requests for a stay of removal, one with ICE and one with the Board of Immigration Appeals, a motion to reopen his removal proceedings, a habeas petition, a motion for a preliminary injunction, and a memorandum of law with the Southern District of New York. We have held 4 press conferences, an online community gathering, and have gathered over 6,000 signatures in a public petition. We have also engaged with legislators and elected officials at every level. Before coming to Unlocal, Javier's family spent over $20,000 in private legal fees to fight their immigration cases. Javier's mother has told me about how her family was taken advantage of by unscrupulous providers and how hard it was for them to find free, high-quality legal representation. Their case came to our attention via the Rapid Response Legal Collaborative just days before Javier was transferred to Louisiana. If the events of the past 2 weeks have taught us anything, they have taught us that while the Trump administration is no longer in power, this work is far from over. Deportation flights are still taking off, and Unlocal and immigration advocates across the state are working tirelessly alongside immigrant New Yorkers to ensure they can remain here with their families. Javier is DACA eligible, his siblings have DACA, his parents have TPS, and we continue to work harder than we have before to provide immigrant New Yorkers like Javier and his family with free, high-quality legal services. We appreciate the legislature and OCA's support of civil legal services, and as Javier's case demonstrates, the need for this funding continues, particularly as immigrant communities battle the effects of COVID. Thank you so much for this hearing and for outlasting your federal counterparts by several hours today. So thank you so much.
Thank you very much. And our last testifier for this evening, Elena Sassower, excuse me. Sassower, I know how to say it. I'm just a little tired, excuse me. Okay, unmute yourself, we can't hear you. There we go.
My name is Elena Sassower, and I am director and co-founder of the nonpartisan nonprofit citizens organization, Center for Judicial Accountability. Our website is www.judgewatch.org, and from its prominent center panel entitled Comparing New York's Legislature Before and After its Fraudulent Pay Raise, you can find the evidentiary substantiation of this testimony. As you know, because I've stated it repeatedly, our foremost public protection is the New York State Constitution, which by Article 7 lays out the manner in which the state budget is to be fashioned and enacted. This year, as in past years, the budget is off the constitutional rails, and I long ago and repeatedly furnished you with proof, and in the absence of your response, sued you in 2 citizen taxpayer actions, the second encompassing the first, laying out the unconstitutionality of the judiciary budget, the legislative budget, and the whole of the executive budget, and of the force of law commission scheme by which you gave pay raises to judges and as a consequence to district attorneys via commission reports that are false instruments. You had no legitimate defense to either lawsuit, and so your attorney, the New York State Attorney General, himself a defendant, corrupted the judicial process with litigation fraud and was rewarded with fraudulent decisions. This also enabled you to utilize the same force of law scheme to procure committee-based pay raises for yourselves and for the Attorney General, the Controller, the Governor, and the Lieutenant Governor, also by a report that is a false instrument. The foregoing is the subject of 62 fully documented grand jury public corruption complaints against you that I filed with New York's 62 district attorneys, including Washington County DA Jordan, who has just testified at this hearing. In the event you are not knowledgeable of those 62 complaints, and the most important being the complaint filed with Albany County DA Soares, all 62 are accessible from CJA's webpage for my testimony and this public protection budget hearing. That is where you will also find other relevant complaints, such as against the first witness at this hearing, Chief Administrative Judge Marks, and New York's Court of Appeals judges who certified and approved the judiciary's slush fund budget filed with the Commission on Judicial Conduct, whose administrator, Robert Tembekian, was your second witness. I am available to meet with the legislatures to discuss the foregoing, including the specifics relating to the fiscal year 2022 budget, and to testify under oath. Thank you.
Thank you. Any questions? I don't see hands raised.
No questions from the Assembly.
Okay, and no questions from the Senate. So I want to officially call this hearing over. I want to thank you all for participating throughout the day and evening. We learned a lot and we absorbed a lot. And again, anyone who's still listening and who thought, why am I not there testifying? The answer is you can still submit your testimony and it will go up online and we can review it in the context of all of our work on the budget. So I want to thank my colleague, Helene Weinstein, and all my colleagues for making it through with us today. And tomorrow morning at 9:30, we start the local government's budget hearing. Am I right, Helene?
Yes, correct. 9:30 we start.
There you go. So tune in tomorrow, same people, different topics. Thank you so much. Get home safe.